I thought I would just talk about the act, but then when the schedule came out and I saw that this is a keynote, so I thought I would generally expand the scope of my address to beyond the act. And though I would mostly focus on the act. So with that introduction, I mean, I just wanted to, as the coordinator mentioned, it's about one needs to locate it in the larger framework of federal water governance, whether it is disputes resolution or enabling cooperation between states over water resources. It is necessary, the work that we have been doing shows that it is necessary that we should locate it in the larger framework of federal water governance and build on it to achieve the outcomes that we are looking for in interstate river water disputes resolution. So with that initial remarks, let me just start off my presentation quickly. I hope that can you see my screen?
Yes, sir, we can see.
Okay. So as I did say, initially I thought I would share my views about the bill. And I don't know how many of you can recall that the good, the bad, and the ugly. I deliberately picked it up from the internet and then put it as, that's one of those movies that I enjoyed for a long time. I just thought that there would be plenty of student community and they would be able to relate to it. So that's how I had put it there. But if this has been a personal, interactive session, that would have been different in terms of, I could have, I would have liked some responses from the students about it. But let's move on now that it is a virtual engagement. So if you look at the broader picture, that's what it's an overlay of Indian states with the river basins that the Central Water Commission has delineated. And you can also see some rivers. That's not the best representation, but I hope that it gives you a sense of the overlapping of the geographies between state territorial boundaries and the river basin boundaries. So one of the things that I wanted to communicate through this slide is that you must recognize that India's long-term water development and security goals, including, if you want to call it, sustainable developmental goals, they are located in the realm of interstate river water governance. It is because you've got now, I think as the count goes, 29 states, and then it is not necessarily that it would remain the 29 states, and they share, in fact, technically they share 25 river basins because that is the number of basins that Central Water Commission has delineated in its 2012 publication of River Basin Atlas. But effectively, there are 20 river basins because all of those river basins don't necessarily lie within India's territory. So what we are talking about is increasingly interdependent hydrogeographies. So the rivers, interstate rivers, represent indispensable interdependencies between states. So if you look at the kind of India's flagship programs that are pursuing water resources developmental goals, you would see that the river rejuvenation has received a lot of attention. And as you might be knowing, River Ganges, which is now a flagship program of this government, is shared by something like 11 states. And there are other programs like inland navigation and interbasin transfer, which are also important developmental programs. And the recent one, Jal Jeevan Mission, if you look at them, they're all connected to interstate river water geographies. So, and not just about developmental goals, but also if you look at the emerging risks within the realm of hydrogeographies. It is we've been having, as you know, if you want to relate it to climate change, but we've been having floods quite frequently, and also the climate change itself, as you know, the impacts are not clearly known when it comes to local and regional scales, but we know that there will be extreme events, and they are uncertain both spatially as well as temporally. So in order to respond to these risks, the emerging risks and water governance challenges, you need coherent interstate action and concerted interstate action and a federal response. So it's very important when you come to look at the longer term national water resources goals, water resources development and security goals. If you look at it, it's very important that we recognize that our goals, significantly lie within the realm of interstate river water governance. So with that in mind, how are we doing with response to our own federal governance and interstate water governance instruments? So if you look at it, this is what pretty much represents that space, federal water governance. One, it is for the disputes resolution between states, that is drawing on Article 262, the Interstate River Water Governance, River Water Disputes Act 1956, basically provides the framework for river water disputes resolution. Essentially, if you look at the role of the center, which is center-state relations, if you look at it when it comes to water governance, within that particular act, the center's role is primarily limited to some level of efforts to mediate between the states and try resolving it, which we have a very poor track record. At least if you take the 9 disputes that have escalated for legal adjudication. And then after that, they just simply constitute tribunals and then leave it there. So it is also, should be recognized that it is meant that the states would give effect to the decisions of the tribunals. So the center's role is pretty much limited. And as you know, under the constitutional scheme, Entry 56 also defines the role of the center, which is essentially, it has powers within interstate river water regulation and development. Now, if you look at it, Entry 56 has been used to enact a legislation called River Boards Act 1956. It has been there since 1956, and the track record is that not a single river board that you see are constituted using the force of this law. So in the sense, like and this law has been called repeatedly as a dead letter, and it has been in disuse for a long time. You're talking about pretty much since 1956, we haven't even amended it, nor we used it. So that space where the center is given responsibility to play its role as in interstate river water regulatory and developmental responsibilities, you see that pretty much there is an inaction, at least using the instruments that are there. Now, there is a very totally inexplicable reason why the center always chooses to create those river boards that we see, which are about, if you count me, they're not entirely called river boards, but there are 11 interstate river water institutions, coordination institutions that have been created, and they have been functioning for a long time. None of them use the force of this law. So that's the kind of role that the center is located with over the, since the inception of this act. So this has been recognized by the scholarship, which is also very limited. It's been called that Professor Ramaswamy called it as the center has abdicated its role in this particular space. And then I've been arguing that it is not just abdication, but it just lost its ground because of certain political dynamics associated with Indian states' transformation over time, historical transformation. And then we have had enough evidence to call it that there's a federal anarchy there when it comes to river water governance in the federal frame. So if this is the situation, one has to recognize these the state of affairs, and then look at the river water disputes resolution and the way the bill is proposed. So we will just move to the particular bill that I want to talk about. So, I mean, if you look at the mechanisms, I mean, this is a forum that is hosted by the law, by a law university, and you know that the river boats, the Interstate River Water Disputes Act 1956, the mechanism essentially consists of one, which is a very peculiar, I would say, provision provided by the Constitution, and the interstate river water disputes, as opposed to interstate disputes, have a special status in the Constitution. See, the Constitution empowers the Parliament to enact a legislation, appropriate legislation, and also provides for the bar of all courts, I mean, including the Supreme Court. So there is a particular history to it, and we can come to it if you want to, but this is a very peculiar provision that is there in the Constitution. And that has been used by the Act, and the Section 11 bars the jurisdiction of all courts, including the Supreme Court. Now, the mechanism is that when states come with a complaint about a possible dispute or likely dispute, the center tries to mediate, and then after that they constitute, if they see that it can't be resolved through mediation by the center, they constitute ad hoc tribunals to adjudicate this dispute. And the other provision, which pretty much fortifies the earlier bar, is that the tribunal awards carry the force of a Supreme Court decree. So, I mean, it doesn't say, but I think it's under Section 6. But it is pretty much that it is meant to not to have an appeal, though the recent instances are different. We can talk about it in due course. What are the problems with this, and that push for amendments on a pretty much frequent basis? I mean, if you look at the track record of how we have dealt with, I think it has gone through more than half a dozen of amendments since its inception, 1956. So what are those problems that are recognized and generally accepted? You know that they take long time, prolonged adjudication, and they take several years for the decision to come out of the tribunal adjudication. Just as instance, Ravibias, it's been 30 years and there hasn't been a closure for it. And Kaveri took 17 years. And the second tribunal of Krishna is taking more than 10 years. And then after the decision is given, the problem has always been with the complaints of the states. I mean, there is very often these disputes recur and emerges entirely different disputes because states refuse to comply with the decisions that are given by the tribunals. And the problem is that, which has been identified extensively by several scholars, is that there are no reliable implementation mechanisms. And then the fourth, and that is not adequately recognized, and we try to sort of show it as an important factor that needs to be considered, in spite of the fact that the scholars have this visceral reluctance to deal with this element of interstate river water disputes, is politicization. I mean, for your general sense of what it means, I mean, if you can look at the cartoon that I have shared, which is my favorite one, which reflects the nature of emergence and recurrence of the disputes. So the very nature of the federal democracy is that the federal entities tend to territorialize these disputes, in the sense like they claim certain rights which often conflict with the core riparian states. So these are often not just used as those substantive disputes with the difference over allocations or coordination, but they also tend to become sites of political mobilization towards the greater political objectives and the broader political objectives, essentially in terms of electoral rewards. And this is not often recognized. Very often the tendency is to say that it's plenty of politics, let's not touch it. So some of the argument that we have been trying to forward is that the very politicization itself is a very important factor and one has to take it as an important parameter in our analysis towards design of policies and institutions, and also legal instruments towards a more effective and improved disputes resolution. So if these are the problems, how did the bill try to respond to it? As you know, I have given you the broader frame of how the act itself tried to deal with it. And then these are the problems that we have observed over time in the history of this act's use or deployment to resolve disputes. Now, what are the features? Well, before I move to the specific features of the bill, let me just come back to it. And I have written a piece earlier saying that this is a kind of circuitous way of complying with the Article 262 under the Constitution. But there's a big debate that has been happening for a while, and people of eminence like both practitioners as well as scholars, Ramaswamy Iyer and then Falin Ariman, they have recommended restoring the Supreme Court's jurisdiction over interstate water disputes. That did not mean that it should go for a constitutional amendment, but they suggested that simply repeal the Interstate Water Disputes Act 1956, and that would, by default, would put it under the Article 131 jurisdiction of the Supreme Court. Now, this is primarily the major debate happened when the Punchi Commission has asked for representations from the scholars, and they have certain kind of nuanced differences, but that is not perhaps not important at the moment. But what we have taken up as part of the researchers' effort here is to look at significantly, particularly historically, how the Supreme Court has dealt with this bar that has been provided by the Constitution as well as enacted under the River Water Disputes Act 1956. And we believe, and that's an argument that we have forwarded in the recent report that we have written and which is under review, is that I think it is important, we think it is important to maintain the bar in its absolute sense. And that is what the Supreme Court has done historically till the decision that was written by former Chief Justice Deepak Misra in December 2016. And after that, his bench adjudicated and modified substantially the award that was given by the Kaveri Water Disputes Tribunal. And this was an unprecedented incident where the Supreme Court has dealt with the substantive questions of the dispute and not the questions of law, as it has been doing for the past several years since the inception of 1956. So we tried to build on certain historical archives and look at the origins of the bar, which goes back to the colonial administration. And then we have enough evidence to argue that it is perhaps not such a good idea to restore the jurisdiction of the Supreme Court, but to maintain the bar and let the tribunals adjudicate and have the finality with the tribunal's decision itself. But the more important responses should be more political and institutional towards enabling deliberative resolution and interstate cooperation to give effect to the decisions. But this is the bigger argument, just to sort of share it with you, that this is still an unresolved issue yet. So it's something that will be eventually in the future. It will be open for debate, particularly because this bill that is, you're talking about the Supreme Court saying it in December 2016, and this bill that is put before the Parliament in 2019 still carries that bar. Section 11 bars the jurisdiction of the Supreme Court. Of course, there is a subtle difference in the sense, like the Supreme Court's decision says that it has plenary jurisdiction under Article 136. Anyway, we'll come to that perhaps over discussion after this. But the bill essentially tries to bring in these following changes. Instead of earlier ad hoc tribunals and exclusive tribunals to adjudicate the disputes where they would be dissolved after the decision is given away by the tribunal. Now it proposes a permanent tribunal in the form of Interstate Water Disputes Tribunal. And again, as I said, the bar on court's jurisdiction under Section 11 and the force of equating that decision with the force of a Supreme Court decree under Section 6, they both remain. Instead of, as I did say, under the exclusive tribunals, now there will be exclusive benches, and then all existing tribunals would be subsumed as benches. And there is a very interesting element of what that has been brought in place of earlier ad hoc, unstructured perhaps centers mediation, but this is now more structured in the form of a disputes resolution committee for negotiated settlement. And it is after that process of ex ante process of disputes, attempts to negotiate these differences, the tribunal will adjudicate those remaining unsettled matters. And then there is a technical agency. There is a provision for a technical agency for data bank management, because that is the primary major source of disputation when you look at the tribunal proceedings and the kind of disputes, the points of difference that the states have very often, which prolong the litigations for such a longer periods. Now, as I did say, I just wanted to share my thoughts about under those I think which are very good and improvements, and those not so good, and then those perhaps should be avoidable. So I think one of the things that it addresses is that there is a permanent avenue. One of the reasons very often the disputes, the Supreme Court is forced to engage with the interstate water disputes is that once the ad hoc tribunals give away the decision, now they are dissolved, and there is no avenue for them to approach for further not further clarification, for clarification about any new ways of interpreting this decision, or otherwise due to certain new interventions, if whether it fits within the larger decision of the tribunal, there is no avenue for states. So very often the states end up going to the Supreme Court. That's partly the reason why you have fairly long history of the Supreme Court engaging with interstate water disputes. So there is a permanent avenue right now. So there's a tribunal, and then every time there is a problem with the way the decision or the award of the tribunal is interpreted and implemented, if there are differences over these, then the states can come back to it. And again, it tries to address that long drawn problem about delayed decisions by the tribunal. And even if you allow all the possible extension, as my calculations go, the decision should be coming out within 6.5 years since the formal complaint by the states. Now, that's an improvement. And then I would consider the Disputes Resolution Committee as a major improvement, though the devil would be in the details, so we don't know much about it. But I think there is a reason why I think that it is very important element, and I think it is one of the it can significantly improve, and it can be used for negotiated settlements, and that is what they are meant to be, and that's partly the reason why the court's jurisdiction has been barred under both Article 262 as well as the Water Disputes Act. So it's an ex ante space for negotiated settlement through mediation. And it is, DRC, the Disputes Resolution Committee, with members from such relevant fields, which includes both judicial as well as expert members, adequately provides for space for us to sort of work out necessary details to achieve the objectives of a disputes deliberative mechanism like Disputes Resolution Committee. Now, not so good part about it is that the challenges, what I call is that it sticks to that legalist template, and it doesn't pay adequate attention to this politics and institutional gaps that are necessary to address it effectively. And that's a sort of bigger, broader statement about not so good about, because we have had a fairly rich history of interstate river water disputes. And we could have responded to the changing nature of the disputes themselves because of the changing polity or Indian polity itself. So there is another reason why I think it doesn't respond adequately is that there is a lack of appreciation for the nature of the disputes. Now there is if you look at the work that is being done under transboundary river water conflicts, both at an international scale as well as at interstate level, which is much less, I would say. Unfortunately, very poor body of work that exists right now. From alternative and interdisciplinary views, if you look at it, the very political ecology, I mean, there is a greater recognition now that while the disputes are what you can call as the sources of perennial disputation, but it also recognizes, I mean, there is a greater role for the politics, and because of the politics and other factors, which we can discuss, I mean, that's a different topic altogether to understand the nature of the disputes themselves. But the political ecology also tells that, is that there is a greater, both conflict and cooperation coexist. I mean, yeah, you can't simply put these disputes into one category of a conflict or otherwise you have achieved cooperation. It's not like that. There is a greater chance of recurrence of the disputes, even if you have fairly resolved or otherwise settled, disputes. Now that hasn't been adequately paid attention to. And again, as I said, that the fact that in a federal democracy, the interstate river water disputes, because of the very close connect with the public and the public interests at large, they are very important sites of political mobilization. That needs to be given due recognition while designing these instruments, both legal policy as well as institutional instruments, which I don't think the bill responds to properly. Now, as I did say that, the devil is, in the details. And so it's important that the DRC, in terms of its positioning as well as composition, it's very important. We don't have much information about it at the moment. But, if you look at the very, text of the amendment bill, it pretty much reflects similar to what tribunal had been doing for a long time before it framed the issues of conflict. I mean, it's basically recording data and recording the stands and claims of the states and then reporting facts. It sounds like a very techno-legal approach, practices the tribunals were following it as a kind of pre-adjudication phase. It doesn't think, it doesn't reflect the true deliberative spirit that that it is meant to have. And in my view, it's a very important space where you need to have a greater role for political mediation rather than obviously supported by technical support and technical fact support. And it also needs to be designed, I mean, if you look at it, it is supposed to be headed by an officer of secretary rank or similar kind of stature, but I mean either a serving secretary or otherwise who has been a secretary rank officer. I mean, if you take the record of interstate water disputes resolution, particularly Kaveri kind of disputes, which frequently recurred, I mean, there has been a prime minister, there has been a Kaveri River authority headed by the prime minister himself at some point, and then there was a Kaveri supervisory committee headed by the secretary of the Ministry for Water Resources. They have not been able to deal with this issue. So one needs to think beyond that, I mean, taking the experiences of not so effective framing of similar kind of and those kind of, one needs to ensure that there is this particular avenue has the right kind of credibility and legitimacy to bring states to the table and talk in the spirit of resolving their differences. So that is, I think, one needs to wait for it, but I think as it stands, the way the text is shows it's perhaps not going to achieve the kind of outputs that we are expecting this avenue to do. Now, as I did mention, one of the major differences between states every time is that the data's, the data that is used by the states to support their arguments, they do not often match. And then one level, I feel that there is a kind of ambiguity that is left out, is that why does one needs to even say that there will be, the central government will appoint an agency for data maintenance. I mean, I can't think of many agencies possible beyond the Central Water Commission, which is a federal agency and which has the right kind of, both skill set as well as infrastructure to maintain that kind of data set. So at one level, not even specifying that and making that particular agency responsible itself is an avoidable ambiguity. Now, it's not just about data. So the problem is that one has to recognize and give it adequate attention to it, is that it is not just about data and information. It is about that data and information that is agreeable to the states, which means that one has to standardize data capturing and analyzing it. So there is a certain kind of consensus that is necessary between the states and the center about how the data needs to be captured by this particular agency. So that element is extremely important. So until and unless there is an agreeable knowledge production that could be used for disputes resolution, we can't expect that to be resolved easily, in sense like effectively with not much of litigation around the very data itself. Now, what is I think, in my view, is avoidable, or not avoidable, but there's a major gaps, is that as I did mention, the December 2016 decision of the Supreme Court essentially establishes its plenary jurisdiction under 136. Now, if you take and then eventually after that, in February 2018, in a substantive way, the court has modified and given away decision. Now, the question is about opening up this additional layer of litigation for extended litigation. Now, that is the problem. I mean, one can get into this discussion separately, but the moment you open it up, and say that the tribunal's decision could be challenged before the Supreme Court, given the nature of the territorialized and politicized nature of the disputes, I don't think one can prevent them from going to Supreme Court. So pretty much there are additional layer of disputation before the Supreme Court that is going to eventually invariably happen. So in the process, what happens earlier is that the decision of the tribunal was considered final and binding on the states and would be carrying the force of the Supreme Court. Now it's going to undermine the very power of the tribunal itself. Now, effectively, what it's saying is that even if you read it, the courts are saying on one hand that we have jurisdiction, but the fact that the bill continues with the bar and the equating it with Supreme Court's decree, even though with this nuanced difference that it is about plenary jurisdiction, it's effectively saying that the courts are saying that we have jurisdiction, and the legislature is saying that no, you don't have. Now, this needs to be resolved and needs to be clarified, and in the light of the Supreme Court's decision, so that it wouldn't lead to further extended deliberations on the questions of law themselves, instead of the questions of substantive aspects of the dispute. And besides that, I mean, there is a new element within this bill, which basically has a selection committee to select the tribunal judges. Now, this is dominated by political executives. So there are going to be 4 members of the selection committee, where Chief Justice of India would be there, but then there is Prime Minister of India as the chairman, I think designated as the chairman. And then the Minister for Law and Justice, then the Minister for Jal Shakti, and then the Chief Justice of India. So it's dominated by the political executive. And if you take the decisions of the Supreme Court itself in the recent times, it says that this dominance of political executives role in selection and regulating of tribunals is leading to dilution of judicial processes. That's what Supreme Court itself has said several times. Now it's so once you have this kind of selection committee, now it's first of all it is going to be very unlikely that it will stand the scrutiny of the law eventually. And second thing is that now as someone who looks at politics with a lot more attention, I would argue that first, so far the states have always been politicizing the tribunal decisions, but now they're going to politicize the tribunals themselves. So the institutions themselves could be subject to politicization, and you can think about those kind of repercussions of that kind of changes. So one has to also pay sort of attention to that. And as this has been my major complaint about most of the amendments, is that there is an ex post gap, in the sense like it's all fine to adjudicate and give a decision, but how do you give it effect in the kind of democracy, federal democracy that we have, and fairly federalized democracy, I would say. So we haven't paid, if you look at the history of interstate water governance, we haven't paid adequate attention to creating the right kind of institutional models to give effect to decisions where there is a need for interstate collaboration, coordination, or generally the larger cooperation. So we don't have many institutional models that are framed within the structural design of the federal relations over water governance. Now, if you look at the way the tribunals have dealt it, and if you look at the history, there has always been an argument that the premise is that unless and until you achieve consensus of the states over the implementation mechanisms, you should not recommend. That is partly the reason why you don't have a Krishna Valley authority that was recommended by Justice Bachawat, but not as part of the decision. It is just a recommendation. But whereas the Narmada Control Authority was something that was achieved through consensus of the states. Now, if this has been recognized that there is a necessity for consensus of the states, what are we doing about building consensus between states, about implementation mechanisms, or otherwise about generally the larger roles of the center and states? Now, if you don't supplement the legal instruments like this with the necessary political and institutional responses, you will end up having extended litigation the way it has been happening with the disputes, and prolonged continuance of these disputes. So with these, I think I just wanted to share with you various kinds of in my own views about what is so good about this bill and what is not so good about the bill, and I would welcome your own thoughts on it post conversation. But one I just wanted to emphasize towards closing is that, you see, this is something that very often we work on a regular basis these days. And one of the mandate for us is to look at that aspect that I mentioned about, is that we don't have the institutional models or the politics that are necessary for enabling interstate cooperation. And you would be surprised to know that the track record of India in terms of interstate cooperation, though not necessarily mediated by the center, not always, you're talking about 9 interstate disputes in contrast to 160 agreements between states over river waters. So there are, you are talking about a remarkable track record of 160 interstate river water agreements, and not a single publication, respectable publication, exists on that track record over the past 70 years of the scholarship over interstate water disputes. So until and unless we learn from the experiences of what makes states to cooperate over interstate river waters, we will not be able to design the right kind of institutions or the political practices to ensure that the interstate river water disputes resolution is effective and improved. So with that, I'll close and invite any thoughts, comments, questions. Thank you.
Thank you, sir. Anybody want to ask any questions to sir?
Can you use the chat box to drop your questions?
Yes. Meanwhile, sir, like since you are asking your take on this aspect, I just want to highlight one issue. If we see this Krishna river water dispute and the states understanding of like states basically, if we see Andhra Pradesh, they went directly to Supreme Court from tribunal. That means that states are basically relying on litigation more than mediation. When CJ and Justice Ramana were asking that, will you go for mediation or let us continue with this case, and I'll be restraining from this case because he's personally involved with both the states. Andhra Pradesh government both they opted for going for litigation more than consensus between them. And after that, when river water disputes are proposing some kind of distribution is also Telangana walked out of that particular consensus that we have. So that means states are themselves are not ready for consensus building based on tribunals. They're ready for only litigation. So in that scenario, maybe we should give courts only that kind of mandatory jurisdiction or what, something like that, right? Because states themselves want that, according to this issue.
Well, states, I mean, I mean, states that are, you can call them as political actors and states as representative of the society. Now, one has to understand states, when you say states preference and what are the, eventually to what end this is leading to. And if states, at least outward, response is to choose for extended litigation, and if you want to provide for it, you know the answer for it. I mean, you will end up in litigations, and then states would suffer the consequences. Partly because eventually, if you don't have a solution, and then if you continue to fight. But there is also, it's not that states always choose litigation. States are actually very accountable, and they keep looking for solutions there for the problems. It's only when they have an opportunity to politicize, they use that. So if you look at the track record of 160 agreements, why did that, if there is greater incentive to litigate, why did they get into agreements in the first place? So, I mean, I can tell you about incidences, for example, at the height of the Mullaperiyar dispute between Kerala and Tamil Nadu. And I remember there is an incident where the then Chief Minister Jayalalitha sent her Minister for Water Resources to negotiate a deal to get water from an irrigation scheme to address the drought conditions in Coimbatore district. So there are these opportunities. So basically, by allowing litigation, you are giving them opportunity to continue to politicize, right? So if you are responding to the choice of the states, that means basically you are allowing them to continue to politicize. I would leave it at that.
Yes, sir. Some of our participants asked one question. So what is your opinion about interlinking of rivers?
Well, in fact, part of the reason why I started working on interstate river water disputes resolution is attention that it received under the first NDA government about interlinking of rivers. That was the time it was at its height. So when I looked at interlinking of rivers, and when I saw that interlinking of rivers would significantly affect the hydrological regimes and hydrogeographies of the country. Unless and until you have a very effective mechanism for disputes resolution, you can't go for that kind of project. So from the perspective of disputes resolution, I would say that unless and until you have robust and resilient mechanisms for resolution of disputes and differences between states, you can't really think about interlinking of rivers. Let me just put it this way. I think, one interlinking of rivers, unfortunately, carried that baggage of I would say, as that mega project, that is going to transform and have this major environmental consequences. But the very fundamental principle of interbasin transfer to deal with, what might very popularly said as the deficit and surplus, but that is, I think, very inappropriate way. But I think the fact that, the paradigm of interbasin transfer is not something that is new. I mean, that has been in practice for a long time. I mean, Chennai wouldn't be there if there was no Telugu Ganga at that time. I mean, if you look at the history. So interbasin interlinking in its fundamental form has been practiced for a long time. So one can't reject the paradigm. One has to look at critically the politics of projects that are being proposed. But the paradigm of transferring waters, I don't think we can actually entirely reject it. But I would go back to my own argument about saying that unless and until you have robust and resilient mechanisms under dispute resolution, you can't actually go for that kind of process. You would end up recurring disputes and extended litigations.
Yes, sir. Somebody put in chat, P. Srinivas, he asked that, can't representation of member in parliament on water resources be nominated and chair committee in case of dispute?
Oh, that's an excellent idea. In fact, I keep wondering about myself, and I would like to look into it, that possibility is that why can't the members of parliament from the states play a more proactive role in resolving these disputes? I think it's a very important idea one can explore. So very often I look at our own members of parliament and the kind of role that they play in the parliament and when it comes to issues. And while it is good, but I think there is definitely a possibility of expanding that scope of their role to playing a proactive and positive role in disputes resolution. I agree.
Thank you, sir. Thank you for such a wonderful session. It was really inciting. So we'll start with presentations now. We have our co-chair and moderator here for today's session. L. Ashish Kumar, he's an assistant professor from VIT School, AP School of Law. He's our moderator for the session, and Dr. K. Pallavi from Andhra University, B.R. Ambedkar Andhra University, assistant professor. He's our co-chair for the present session. So can we start with our presentations now? Sir, you can take your Ashish Kumar.
Thank you, Priyanka. Firstly, I would like to acknowledge Professor Srinivas Chokkakula sir for his enlightening session. Just not a question, but just adding on to what is my opinion. Rather than most of the legalization of the dispute, it is politicization of disputes, as you rightly pointed when we talk about river disputes. And in future, the adverse impacts of climate change are going to add fuel to this particular dispute, because that is the end result. And how we are going to manage is again an unanswered question that needs to be addressed.
If I may, I mean, I know that you didn't, I don't know whether you wanted me to respond or not, but I think it is the broader frame. Is that okay? Can I respond?
Yes, sir. Yes, sir.
Yeah, I did flag that climate change risks as the future and emerging challenge of water governance that requires, coherent and concerted action between center and states. And unfortunately, see, I think the very entry 56 or otherwise, if you look at the constitutional scheme, the entry 56 vis-a-vis the entry 17 of the states list, which basically gives states the dominant and presumed exclusive powers over water governance. Now, the question is that, yes, it did work at a certain point of time, at the time of the 7th schedule, conception, organization of powers, but that organization of powers and their own, the ways we have given effect to those powers under the 7th schedule, I think it is slightly outdated in comparison to the kind of new sensibilities and new challenges and new risks that we are facing. and climate change is one of them. So if you look at the recent UN, and particularly, and this is yesterday, Philip was mentioning, my colleague, and others also acknowledged it. I think the least understood link is when it comes to climate, the big bogey, climate change is the link between climate change and water. I mean, you don't find a definitive line of thinking that is happening when it comes to climate change and water, unfortunately. And that is a big gap. I mean, very often people don't acknowledge it, who talk about all the time IPCC reports. Very poor debate or dialogue, I would say, and I'm very disappointed about it, is that that link has not been adequately explored, and it is not even acknowledged, the gap of that link, the understanding that link. So if you take the recent most publication of an agency like UN Water in 2020, and I keep citing it these days in our conversations as well, is that there is an overwhelming evidence to show that the climate change impacts hydrological regimes, global impacts of hydrological regimes, but there is a significant, not significant, there is an absolute no understanding about what are that impact when it comes to local and regional scales. So we don't know how to deal with the climate change impacts of the water, the impacts on water. So the only thing that we know at the moment is that there will be extreme events. So there will be floods, there will be droughts. Where, when, no idea. And particularly with the kind of data sets that we have in India, and with the kind of climate variations that we have in India, I think that is the bigger gap that we have. And we can't, first of all, talk about them without knowing what are the impacts. And we can keep explaining it. For example, take the Kerala floods that happened 2018. Everybody said, this is climate change impact. There are plenty of people who said that, but there is no definitive explanation that we have got so far. So, and one has to, and given that that kind of uncertainty exists about climate change and water, and given that we live in this realm of interstate river water governance, you know how important this is, both interstate coordination as well as federal water governance. And as I did remark initially, saying that we have this, gap, huge gap, whether you want to call it vacuum, lost ground, or anarchy, or application of role by the center, the fact remains that we don't have an effective federal governance to think about climate change impact and how we deal with them between center and states or between states. So we have this major policy and institutional, in fact, even legal for that matter, gap to address this problem. So we have, if you start looking a little deeply, and you have a range of set of gaps to talk about it, but you hardly, if you know, I to my knowledge, I don't know, but is there a single institution that we can think about as someone that can produce, impacts on hydrological regimes in over water, because of possible climate change? We don't have a single institution with that agenda at national scale or even at the state level. Sorry, I took a little longer than.
No problem, sir.
It's very disappointing, but this is a very important question, and I appreciate that you have raised it and gave me an opportunity to share my right.
Thank you so much, sir. Thank you. Now we can proceed with the presentations. Before that, I would like to make a small announcement that each presenter will have 8 minutes for their presentation. So I request all the presenters to please confine to the timings. And ma'am, is Dr. Pallavi ma'am available?
Sir, good morning. Sir, namaste, sir. Srinivas, sir. This is Dr. Pallavi.
Namaste.
Andhra University, Dr. B.R. Ambedkar College of Law. Sir, so here just I have one doubt. It's not a question. So here, in the view of 2019 bill, the two-tier system dispute resolution committee, which was introduced through the 2019 bill, which is more, and with we hope it's more effective for resolve the disputes between the states, interstate river disputes. But here, the fear of centralization of power and impartiality in the view of appointment of members in that particular committee, the members are appointed by the central government instead of Chief Justice of India, like that. So here I have some need some clarification, sir, whether it is, I mean, is it a centralization of power or not? How can we justify?
No, I think, you see, the tensions are, I agree with your apprehensions,
Yes,
but
sir.
to put it as centralization of power is, I think, is a very poor representation of those apprehensions. The reason why I say it is, and I see quite a few people commenting on it, and I think with the recent notification of the jurisdiction of KRMB and GRMB, that has sort of reached at its peak, particularly in Andhra and Telangana. But I don't consider as a centralization of power if the states have played their own role. I think it is, states were given I mean, at least in my own conception of what I think I would claim some credit to contributing to these conversations about disputes resolution committee. But our own conception of disputes resolution committee is that there will be, a an opportunity for the states to resolve, and that is why I stressed on those words of credibility and legitimacy of that space. You see, the states need to have have a perception of that space being credible and legitimate as well. Is that it will not be, it will be unbiased, and it will provide space for objective resolution of differences between the states. That was the spirit in which that deliberative mechanism was thought about. Now, appointment of members has little, I mean, selection committee, I think, as I did say that itself, I think you lawyers you yourself will deal with it and you will consider, I mean, I don't think it will stand scrutiny of the law, but the disputes resolution committee, to prove its own effectiveness and to prove its own relevance itself, they need to work out the right kind of mechanisms to assure states about these kind of apprehensions. So that is why I said the devil is going to be in the details. The only thing that I said is that, you see, if a secretary rank officer can bring states together for objective conversations, I mean, that is something that we are gambling on quite a bit. So whether it is going to be possible for the states to trust and then come and sit and talk objectively about it depends on those details of the nuts and bolts of those practices that we would use. And we want to, I mean, we're trying to work a little bit, and we have offered that we would like to work on those kind of practices and processes to ensure that the states feel assured about it. So I totally agree with your apprehensions, but I wouldn't call it centralization of power. I think it is, on one hand, I believe that because states have been a little somewhat intractable and on a common resource, I think there is a need for an anchor, and the center has neglected its role as an anchor. I'm not saying that it has to extend its executive power, but it has to play the role that is necessary to facilitate interstate conversations. I mean, I think that is what I would put my position as. Right. So
Thank you, sir. Thank you so much. Thank you, Ashish.
Sure.
Thank you, ma'am.
Thank you.
One more thing.
Yeah.
After the presentation, should we take questions right after the presentations or at the end of the presentation? All the presentations.
End of the presentations is, I think.
After all the presentations are done, then we can take one.
Yeah, yeah.
Okay, thank you.
Thank you.
So, with your permission, I would like to call upon the first presentation that will be delivered by Dr. P. Balaram Babu and Mr. P. Srinivas on the topic, a new mechanism to resolve the interstate river water disputes.
Thank you, Ashish Kumar. Thank you, Pallavi, and good morning to all. Particularly, I am thankful to Srinivas Chokokala, who has given this such opportunity to say something and accepting my article published also. Okay. Now I am Dr. Balaram, working as a senior faculty in MSS Law College, Hyderabad, and my colleague 3P Srinivas are also with me. We both are presenting the article on a new mechanism to resolve the interstate river water disputes. Okay. The interstate water disputes are today the most vexing problem in India. For example, Kaveri water disputes, Satluj Yamuna link canal disputes, Krishna river water disputes are recent instances. Though various tribunals on inter-water disputes are established, but nothing amicable settlements are through these tribunals. So a new mechanism is required, and we suggested in this paper. At present, to resolve the interstate water dispute, the Act of 1956 is governs to resolve the river water conflicts. Causes for these disputes are mostly due to low rainfall, limited water supplies, and dependency on a single large water source. All are key causes of war, along with a rapid population growth, and urbanization, modernization, and industrialization are also key concepts for these conflicts. Mr. Sino, are you displaying my PPT? Please. Hello. Hello, Ashish.
No, sir. No, sir. We're not able to see your PPT.
Just a moment. Will you please display it?
I think Kiran, Srinivas sent the PPT to
Yes,
the
madam.
water law seminar email ID.
Shall I continue?
Ma'am, Sar is the presenter access me.
Your screen is visible, sir. You can open the PPT now.
Just a moment. A few minutes, madam. Excuse me.
Madam, we are facing some problem here. Can you use the
Just
technical?
Sir, kindly send the PowerPoint
there
via
in the
email.
water law
We'll share it
seminar.
from our side.
No, it's there. He sent it in the morning
Email.
to the
Okay.
water laws.
Okay, ma'am. Okay.
Thank you.
Shall I continue, madam? Without a PPT?
Yes, sir. Yes, sir. You can please continue to that.
Thank you. The water is a state subject as per entry 17 of state list, and the states are empowered to enact legislation on water. Entry 56 of union list gives power to the union government for the regulation and development of interstate rivers and river valleys to the extent declared by parliament to be expedient in the public interest. So the Article 262 of our Constitution states that Parliament may legislate by law for the adjudication of any dispute or complaint relating to the use, distribution, or control of the waters of or in any interstate river or river valley. The National Water Dispute Act also argues that if a committee of jurists is constituted to settle the impasse, no changes to existing laws will be required, and it proposes the creation of a national water policy as well as a river liaison authority. So disputes must be resolved by dialogue and talks, and the political opportunism must be avoided. As per our Honorable Chief Justice, Justice N.V.
Sir,
Ramana.
sorry to disturb. I just started sharing your PowerPoint, sir.
Pardon? Yeah. Okay. And as per our Honorable Chief Justice, Justice N.V. Ramana, the disputes can be resolved through mediation. The Egyptian civilization and Mesopotamian civilization on the Tigris and they are all well formed on the outskirts of rivers. Because approximately 85% of Indian territory is within its large and medium interstate rivers, the element becomes even more essential in the Indian context. There are 14 significant rivers in India, all of which are interstate rivers, and there are 44 medium rivers in India, with 9 of them being interstate rivers. A river classified as medium, where a catchment size of 200 to 20,000 square kilometers. So, water share has been a key concern in India in recent decades. In addition to water scarcity, this for the most part true in the drier parts of western Rajasthan, where in addition to physical water scarcity, the social and economic components of water scarcity have complicated water allocation among various customers. Water benefits people in a variety of ways because including health, that means clean drinking water is most necessary, agriculture for irrigation purpose, and industry, that is hydroelectric power, as rivers cross state borders, and India is a federal democracy, creating efficient and equitable system for sharing river flows has long been a legal and constitutional concern. A recent dispute over the Yamuna rivers used between the states of Delhi, Haryana, and Uttar Pradesh was settled through talks including the 3 state chief ministers as well as the central government. India's previous experience with the declaration of interstate water conflicts has not been particularly positive. It is difficult to say if this is due to the temperament of the conflicts, political reasons, or the constitutional provisions on the matter being insufficient. Interstate disputes in India's federal political structure necessitates the engagement of the central government on 2 levels between the states involved and between the center and the state for a federal solution. The tribunals constituted under the Interstate Water Disputes Act to decide on them have so far yielded no results. Because no results. Union-state relations under the Indian Constitution is not well mannered in regarding to the interwater river disputes. We know from other countries' experience how time-consuming and costly these adjudication can be, and our government cannot afford either the cost or the long delays. Why should not the Union use its legislative powers under entry 56 of List 1, which allows it to legislate for the regulation and development of interstate rivers?
Sir, sorry to interrupt. You have exhausted the time, sir. If you could please conclude.
Sorry, okay, exactly. Okay, thank you.
Thank you.
Thank you, sir. Thank you.
Thank you, sir. Thanks for the presentation. We would like to move to the next presentation from Ms. Radhika Yennu, a socio-legal study of water resource management of the Kaleshwaram lift irrigation project in Telangana state.
Good morning to everyone. I am Ennu Radhika. I am going to give my presentation on a social legal study of water resource management, Kaleshwaram lift irrigation project in Telangana state. As we all know that water it is a combination of minerals like hydrogen, oxygen. It is a natural form to develop as a fundamental resource for the existence of life on the planet Earth. The distribution of its resource and the process of creating, implementing plans, programs, clearance as originally conceived by Dr. B.R. Ambedkar as Pranahita Chevela Sujana Savanti project. This project is re-engineered to provide irrigation facilities with 240 TMC access of water for an estimated 16 lakhs 40,000 irrigated commended area in the 7 districts of Telangana state, namely Adilabad, Nizamabad, Karimnagar, Medak, Warangal, Nalgonda, Rangareddy, besides drinking water and industrial water. The big policy initiative to put available water for conservation in the state, the optimum use through the water management program known as Jalayagnam. Dr. B.R. Ambedkar Pranahita Chevela Sujana Sravanti, an interstate project between Maharashtra and Andhra Pradesh, as a barrage was proposed near Tumati village, conceived in the year 2005 with an estimated cost 17,875 crores. Due to its location is Edward with FRL 152.00 m and capacity with 5.09 TMC. They have agreed with the Godavari Water Dispute Tribunal for 3 projects, namely Lendi Project, Lower Pendugana and Praneta Chevela. Then the Chief Minister of Maharashtra expressed his consent with FRL 152.00 m, that is meters, for constructing the barrage near Tumati due to the submerge of large extent of land in his territory to an extent of 5,247 acres with the insufficient availability of water as a cause, and requested to reduce the FRL to avoid the submerged territory. The administrative approval of the project was sanctioned with 38,500 crores. The government of Telangana have made an effort and they have held 12 meetings with high-level Honorable Chief Minister and honorable meetings with Technical Coordination Committee, and Interstate Water Board was constituted to determine the issues between both the states on 8 March 2016. Finally, the government of Maharashtra has agreed for the construction of barrage at Tumati village, reducing to 48.00 meters FRL. The technical branches assumed location of barrage being unsuitable, calling for the meeting requirement of contemplated work at Tumati village. The relook of Kalavaram project irrigation scheme for construction of 1 barrage across river Godavari at Medigada near Kaleshwaram to lift 3 TMC of water, and 2 more barrages between Medigatta and Sripada Yelampari project at Annavaram to convey water from Sripada Yelampari project to command areas spread over the 7 districts of Telangana through components such as canals, tunnels, lift systems, reservoirs, distribution network for irrigating of 18 lakhs 25,700 acres. The project, after careful planning, the proposed capacity of reservoir was increased from 11.43 TMC to 147.71 TMC by enhancing the capacity of existing reservoirs and proposing new reservoirs to match the demand and supply. Kaleshwaram, being the India's largest multi-state lift irrigation design project, includes 7 links, 1,531 kilometers gravity canal, 203 kilometers tunnel routes, 19 kilometer pressure vanes or delivery vanes, 20 lifters, 19 pump house with 4,992 megawatts of electricity required, which contains 19 reservoirs storing 141 TMC of water. The Kaleshwaram lifting irrigation system is measured to be one of the world's biggest multi-purpose projects. It aimed to provide water for irrigation, industrial and drinking purpose to about 45 lakhs acres in 20 of 31 districts in Telangana state, apart from Hyderabad and Secunderabad. The water pumping up to 680 meters from mean sea level is the highest point being Kondapochamma River in Gajwel. The detailed report estimated at 80,190 crores and new purpose vehicle Telangana Kaleshwaram Irrigation Project Corporation is formed under the Companies Act 2013 with CEO and 1 lakh crore capital to plan and approve release funds, implement and managing, operating, monitoring the project by the time it is completed, constructed by the end of 2020, and it is transferred for the functional purpose. The Telangana Social Economical Outlook Report 2021 increased estimate the total costs of project to be rupees 1 lakh crore rupees. The construction of these 3 barrages, that is Lakshmi, Saraswati, Parvati, with lifting system and the water conveyor were completed in record time. And the environmental impact assessment, the Pranayata Chevela Sujana Savitri applied on 10th November 2014 for the environmental clearance. In fact, as a river valley project falling under entry 1 clause C, according to the notification of 2006 in accordance with the object of National Policy on Environmental as approved by the Union Cabinet on 18th May 2006. This lifting irrigation scheme involves the approximately 32,000 hectares of land in Telangana, 32.297 hectares of forest land in Telangana, approximately 302 hectares of land including some forest land in Maharashtra. This project in principle requires clearance from Central Water Commission and technico-economic report. The project adversely affects the ecosystem in the big way as a construction will be in the forest area without forest clearance. Witnessed accident in the form of landslides to the government of Telangana, making a note of incidents without permissions in the statutory violation. The central government have conducted the environmental impact assessment.
Ma'am, sorry to interrupt. If you could please conclude.
Okay, sir. Okay, sir. I will conclude it. The state government can take a note that this reports and review of cost as benefit technical specialization to the independent body so as to signify the reduce the cost and improve the benefit of the farmers, providing the government it should prepare to engage a senior debates and a proper schemes. The social economical costs like implementation of promoting the solar energy products under the Power Ministry 2018 on the reservoirs to become green by 2032 are not even included in this project. So I'm going to suggest that the central assistance scheme under the power, financial, tourism sectors, etc. be extended to the Kaleshwaram lift irrigation project to the operation of maintaining cost creation, agro-ecological zones, efforts to have the safe drinking water as a part of mission of Bhagirath. Okay, thank you, sir.
Thank you, ma'am. That was a wonderful study. Now, I would like to invite Dr. R.V. Vishnukumar, sir. He'll be presenting on big dams and developmental projects legal implications. Welcome,
hello. Yeah, good morning. Can you give me the presenter this thing?
The IT team can please enable.
Yeah, we're doing it.
Yeah.
Good morning, sir. It'll be great to hear you after a long time.
Hi. Good morning, Ashish.
Yes.
Yeah. I think I have shared my screen. You're able to.
Yes, sir. It's visible.
Yeah, visible. Yeah. Okay, right. Good morning to all the dignitaries present here, my colleagues and dear students and guests and visitors from outside also. And as you can see, my paper is titled as Big Dams and Developmental Projects and Legal Implications. Just a few graphics, before I just start with the introduction. This is about dams basically, as I told you, and a little bit about development projects also. And dams are not nothing new as such, In fact, they have been since ancient times. And the earliest known dam is the Java Dam in Jordan, it is the structure is of about 3000 BC. So you can guess how long these dams have been there, and it's not a recent issue as such, though the issue might have been aggravated otherwise, right? So that's it. So now, why dams at all then? So many dams, so much of a history since from 3000 BC. Why dams at all? So we just link it up to the essence or the soul of the scenario, water loss. So water always have been an essential element, for the survival of mankind or human race as such, And the scarcity and resultant need to augment it, because of the scarcity, particularly in certain parts of the globe and of course in India also, led to the emergence of large dams as a river basin development tools and management as such. Dams, yeah, on the other hand, are not cheap to build, They are very costly affair. And in spite of a costly affair being an infrastructure which is supposed to help the development work, they have a significant negative influence, on the physical environment. They tend to disturb the lives and lifestyles of the individuals, who especially live in the reservoir region and the peripheral region, and especially those who rely for their livelihood on those dams. And this is all in the absence of without being replaced by any equivalent and acceptable alternative systems. I think that is the crux of the problem. We have a look at certain other aspects, which gives credence to my point that this is the crux of the problem. Dams have been harshly criticized by a number of NGOs as such, has been counterproductive and environmentally damaging in spite of it being a development work per se. There is some statistics, from the World Commission on Dams, displacement policy and law in India. There is a paper, by them, and they say that in 120 years of planned growth, it has resulted in large forced evictions of especially the vulnerable populations without any recourse, or countervailing programs to assist them in rebuilding their future lives. And here we have a quote of a sociologist, because essentially dams are also studied by sociologists quite often, if not all the times. So I thought I should just bring in this quote so that better perception is there, what is it I'm trying to drive about. So he says, he's Michael M. Cernia, he says it's like becoming a refugee being forcibly ousted from one's land and habitat with the construction of a dam, a reservoir or a highway. And it's not only immediately disruptive and painful, it is also fraught with serious long-term risk of becoming poorer than before displacement, more vulnerable economically and disintegrated socially. I mean, it is there for all to see what is it about in spite of it being a highly developmental work. Then what I thought, since it's a research paper, I would just try to put in some hypotheses, So I've just drafted some hypotheses, which is like majorly negative aspects are associated with the displacement, which are lack of information, failure to prepare a comprehensive rehabilitation plan in advance, undervaluation of compensation and its payment in cash, failure to especially restore lost assets or livelihoods. Then not to talk about the traumatic and delayed relocation problems at the relocation sites, multiple displacement, and neglect of the special vulnerabilities of the most vulnerable sections of the society. And I would demonstrate my hypothesis is proved in just a little while. So after setting out the hypothesis in this research paper, I propose to deal with the topic on hand, in three phases. Basically, what is the ramifications of big dams and developmental project, its legal implications, because that's the title, right? And some few suggestions at the end. I have a graphic here. Really, this all tells it all, the ramifications. It's about displacement, dharnas, protests, and nothing to talk about the rehabilitation and resettlement, which is a big question mark, a big question mark. I would also address the relevant legal enactment, to understand how this has been tried to, mitigated in the long run, by virtue of the provisions in the enactment. Now, what are the other ramifications? Since 1947, all these development projects have been going on. And there is one study, by Walter Fernandez. It's a rehabilitation policy for the displaced. I have given the source also. He says that about 50 million odd people have been displaced, since 1947 because of these development projects. And then to quote from the Greater Common Good, it's an essay, The Human Cost of Big Dams, written by the well-known Indian author and social activist Arundhati Roy. Permit me to quote it, according to a detailed study of 54 large dams done by the Indian Institute of Public Administration, the average number of people displaced by a large dam is 44,182. Admittedly, 54 dams out of 3,300 is not big enough sample, but it's all we have. Let's err on the side of abundant caution and take an average of just 10,000 people per large dam, 33 million. That's what it works out to. What about those that have been displaced by thousands of other development projects? 50 million people? I feel like someone who is just stumbled on a mass grave, That really tells the agony for me, Moving on further, like I said, the hypothesis I have framed, in fact, it is answered here, again, I just would request the moderator, to permit me to narrate this story. I promise, give me some time. I promise it will infuse life into my presentation. Again, I have given you the source, Hello.
Yes, sir. Yes, sir. Please proceed.
Okay. Again, I have given the source, it's a book, by Harsh Mandar. The title is Unheard Voices, Stories of Forgotten Lives. It's a 2001 publication. And it deals with issues of development, displacement, and rehabilitation, through the eyes of Nanhe, he is the protagonist, he is the central character in the book or in the theme, so to say, or in the story. It's not a story actually. It's a real incident, in the state of Madhya Pradesh. I would just narrate it to you. See the agony of this displacement, these developmental works. That's what I said. It would infuse life, into my presentation. Please bear with me. I narrate this story, 2 decades after his uprootment from the land of his ancestors, Naneram still speaks little. Looking much older than his 60 years, he sits for long hours outside his dilapidated hut in the resettlement village of Aitma, that is in MP, He has no land, no cattle, no sons. It is his aging wife who labors all day in the forest or fields of the big farmers to keep the fire burning in the kitchen. The first time Nanne and the villagers heard about the large dam would submerge his village, he recalls, was when the daily wages were 12 annas, probably in the mid-50s. Their village, like the entire region, was entirely unconnected to the outside world. He did not know then the gigantic thermal power complex was being planned in the neighborhood of his village, Korba, where 2 rivers were to be dammed. 59 tribal villages were to be submerged, 20 completely and the rest partially, in an area of about 213 square kilometers. The survey, sorry. In fact, before the survey, no one consulted with or even informed the families, who are numbering about 3,000 or so in the 60 odd villages, and they have been condemned to internal refugees as internal refugees to the cause of national development, and how it would so profoundly alter their lives, I'm afraid, irrevocably. And an overwhelming 85% were tribals and Dalits who, like Nane Ram, were the least equipped by experience, temperament, or culture to negotiate their new lives amid ruins of their overturned existence overnight, literally. The survey continued for 6 or 7 years, and it was in 1961 that the first phase of the project for construction was sanctioned. Or it was a decade and a half later, in 1987, the submerging actually started, and in between these intervening years, this is of particular note, no one from the government planned or spoke as much with them about how they were to reconstruct their ravaged future lives. However, after a few months before the actual submergence, the farmers were addressed by the officials informing their village would be drowned by the dam reservoir only months before the next monsoon, and the government would be paying them their first installment of compensation. And for Nanne, the central character, this was the measly 540 rupees. Imagine 540 rupees compensation. When their truck returned to them to their village, it was morning. They found that the local revenue officer, Tahsildar, was waiting for them. What for? Not more compensation, but to recover from their compensation Nanne's land revenues. Nanne lost to him 300 rupees, and the remaining 240 also disappeared along with the day for the day-to-day survival. During the meeting, the district officer in the district office, someone timidly asked, "But where are we to go when our village drowns in the next monsoon?" The officer curtly replied, "How do I know? Why don't you go to your relatives' homes?" Eventually, some compensation was paid, and Nanne started his new life, with his wife and two daughters and a cow, Somehow he could not maintain the cow, and he gave to one Ahir, and started paying him 250 rupees each year to look after the cow till the cow had died, And then just before the next monsoon, the trucks arrived again. And what were they given as a compensation? What was the rehabilitation? What was the rehabilitation? The rehabilitation was a measly and a very lagging 0.05 acres of land, and that has been hurriedly cleared.
Sorry
Yes,
to interrupt.
yes.
We are little short of time.
Yeah, give me 2-3 minutes. 2-3 minutes.
The next session
correct?
is going to start at 12
Yeah,
o'clock.
just give me 2-3 minutes, right? Yeah. So therefore, this is how you can say the story, not story, actual incidents of what is there at the ground level, So I conclude with the story. I straight away come to the legal implications. Just give me 2-3 minutes more. That's it. So it has resulted in the enactment of the Right to Compensation and Transparency Land Acquisition Act, and it has tried to balance both the development and the loss which occurs during the development, And one of the most important features of it is the social impact assessment. Without the social impact assessment, no compensation, howsoever it may be, howsoever much it may be, can be validated, right? This is an important aspect of it. Then there are certain other provisions which say that only after ensuring full payment of compensation as well as rehabilitation resettlement entitlements are to be paid to the tendered or to be tendered to the entitled persons, then only possession of land is to be taken, right? So these are some of the provisions. There are other provisions also which go towards achieving a balance, between the development and the whatever loss has been there for the whose land has been taken away. And then on a flip side, all this has brought about increasing costs and all the things. A classic example is the Delhi-Jaipur Express Highway, where the initial cost was 50 to 60 billion. It has shot up to 320 billion. I understand it is going to be completed next year, March 2022. And then some suggestions, finally, I wouldn't go through it. You could just glance it. Give me another half minute. You could just glance through it because of paucity of time. So with this, I come to end of my presentation. I thank the Honorable Vice Chancellor for giving me opportunity for being here. I especially thank K. Sudha ma'am, the convener of this workshop, for enabling me to present my paper here. And finally, I thank all the learned audience here for having patience to listen to my presentation. Thanks one and all. Have a great day.
Thank you, sir. Thank you so much. Now I invite Ms. Nivedita to deliver on the topic India and its interstate water disputes. Is Nivedita present? I think she is not present. We'll move on to the next presentation. It is by Mr. Samarth Jain and Ms. Sejal Gupta on disputes, democracy and citizens, interstate water conflicts.
Can you please allow me to screen share?
I just made Sejal Gupta presenter. Okay, I'll make you all. Please check it, Mr. Samar.
Yes, sir, sharing.
Am I audible?
Yes, yes, you are.
Good morning to all the dignitaries present. The topic of our research paper is Disputes, Democracy and Citizens, Interstate Water Conflicts. See, we have to differentiate between situations in which collaboration is feasible and situations in which the initial distribution of rights is at issue. In the latter scenario, attempting to reach an agreement via negotiation may be fruitless, and moving quickly to arbitration or adjudication for that matter may be more efficient. However, in India, intertwining interstate water disputes with broader center-state tensions and political concerns accelerates challenges. The reason for selecting the topic is that while researching upon the sub-theme interstate and intrastate water disputes, we stumbled upon the proceedings of the 1992 International Conference on Water and the Environment and realized that a water crisis can put pressure on affected parties to get more of a shared water supply, which can lead to diplomatic friction or outright violence. Our research aims to discover which dispute resolution arrangements are more likely to provide a satisfactory result. The research method used was a qualitative method where we, for the most part of it, relied on secondary data analysis. This has been done primarily with the help of case laws, leading judgments of various courts, and the reports of various committees and commissions, for example, the Sarkaria Commission's report. A thorough analysis of content from sites like JSTOR, SSC, and Westlaw was also done to generate a better perspective. And empirical research has also been conducted by us to assess citizens' knowledge of the problem and solicit their recommendations. Moving on to theories and institutions of law, during discussions, initial claims to water were frequently supported using many basic legal theories. We have identified 4 such theories. The first theory is that of doctrine of riparian rights. The name Ripa means the bank of stream in etymology. The theory of riparian rights stresses that all owners of land bordering a river have equal rights to utilize water. According to the Krishna Water Disputes Tribunal, the theory controls the interests of private parties but does not provide a suitable foundation for addressing interstate water disputes. The second one is the theory of equitable apportionment. This theory was originated in the United States as evidenced by the Supreme Court's decision in Connecticut versus Massachusetts, which said that interstate water disputes should be decided on the basis of equality rights. The Krishna Water Disputes Tribunal report again noted the following, that in India too, the rights of states in an interstate water dispute are settled by adopting the equitable apportionment rule, which with each unit receiving a fair part of the shared river waters. The third one is the theory of prior appropriation. According to this idea, the first user who puts the water to good use creates a prior right, and future users can only take what the first user has left. This theory assigns property rights to water based on its previous usage. In India, this notion is likewise not considered to be legal. The fourth one is the theory of community of interest. According to this thesis, a river that flows through multiple states is one that should be handled as one in order to maximize the use of its waters. The Kosi project between India and Nepal is frequently mentioned as an example of how this strategy has been implemented. Moving on to instruments of legislation, Dr. Srinivas has already covered this very well in his keynote address, so not getting into the details of it, but just the shortcomings that we came across. Water is declared a state subject in the first clause. However, it is limited by the Union List Entry 56. The ability to act on the issues stated in Entry 56 as well as supremacy over the Supreme Court is specifically granted to Parliament in Article 262. The Parliament, on the other hand, hasn't put Entry 56 to much use. Various river authorities have been proposed, but none have been legislated or established as management organizations. Instead, river boards with just advisory powers have been created. In this institutional context, conflicts are inescapable since rivers run over state boundaries. To resolve conflicts, the Interstate Water Disputes Act of 1956 was adopted, which included provisions for the establishment of courts to arbitrate when direct negotiations fail. States, on the other hand, have refused to recognize tribunal decisions on a few occasions. Arbitration, as a result, is not legally binding. In addition, the courts have occasionally been disregarded. Finally, on a few occasions, the center has engaged directly, but only in the most critical of interstate river water disputes. Government participation has also failed in tough situations such as that of Haryana, Jammu Kashmir, Rajasthan, and Punjab sharing the river Ravi Bias rivers. For addressing interstate water issues, there is no defined institutional structure, and this is where the problem lies. And even the river boards that were established by the River Boards Act of 1956 to oversee the management and the development of interstate rivers and river basins was just an advice. The board's role was just advisory rather than adjudicatory. So I now hand it over to my co-author for further discussion.
Am I audible?
Yes, yes, you're audible. And
Moving on with
Samarth,
the
you have
empirical.
2 minutes to conclude.
Okay, sir. Now, moving on with the empirical research of our presentation, the process which we followed was by sending an email invitation to complete an electronic form of the survey. And the survey was sent to the entire student body of our college, which is Institute of Law, Nirma University, and also to some of our friends and family members on 1st of August 2021. It was sent to approximately 2,000 people, out of which a total of 197 responded by the collection date of 12th of August. The results of the survey were basically to check the ground reality of the situation and the awareness. The results which we found was that around 81% of the people polled were already aware of the problem and also were thinking about what its repercussions are. Out of them, around 30% of the individuals said that the host country should have the total access to river water. And around 78% of the respondents said that India is still lacking such regulations and that the government should enact strong legislations on the subject. If we talk about the majority of people, that is 94% of the population, thought that the government should share water equitably and that they should attempt to prevent conflicts as much as possible. Now, moving further, with the India's major interwater disputes, we have gone through some of the major points of contentions. Water concerns have gained a lot of attention from the national government since they first emerged shortly after the constitution was established. The Damodar Valley Corporation was inspired by the Tennessee Valley Authority in the United States. Tensions and disagreements arose between the corporations and its member countries shortly after its establishment, obstructing its activities. As a result, it was never able to establish return in the lack of a clear transfer of power away from the politicians. There have been three major disputes, which is the Krishna and Godavari River, Kaveri River water dispute, and the Ravi and Beach disagreement over water. Because of the possessivity of the time, we will continue only with the Krishna and Godavari River. Now, moving forward, negotiations between Maharashtra, Karnataka, Andhra Pradesh, Madhya Pradesh, and Orissa over the Krishna Godavari river water issue failed. The major point of contention was the interstate use of untapped excess water. In 1973, the Krishna Tribunal issued its verdict, which was published in 1976. For
Mr.
the actual
Samarth, sorry to interrupt. I've exhausted the time. Could you please conclude?
Sure. I'll just proceed with the conclusion and recommendations. To conclude, we have considered how effective the current system is in resolving interstate water conflicts given this context. The conflict resolution system given by Article 262 and the Interstate Water Dispute Act 1956 appears to be functioning well, but however ran into problems later on. If we talk about major flaws which it is having, first is the adjudication is not the best way to resolve such issues. Instead, a negotiated arrangement would be far better. It should be emphasized that Article 263(2) and the Interstate Water Issues Act of 1956 do not impose adjudication on contending parties, nor do they prevent discussions, conciliation, or mediation. The second flaw which we found was that there were no national water sharing guidelines present in the country at this point of time. The third is that there are no efficient ways of ensuring that the final decision is followed. Although an interstate water dispute tribunal's award is supposed to be final and binding, but there is no way to ensure that it is being followed. The fourth is that there are no efficient ways of ensuring that the final decision is followed. Although an interstate water dispute award is given, but it is not final and binding. Now, I would like to end by giving a few recommendations which we found while working on this research. First is that Parliament can pass specific legislations under Entry 56, bringing the river under central control, or the centre can establish a river board for the river under the River Boards Act 1956. The last recommendation which we would like to give is that rather than a total bar on the Supreme Court jurisdiction as specified in Article 262, a partial adjustment of the bar should be worked out. The Interstate Water Dispute Act of 1956 should be modified to allow for a Supreme Court appeal of the tribunal's decision. This proposal, it is said, combines the benefits of a tribunal system with those of the US system of a final ruling by the Supreme Court. I would like to end it, and I would like to thank all of the organizers for giving us a chance to present a paper here. Thank you so much.
Thank you, Samrat and Sejal. We would like to move to the next presentation by Ms. Sanjana Rai and Samriddhi Jha on the topic tug of war between inter and intra-state resources and expeditious need for mediation over water disputes.
Can Sanjana or Samriddhi tell me as to who should be made a presenter?
Sir, I will be the presenter.
Okay. Check your share button. It should be active by now.
Yes, sir. Sir, is it visible?
Yes, yes. You may start.
Yes, sir.
Samriddhi, you can take the position of the screen as well as make sure that it is completely visible, because I can see a very short of the presentation is only visible. Can you make it a bigger in size so that other people can also see it easily? Can we do that? Is it possible?
Just a second.
Yeah.
Ma'am, in the meanwhile, you can start the presentation. You can.
Sir,
Sure,
I
sir.
am going.
Samriddhi, go ahead with the presentation.
Okay.
Yeah.
Good morning, everyone present here. I, Samriddhi Jha, along with my co-author Sanjana Rai, are going to present on the topic tug of war between inter and intrastate river resources and expeditious need for mediation over water disputes. In India, India is an inland of major tributaries, many of which are connected through different regions and states. Since river resources share an integrated provincial approach with the involvement of the center, it requires conservation, equitable distribution, and sustainable use of river water. Hence, rivers in central India have become a competitive area, fueled by conflicting ideas for property rights, erroneous economic resources for food security, and increased hydrology that hampers the development of water dispute. Such dispute over the management and control of river water have continued since the founding of the Indian Republic. Long delays had been upfront due to historical, institutional, and political factors. In recent years, rising water scarcity, rapid urban and rural demand for clean water, and conflicting political forces have only increased the problem. Here we have shown the Maslow's hierarchy of needs with comparison to the water sustainability and utilization. Interstate river water dispute. The most longest and the oldest water dispute in India is Kaveri water dispute. It was there was an agreement between the Mysore government and Karnataka government in 1892. After that, in 1924, a new agreement was formed, which will likely to continue to 50 years till 1974. But in 1970, Tamil Nadu Farmers Association filed a civil suit in the Supreme Court demanding the release of water from the Karnataka. After that, a formal request for the formation of tribunal was made by the Tamil Nadu government to the central government in 1986. In the year 1990, the tribunal was formed, and after almost 17 years, the Kaveri Tribunal declared an award on February 2007, ordering Karnataka government to release the given amount of water to different states. But Karnataka government didn't comply with the given order, and even in the interference of the central government didn't put a full stop in the given dispute. Satluj Yamuna Link Canal dispute. The Satluj Yamuna Link Canal dispute is between Punjab and Haryana.
Samriddhi, can you just change the slide? It is still in the first slide, maybe.
Sorry, sir.
It is still showing the first slide. You can just click on the slide bar.
Samriddhi, please change the slide. You are in the third slide, but it's still showing the first one. If you could do that.
I was changing the slide the whole time.
Okay, it wasn't visible on the screen, but it's now. But make sure that it's changed. Okay. Yeah, you can continue.
Sorry for the inconvenience. Another major river water dispute is Satluj Yamuna Link Canal dispute. The Satluj Yamuna Link Canal is 214-kilometer long waterway that connects the Satluj in Punjab to the Yamuna in Haryana. But it has given rise to a very big dispute between Punjab and Haryana government. When Punjab was divided into another state, Haryana, on October 31, 1966, a new dispute arose for the water between the two newly formed states. In 1976, the then Prime Minister Indira Gandhi divided the water between the two states. But Punjab refused to play its part in the deal. Thus, the Haryana government moved to the Supreme Court for the construction of canal in 2002, and the Punjab government was ordered to construct the canal in 12 months. But soon after that, Punjab government then passed the Punjab Assembly Termination Act in 2004, which terminated all the water sharing agreement of Punjab with other states. It was declared unconstitutional by the Supreme Court. But in 2016, Punjab government passed another act, that is Punjab Satluj Yamuna Link Canal Rehabilitation Revesting of Proprietary Rights Bill, to give back the lands in which the canal is going to be built to the original owners of land free of cost. For now, the Supreme Court has ordered status quo on the bill. The following data shows the tribunals formed in the various years for the different river water disputes. Conflictual unionism. The issue of conflictual unionism arises when there is an improper power distribution over water resources. The main reason behind putting river water under center is that river water is not restricted by the boundaries, and hence no state can have exclusive right over it. But the state government simply uses the term water, which allows it to make laws all over the available surface water, irrespective of the fact that the source of the river is located outside of its boundaries. State only exercises its right to use water as long as union government finds it appropriate. If used inappropriately, then the union government can enact law in the public interest. But the union government had been reluctant to play this role.
Presenter, sorry to interrupt. You have 2 minutes more to conclude.
Yes, sir. Which resulted in indiscriminate and unregulated use of river water. The second half will be covered by my co-author Sanjana. Sanjana, over to you.
Yeah, I keep it in a very brief. Coming to the next slide, where the debacle of government administration framework failed actually for the prolonged river water dispute. Conflict over the river have always been a source of political inequality. These conflicts include matter of pride and nationalism. The importance that conflict resolution plays in political Indian system, where water supply is referred to the constitution as a national issue, But significantly, the rollout shows a completely different situation where the administrative government has failed at multiple occasions for river water dispute. From prolonged imparted dispute to being failed being established a mechanism, the administrative government has made its own people under the shadow of suffering. Moving to the another slide. Samriti, can you change the slide? Moving ahead, given these statements, some exception make a stellar entry to the hindrance process of interstate water dispute by turning the cause of non-effective implementation of solving dispute at hand. Number one, forthcomings in implementation and assessing of 2019 Inter-Water Dispute Amendment Bill, which straight away restricts the power of the judiciary, political of identity of state, which is linked to the nationality and culture of the state and its people. Third, political quandary, which actually limits the state political disclosure with reference to the dispute resolution of the inter-water state. Making a move towards why it is actually needed for mediation to come into a picture, that it is very much
sorry to interrupt. You have exhausted the time.
Sir, can I take the recommendation and conclusion at hand then?
Yeah, please, very briefly. Just for
Sure,
the
sir.
best interest of the time, we are running little late for the next session.
Sure, sir. Considering the future goals of resolving water dispute amicably and peacefully, there are some pointers which we have taken under the umbrella of mediation for the dynamism of interstate water dispute. Need for a transparent and a powerful institutional framework is required for a cooperative approach. Administrative council must work together based on the absolute equity, integrity, and mutual to achieve an optimal use of mediating resolution. There is a need for center to establish a single permanent tribunal to rule water dispute between rivers and major step forward the resolving dispute with reference to the alternative dispute resolution. Lastly, there are two main international conventions which are named to be Agreement on the Protection and the Use of the Transboundary Watercourse and the International Lake and Convention of Law and Non-Navigational Use of Water Resources, which actually highlights that India is not part of these international conventions, which raise a question to its Indian legislation framework with reference to the interstate water dispute. If India would have been signatory to these meetings, its legal framework would not have been outdated and insufficient now, because it would have been in line with international standards for resolving the water dispute of among the parties amicably. And concluding part, we surely believe that mediation can bring in a very suitable part with reference to the interwater and intrawater water state dispute, as mentioned by a CGI in the reference of the why mediation can bring in so much of amicability and peacefulness while resolving these disputes is effectively and cause of bring of change that we can bring in the chamber of alternative dispute resolution. So that is for my end of my conclusion. Thank you so much. I take the opportunity to thank the organizing committee and student council for organizing this event. Thank you so much.
Thank you, Ms. Sanjana. Now we move on to the final presentation for the session. That is by Sushrita Mishra and Lalitendu Debata on the topic Interstate River Water Disputes, Politics over Welfare.
Sir, could you please kindly make me the presenter?
Sir. I think you have been made.
Your share option is enabled now.
Yes, thank you very much. Yes. Thank you very much for the opportunity. So the topic of our presentation is Interstate River Water Disputes, Politics over Welfare, presented by me, that is Lalitendu Debata, and my co-presenter Sushrita Mishra. As we all know that India is a home to innumerable water bodies, yet the irony is that the people of India face a lot of water-related problems throughout the year. Even though there are 10 major water river bodies and 20 major river basins, yet the problem is still very much detrimental in the context of today's scenario. These issues can be traced back to both the natural and artificial issues that's been highlighted in the presentation. And now moving on to the legal framework, as already vividly explained by Dr. Srinivas Chukakula. So I do not think that there is any necessity, but as he stated that NT 56 of Union List, NT 17 of State List empowers the center and the states to make laws. And apart from that, Constitution of India, by Article 262, has entrusted the Parliament with the power of enacting laws for resolution of interstate water disputes. And following that, the enactments have been made with that Interstate River Water Dispute Act 1956 and the River Board Act 1956. However, the presenter would like to take out some loopholes in the present enactment at a later stage. Water dispute has been defined in the Act that any disputed difference between two or more state government with respect to the use, distribution, and control of the waters, as per the definition under Section 2, Clause 6 C of the River Dispute Water River Dispute Act 1956. So the authors have divided the types of interstate river water dispute, that is allocation of water between different states, the apportionment of construction cost and benefits if a project is developed jointly by more than one state, the compensation to states prejudicially affected by implementation of a project by another state, dispute settlement relating to interpretation of organization and excessive withdrawals by a state. These are the kind of disputes which usually happens between two or more riparian states. The blind spot in the law, states to states egotism. That is, many a time the first process for any to resolve any dispute is negotiation. However, the states do not will to mediate, and they prefer litigation. That has been the current scenario. And the composition of the tribunal is from judiciary. However, leaving many technical persons who can give a better analysis regarding the water disputes and give a better solutions. Moreover, neither the states under Article 136 nor the general public under Article 32 are barred from moving the Supreme Court when they are affected by the awards. Even though it has been made in the Act that the decision of the tribunals shall have the shall be binding, but it is generally not followed. And till today's that only 3 awards has been mandated among several other awards. The authors have specifically took the Mahanadi River Water Dispute and Krishna Water River Dispute for this today's presentation, stating how politics has taken over the reformation, the welfare of the people. If we take the Mahanadi River Water Dispute between the state of Chhattisgarh and state of Odisha, it is related to the mainly related to the Hirakud Dam, the formation of barrages, and ignorance to the farmers' lease. The location of the Hirakud Dam makes it the crux of the debate of the utilization of the water, because mainly the catchment area of the Hirakud Dam is mainly in the state of Chhattisgarh, but the Hirakud Dam is in the Sambalpur district of Odisha. And there has been an allegation by the state of Odisha that there has been illegal construction of 7 barrages by the state of Chhattisgarh, which will hamper the ecological disruption of the Mahanadi River and will lead to an early death of the river. However, the same stand has been reverted by the state of Odisha, and state of Odisha is constructing more than 4 barrages on the Mahanadi River, which the farmers, being a resident of Odisha, I have witnessed the protest by the farmers because they want that from the reservoir of Hirakud Dam, the water should be given for the irrigation. However, the water is being provided to industrial units for their development. Recently, in the month of July only, there was a protest by the farmers in the Paradip relating to the construction of the barrage. However, the water resource minister stated that.
Sorry to interrupt. You have 3 minutes more.
Okay. And have neglected this particular issue. And moreover, in the Krishna River water dispute, there have been different demands by the state of Telangana and Andhra Pradesh. They are not, there is no ad concession, there is no meeting of minds. And the disputes led to Srisalam Reservoir in the Rayalaseema region. There is more than the welfare, the politics between the state governments has taken over more. There has been judicial analysis. I would just like to highlight the decision of the Justice R.P. Sethi, who had stated in the Kaveri water dispute case that the states should prefer to mediation. There should be an analysis and they should try to resolve the dispute. However, there is the politicization of the matter, and this is a sheer mistake done by the state governments. Now I would like to request my co-presenter to take over the next issue.
Thank you, Lalit. Hello, everyone. So this paper is a solution-based paper rather than an issue-based paper. And our solution here is the cooperative federalism. This is the instrument that is going to hold the entire states and the center together. As Ivor Jennings has correctly said that our constitution is a federation with a centralizing tendency. And this can be actually implied from the bifurcation of all the powers and functions that has been given to the states as well as the center. So as we have analyzed that entry 17, which deals with water in the state list, is actually a qualified entry and which ends with a phrase that's subject to the provisions in entry 56 of list 1. So despite an influential position of the center, the role has been found to be quite dormant. Sometimes the center is quite nonchalant. Overtly intervening. Again, its dominance is implied when the states ask for any kind of the establishment of tribunals. So it's actually the center whose discretion is mostly found. And in case it is the center finds that it is to the disadvantage to the same party at the state level, it may actually deny for that. So this issue is very much colored with filthy politics and the blame game, whose ramification is no less than the degradation of the ecosystem, the delay in resolution, and the harm to the actual stakeholders. So what it basically implies is that
Ms. Sushrita, sorry to interrupt. You have exhausted the time. If you could please conclude.
Yeah, definitely. Thank you very much. So the thing is that every state is of the opinion that no one can harm the environment except me. So here are a few ways we are providing for. The first is that Parliament should not be dormant. It should exercise its powers under Entry 56 of the Union List. And the laws enacted should be transparent, detailed, substantive laws. And the state should take up all the measures for the compliance of the DPSP. And we need a permanent and independent adjudicatory tribunal or any body whose penalty should be whose decision should be binding, and there must be strict penalty for non-compliance. Along with that, we need an independent body which should collect all kinds of information relating to interstate river disputes, so that the concerned parties should not furnish diverse and incomplete information to the adjudicatory body. So what we want to conclude here is that history is evident that wars have been waged for water. So let the history not repeat. So what we want is that there should be sustainable development, selfless decision making, and serious implementation that will lead to the path of peace and prosperity. And the most important fact is goodwill. Goodwill on the part of state, center, and every individual. That should be the dominant factor in order to decide, and not the greed for power to accept and implement the objective settlement. So with this, I hope the presentation was quite insightful. Thank you all. I conclude.
Thank you so much, sir. Thank you, presenters. And by this, we have come to the end of the presentations. I thank all the presenters for their wonderful presentations. There were 6 set of presentations covering on the topics of interstate river water disputes. And we have come to know about various facets of this particular debatable issue. Now, the session is open for questions. If there are any questions from the participants, they can post it in the chat box, or if there are questions from the panelists, Professor Srinivas sir, if there are any questions to our presenters.
Thank you. If we did have time, perhaps Dr. Balram could actually present his conclusions, which he could not present, which was an interesting presentation, but it's your prerogative anyway, it's up to you. But I have this question to Dr. Vishnu Kumar. I think what I'm curious about it, and I hear these arguments about his sociological dimensions about dams and development, and I just wanted to provoke him by asking this question, particularly post recently, Swaminathan Ankaleshwar Iyer, in collaboration with Columbia University, has done a study as well as a film, which is streamed on Disney Hotstar, about the rehabilitation done after the Narmada Dam, or otherwise for the Narmada Dam. So it's on the basis of that. The question that I wanted to ask him specifically is that if, that Narmada Dam is the peak of that it has shaped the entire global debate over dams, and it has been for over the past 30 years. In spite of the fact that such an awareness has come through about the adverse consequences of dams, why do we continue to build dams? I mean, it is not as simple as that. The point I'm trying to ask is that what pushes us to pursue the dams for development as a paradigm for pursuing India's long-term developmental interests? And why do these dam projects become center of negotiation for bifurcations like Bombay, Gujarat, Andhra, Telangana? Polavaram has become a center point of negotiation between Andhra and Telangana. So what is it that, what are the factors that are supportive of these dams for development? Whereas when we know that such an adverse consequences are there about the dams, due to dams. So trying to be provocative, that's all. Nothing to do with my own position. So thank you. I don't know whether Dr. Vishnu Kumar is around.
Vishnu Kumar, sir, are you?
Seems like Vishnu Kumar sir is having a technical issue. I'll try to communicate. Kindly proceed to the next question if there are any.
Can't see any questions in the chat box as of now. So, Pallavi ma'am, anything from your side?
No, sir. No questions. I have no questions.
Thank you. So there are no questions as such. So I would like to take the opportunity to thank the organizers, especially Dr. K. Sudha ma'am and Viola sir, for giving me this opportunity to be in this particular session. It was a very enlightening session from Srinivas sir, and all the presentations were wonderful. And I would like to also thank Dr. Pallavi ma'am to be the co-chair of this session.
Thank you. Thank you very much.
Thank you.
Thank you.
Over to you, Viola sir.
To Priyanka. Priyanka, wrap up now.
Okay. Okay, ma'am. Okay, so thank you for one and all for attending this session. It was really a good experience for everybody staying here. And this is the end of our session. We thank each and every participant who joined here and each and every presenter who presented their paper and all the guest speakers. We'll proceed with next session after this.
Thank you, Priyanka. Thank you very much, Sudha ma'am.
Thank you,
Shravani is there. Shravani.
Priyanka, I'm there.
Yes, Ramani, I think you can start.
Okay, ma'am. Thank you, ma'am. Yes, ma'am. Good afternoon, everyone. Welcome to the technical session 5, which is about commodification, privatization, and water markets. Dr. Stelina Jolly is the keynote speaker in this technical session. I want to give a brief introduction about this session. Water, like any other source, is finite.
The commodification and mismanagement of water and other sources is making life unsustainable on this planet. When water is treated as a commodity, then the basic question that would arise is, who is the owner? Is it the state, the corporate bodies, or the people? There are some other questions that might arise, like, should water not be treated as a common pool resource? The other one would be, how should it be priced so that access to none is denied and the resource is conserved? So far, the courts had to breathe life into the age-old Roman law doctrine of public trust to remind people in power that they don't own water and they are its mere trustees. Old doctrines are being revived, new remedies are being evolved, but the state keeps resorting to use of the doctrine of eminent domain. The deadly combination of the acts of corporate bodies and the states are converting the clean and pristine waters into toxic cesspools. So with this brief introduction, I would like to introduce about Dr. Stelina Joly before proceeding further. Dr. Stelina Joly is a senior assistant professor at the Faculty of Legal Studies, South Asian University. She is a visiting senior research associate with the Center for Emerging Countries in Private International Law at the University of Johannesburg. She is a Fulbright scholar with the University of San Francisco and a recipient of International Visitors Leadership Program. She has researched in international environmental law and conflict of laws. In the area of environmental law, her research papers have explored the north-south dimensions of environmental justice. Her book, Climate Refuges in South Asia, published by Springer, explored the legal and policy framework of climate refuges in South Asia. She has also elaborately written on environmental justice and governance concerns, and also on intersectionalities of climate change, water, gender, disaster management, and sustainable development goals, focusing on South Asian jurisdictions. Her recent work concentrates on the emerging global trend of rights of nature. In her research, she advocates an approach based on sustainability, hybrid law mechanism, and environmental justice to tide over the environmental crisis. Dr. Stelina Joly has published in numerous leading international journals like the Transnational Environmental Law, Washington Journal of Environmental Law and Policy, Texas Environmental Law Journal, and Chinese Journal of Environmental Law. She is a member of IUCN World Commission on Environmental Law and part of Network of Environmental Champions and Asian Development Bank. She has undertaken projects and consultancies with various organizations, including the Rajiv Gandhi Foundation, European Union, and International Renewable Energy Agency. So with this overview, I would like to like Dr. Stelina Joly to proceed with the keynote address on commodification of water with a special reference to the legal personalities of rivers. Ma'am,
Yeah.
over to you.
Yeah, thank you, Shavani, for the kind introduction. And I should, first of all, let me express my, heartfelt gratitude to Sudha ma'am and other organizers for giving me this opportunity to come and express my views on this topic. I was going through this, the schedule and brochures, and I could find all the topics which are of huge relevance to the current time, whether it is in terms of access to water or issues of water conflict, both at the domestic as well as at the national level. Before I start with my the presentations, let me just ask you how many presentators, and I think we are supposed to wrap up by 2 o'clock. So I prefer to have some time for the question answer session also. So
yes, ma'am, definitely you'll have one, ma'am. We have 11 presenters in this session, ma'am.
Okay. Okay. So I think I should not take much time. So maybe I'll try to wrap up the viewpoints or flag certain concerns in 10 minutes. I just made a very, very small PPT. If you can make me a presenter, so that would help. Yeah.
Ma'am, you're not the presenter, you can share, ma'am.
Yeah, thank you. Thank you. Okay. Is this visible to you?
Yes, ma'am.
Okay.
It's visible.
Okay. So, a warm good afternoon to all of you. So here, there are two concerns I would like to flag. One, I'll start with the concept of commodification of water and my position on that, and link it with the emerging concept of legal personality of rivers. See, I'm sure that in all the panels, the different sessions which you discussed in the last 2 days, the water must have been considered, or we have all realized the significance of water. Water is one of the foundations of life on earth. So given that importance or a significance, or water as a lifeline of the life and the all forms, which is as part of the ecosystem, if you look at the recent developments and trends, there is a legal initiative as well as a push towards commodifying the water. And if I look at the actual practices which is developed across the world in December 2020, that's the state of California has opened up its stock markets to include water also as a part of tradable commodity, and the futures trade and contract in terms of the water, the transaction has begun in. So this particular trend has been taken up in many states in United States. So many experts actually believe that water can replace oil as one of the most prominent commodity of the 21st century that will be purchased and traded in the open market. So this idea of water being a marketable product and also privatizing that, that raises to a certain ethical and legal questions. And the legal ethical questions are centered around two concepts: whether water constitute a global commons, or is it a part of a global public good, or is it something, a commodity which can be under the ownership of any private. See, the answers are not very, very easy to come. See, if I look at the supporters who vehemently argue, if you look at the supporters, there are most of the international institutions in the form of an Asian Development Bank or a World Bank, very proactively are taking a position that water has to be commodified. And for their support, there is a couple of, definitely it's a valid questions. What there is they say there is a huge concern associated with the wastage of water, because unless and until if you put a value or a economical aspect concern attached to the water wastage and the impact on the quality and the other concerns of water will be there. So in order to make some kind of a responsible behavior on the part of individual, yes, these kind of a water commodifications, and some of them goes to the extent that, okay, very soon, even not only the water, air also will needs to be a commodity, and a certain value or economical value may be attached to that. So in this scenario, definitely a question needs to be asked. Yes, there are crises in the water sector, whether it is in terms of quantity, the accessibility, affordability, and also in terms of the quality, in terms of pollutions and all. So while we accept that there is a water crisis, so does the solution also is found in the context of privatization, or bringing the private sector to the water market and to making the water as an economical commodity? See, if you look at the international developments, the water has been recognized as an economical good from the Dublin Statement. It was reiterated in the Agenda 21 and also the Johannesburg. So you can see that a kind of the water being treated as an economical good has developed even at the international law stage, or international the environmental law stage. But the moment water has been considered as an environmental good or economical good, that raised certain ethical and legal questions also. So given all the concerns associated with, or the supporters who argues that, okay, the privatization could be a solution to the water crisis we see, in my view, I think this is an area where vehemently we need to protest. And why I consider that, okay, somewhere we have to, not protest and also protect the concept that water is a global common good. And I consider due to a couple of reasons that, okay, this particular position is very, very important. One, if I take the water as a foundation of life, And water is not only a foundation of life. In many jurisdictions, in India, it may not be declared to be an explicit the constitutional rights, but if you can see, the judicial statement has declared a right to water as a human rights. The General Comment 15 from the International the Legal Initiative has also articulated accessibility and affordability of water as part of the human rights. And many constitutions in the world has explicitly talked about right of human, the water as a human right. For instance, if we take the South African constitution, there is an explicit provisions on guaranteeing a sufficient amount of water as a human right to individual. So considering the fact that water is a human rights, can privatization or commodifications come into that? See, technically, definitely commodification can come even when something is a human rights. Why? Because if I take right of water, it comes not as a political right or a civil right, it's part of economical and social rights. So that the guarantee of that rights are conditioned by certain the considerations in terms of the capacity of the states, etc. So yes, even if something is a fundamental right or a human rights, yeah, some kind of a privatization or a private entities can come into the market. But the larger question is that when the private entities are allowed into the market, what about the accessibility and affordability? So whether that can be maintained, or the state as the major player or a major, like the state under the public, the doctrine of public trust is a trustee of the resources. So we can't have a scenario where the private sector comes and the state's role is diluted. So whether even if we bring an element of privatization to see that wastage is negated, the state's role and the activism or state as a, the public, the trust doctrine, that has to be again given the prominence. So there is a dichotomy when it comes to the human rights and the role of state, the public trust doctrine, and when you look it into the context of the privatization. And this is also, and second problem also comes in association with the human rights. We can understand whether it is at the local level, regional level, national or a global level, there is a water crisis in terms of whether it is a flood or a drought scenario. You can look at the statistics, the millions of people who do not have enough of an access to both quality as well as the quantity of water. And these situations can even lead to conflict, which historically speaking, I don't think that water, even though it was feared that water can be a major aspect of conflict, but somehow, in my opinion, the international community has, instead of conflict, had forged or envisaged most of a cooperative mechanism. But still, with the crisis which is looming, and especially if you add the climate change also to this, the coterie, then we can see that there is a severe water crisis. And another characteristics of the water crisis is that there is a severe social fault line attached to this water crisis. See, water crisis is not just about an accessibility and affordability issue. It is characterized by the fault lines of caste, race, community, gender, the rural-urban divide. So considering all these aspects, the commodification of the water raises definitely the ethical and legal questions for the community and legal, especially the legal community and policymakers to ponder over it. And why this commodification is considered as a solution to the water crisis, in my belief, is founded on the concept of anthropocentrism. And if you look at even the entire international environmental structure or even international environmental or human rights, it's mostly founded on the concept of an anthropocentrism. So I do not say that anthropocentrism essentially is faulty, but yes, when in the larger picture of international environmental law, when you look at it, yes, everything is looked at from my perspective of humans, and it's so this commodification originates out of anthropocentrism. So in this context, if I look at the emerging concept of legal personality of the rivers, which has from a legalistic point of view or a scholastic point of view, has originated as a reaction to the anthropocentrism and also the notion of the private property. And this is where the commodification and the linkage comes into the operation. See, if I take the scholastic or the theoretical framework behind the legal personality of the rivers, when Christopher Stone advocated this idea, his idea followed a two-pronged strategy. He said, yes, when the corporations can be given a legal personality, even though it's inanimate, it cannot express through a human entity or a human as the guardian or a human as the representation can be done. So why not rivers? But there is a catch. When the Christopher Stone developed this concept of the personality of the rivers, it's not always essentially in the concept, or it is against the anthropocentrism or against the notions of property, the property right. Yes, he wanted to extend the concept of legal personality. So he felt if the corporations can be done, and if we look at the entire history of the expansion of the legal personality, yes, this also can be one of the entity. The idea was definitely picked up by scholars like Thomas Barry and other people. So yes, there has been a parallel scholastic development on the topic of legal personality of the rivers, but the later writers also talked about this concept as against the anthropocentrism, which the current international environmental law is built upon. The moment the legal personality of a rivers or a nature has been granted, that works against the very concept of private property. See, again, like if you look at that legal personality of the rivers, once the personality has been granted, it just becomes part of, I won't say it becomes a part of a global commons, because there is again a human centrism attached to it. But yes, definitely the notion of private property cannot be attached. So if we look at in the Indian context that the groundwater is a private property, it's since it is attached with the land. So in various aspects of water aspects today, the private property concept is attached. See, the personality of the rivers or the nature or the ecosystem challenges the very notion of property rights. That if you consider water as a resource, so that is why if you look at many of the jurisdiction, the groundwater is not always attached with the ownership of land. It's considered as part of the public trust, where it's considered to be a common, the public good, and that definitely has to be the correct approach towards it. So in a way, if I speak from a legal perspective, yes, this concept of legal personality of the rivers challenges the anthropocentrism and also the notion of property, and thereby the commodification of the water or any part of the natural resources as a whole. But if you come to the legal development which has taken place in terms of various jurisdictions, Latin America, the New Zealand, the Colombia, other countries, they are the prominent jurisdictions which has given legal personality of the rivers. See, if I take whether it is the New Zealand development of giving legal personality to the Wanganui rivers, or in the Colombia the judicial statement on Atrato River, or even the Bolivian constitution or Ecuador constitution recognize the legal personality of the nature, what we see is that they are not based on the scholastic understanding of Christopher Stone, whereby they followed the expansion of the legal personality, or again is the notion of private property. All these legal developments which has happened across the jurisdiction, in a way, it is a decade years of a struggle of the indigenous community. So my first point is that when I talk about legal personality of the rivers, there is a scholastic viewpoint which talks about expansion of legal personality, and this legal personality of the rivers as an organic growth of that concept of legal personality. But the legal developments across the jurisdiction do not point to that. The legal developments, what it points is the articulation of an indigenous view of life. If we analyze the indigenous view of life, what we see is not just a living in harmony with nature, but a living whereby human beings are just a mere part of the nature. So just like any other natural entity which is part of the ecosystem, we are also just a part of it. So that, the indigenous concept of legal personality is deeply rooted in a respect for ecology. So that is what you can see in the legal developments which actually has taken place in New Zealand and the various Latin American or South American countries. But whereas if I come to the Indian, the judgment, the prominent one being the Ganga and Glaciers judgment. See, while we were very, very forthcoming in terms of incorporating or taking the precedence of the New Zealand judgment, we, I think, fail to understand the socio-cultural perspective on which the New Zealand or the Colombia legal decisions developed. Why? Because if you analyze this Ganga judgment, the Ganga judgment and Glaciers judgment says that the Ganga river should be considered exactly like a human being with all the rights and duties which attach to it. See, that becomes, extremely problematic when we say that the river Ganga can have all the rights and duties which is akin to a human beings. See, the problem is that when we look at the indigenous way of life, their concept of living is not founded on the concept of rights and duties. See, in the indigenous way of life is that you accept that the river or a forest is a part of that existence. So it is trusted on that foundation of respect for that. It is not founded on the concept of a rights and duties. So the moment the Ganga judgment says that this particular river Ganga will have all the rights and duties equivalent to a human being, you have also attached a duty to the river Ganga. That becomes practically and legally becomes problematic. How can the river Ganga be sued for maybe over flooding or other kinds of associated rights? So that becomes one of the problematic. Then definitely there are religious connotations which has been brought into. The river Ganga is worshipped by the Hindus. So in order to protect that faith of the society, we need to proclaim the river Ganga as a legal personality. That particular rationality is very deeply problematic because Ganga is a national river. And yes, religion or morality can be a great impetus in terms of promoting a respect for nature or to consider that, okay, yes, based on that, we have an obligation towards protection of an environment. But no judicial process can say that in order to protect a certain faith, we need to declare legal personality. So religious rationality cannot be invoked to say that, yes, a particular river has to be declared as a legal personality. So especially in a secular framework like India, this can be a problematic. So when you link it in the context of a commodification, see, in my view, the legal personality of the rivers can symbolically achieve certain things. But unless and until we have a very, very concrete mechanism of implementation, like for instance, in the Ganga and Glaciers judgment, we have declared or we have identified government or governmental officers as the persons who will be the voice. So this is not different from the current establishment. But if you look at the legal personality of the rivers from an indigenous way of life, that administration or what is identified as the legal personality of the rivers is a completely different. So my conclusion or a summarization is that while we oppose the idea of commodification, we can't think that legal personality of the rivers can be an answer to the commodification. I think the answer has to be lies in promoting an idea of life where we respect the ecology. I think that's where. So I won't say that an indigenous way of life has to be promoted, but their belief in the system that the ecosystem, we are part of a, that human beings are not supreme to the ecology or ecosystem. We are just part of that natural being. So what we as a legal system has is to develop a deep respect for ecology. And I think, that way we can counter the narrative or a movement for commodification. Thank you.
Thank you, ma'am, for this insightful and thought-provoking session. And now, does anyone have any questions? You can actually unmute yourself and ask, or you can drop in the chat box.
Veena, can I just ask you? Yesterday also the same topic came up even in Dr. Sujit Kudan's presentation. See, it will be challenging this notion, the notion of private property. That's it's very convincing. But is it also going to challenge the human rights discourse? I ask you in the context of the wildlife first judgment, which had actually said that nature comes first, and in that context, it might act counterproductive to the indigenous community. Say, how would you explain the wildlife first case if we treat the nature attribute legal personality to nature or rivers? That's a thing which was bothering me since yesterday.
Yeah, thank you, Sudha. I think see, there is, I think the legal system has a particular phases, right? So when a certain legal initiative develops, I think everybody tries to find only a positive aspect, because anthropocentrism, we all identify that there is a serious problem. So we think, okay, this is the mechanism to overcome anthropocentrism. But before initiating any legal steps in terms of recognizing a legal personality of the nature, I think real serious thought in terms of the dialogue and discourse, and much into what it entails, what could be the consequences. See, if I take the New Zealand and other countries, they have done, after decades of struggle, maybe a 30 or 40 years of negotiations and development. So the most of the aspects of that, the various, what exactly the rights of private people, what is the legal personality of the rivers, what exactly, whether it is equal to human rights. Like if I take the New Zealand Wanganui River, specifically they have identified 2 or 3 rights of the rivers, like right to exist, right to flow, right to flourish. But if I look at the Ganga judgment has not explained what will be the rights of the river. See, that is very, very important, even when you're looking at it as a part of the expansion of the legal personality. See, if I take a corporation's right, it's very clear that what exactly is the rights of corporation. So whenever we are talking about the legal personality of the animals, ecosystem, so you cannot word it in a general aspects. What exactly the rights of rivers, mountains, or a forest definitely has to be specified. And that do not come all of a sudden. I think that has to be the result of a discourse, and it cannot be maybe the universal, it may be a local specific, regional specific, that has to be there. And second, it's a misnomer to understand that when the Wanganui River has been declared as a legal personality, the complete negation of private property. No. If we look at the particular statute which is declared the legal personality of the Wanganui, they have protected and preserved certain private rights which is in existence, whether it is in terms of the ownership or sharing, or it is in terms of certain mining or a certain commercial interest has been also preserved. So it is not that the moment there is a legal personality of the rivers comes into existence, there is a completely negation of private property, because the existing private property need to be balanced. But this has all come as a result of a series of the decades of negotiations. And more importantly, the way the the river system is administered, it is a combination of indigenous, the representation from the indigenous communities, and there is the government and other representatives. But the problem aspect is that, and if you look at the Ganga judgment, it has merely said that river Ganga has all the rights and duties equivalent to a human being, which is problematic and which can be counterproductive itself. And I think, Sudha, you raised a very, very important point in terms of the indigenous right. Yes, exactly. See, just because of New Zealand, the indigenous communities, in order to rectify the historical injustice, they have identified or declared this legal personality. That does not mean that all the indigenous community in the world is in favor of it. Because as you rightly said, the indigenous way of life is not founded on the concept of rights. So in a way, we are forcing our legal notion of rights and duties on the indigenous communities to say that in order to protect your right, there is no other mechanism but to declare a certain ecosystem or a natural entity as a legal person. So that is why even many of the indigenous communities, they are very, very wary of this terminology of the rights. And unless and until that their concern is taken, I think that can definitely be very, very counterproductive, because their idea of respect for nature is just founded on the coexistence where human beings are also part of the nature. I hope that suffice.
Yes, ma'am. Thank you, ma'am. And anyone have any questions? I think we don't have any more questions, ma'am. So we'll proceed with the paper presentations. Right now we have 9 paper presentations in this session.
Shadi, I have one question.
Yeah, sorry. You can ask, ma'am.
Ma'am, what is the liability of corporates when they pollute the water or river? What are the liabilities? Whether the criminal liabilities there, or there is any particular provision which says the criminal liability of corporates when they pollute water in international perspective and also in Indian?
See, in international perspective, if I speak, that is one area where the liability or responsibility to the transnational corporation, that's an unaccounted area. So internationally, there are business and human rights and other soft law developments has taken place, but not a per se legal conventions or anything. So most of these activities of corporations are to be governed by the domestic law. See, I do not know exactly the provisions. I'm not been dealing with the domestic law for a long, long time, but I'm sure that the Water Act and Air Act has provisions, and which specifically applicable to the industrial establishments. They have a certain norms in terms of pollution, and if a company violates that, certain steps can be taken, which is inclusive of both the civil and criminal also can be. Even the IPCC provisions can also be brought in. So definitely there are civil and criminal, and the Indian judiciary has brought in many principles, including the polluter pays principles, and under which also a punitive even punishments, a penalty can be imposed. There are various judgments from the NGT which has awarded punitive punishment, which is also in the nature of a criminal. So both civil and criminal domestically, I think there is no dearth of legal measures.
Thank you, ma'am. And in this session, Delhi Chandana ma'am, who is the assistant professor at Reva University, is the moderator for this session, ma'am. And the rapporteur for this is Riya Hundal. And Delhi Chandana ma'am, you can. Thank you, ma'am.
Thank you. At the outset, I would like to wish everyone a very happy Teachers' Day. Thank you for giving me this opportunity. I'm eternally thankful to Sudha ma'am and Viola Kiran for giving me this opportunity. It's indeed an honor to be moderating a session conducted by DSNEDU, because I was a first batch student of DSNEDU. Thank you, everyone. So the first, we have 11 presentations. in this session. The first presenter is Mr. Naveen Sisla, and his topic of his paper is Right to Water, to Rights of Water, a walk towards personhood of water bodies. I think this would be a great continuation to our initial opening lecture. Mr. Naveen, over to you. Please note, all the speakers, please note that you will have 8 minutes of speaking time, and due to paucity of time, we would strictly adhere to the guidelines. Mr. Naveen, are you here?
Mr. Naveen, can you speak up? We can't hear you. You're unmuted yourself, but we can't hear you. You mute yourself again. Hello, can you speak up, Mr. Naveen? Is it with me or is it with everybody? We can't hear you, Mr. Naveen.
I
I
think
guess
we'll
the
have
audio is not connected, sir.
Yes. I think we can have Mr. Naveen's paper later on. Ms. Nandini Garg and Ms. Sania Agarwal, are you present?
Yeah, we are here.
Good afternoon, ma'am. Your paper is titled The Study of Water Economics and Various Legal Implications Involved in its Sustainability, Governance, Development, and Management. This is indeed a very vast topic. I understand that you would need quite some time to present your paper, but unfortunately, due to paucity of time, we can only give you 8 minutes. Please strictly adhere to the time. Thank you, ma'am. Over to you.
Yeah, sure.
Ma'am, I'll be needing the rights to share my presentation.
Yes, sir. Yes, ma'am.
Do I have to make Sanya or Nandini? Who will present, ma'am? I didn't get it.
Sanya.
Okay. You can share, ma'am. You got your privilege.
Thank you. So just a second. Good afternoon, everyone. I, Sania Agarwal, along with my co-author Nandini Garg, are here to present our paper on the study of water economics and various legal implications involved in its sustainability, governance, development, and management. Water availability is central to human life existence. The multidisciplinary linkages of water resources necessitate the redressal of legal, social, environmental, political, and economic concerns arising out of it. The right to water and sanitation is universally regarded as a human right. Rapid urbanization, population growth, industrial development, and economic growth have posed significant water sustainability challenges. According to the estimates, by 2050, nearly 45% of the worldwide GDP, 52% of the world's population, and 40% of global grain production would be at danger if the natural environment continues to be deteriorated and unsustainable strains are placed on global water supplies. The poor and disadvantaged will be disproportionately affected, increasing already growing disparities. There's a strong need to apply integrated frameworks to systematically analyze the water dynamics and various factors influencing it through long-term and short-term projects of restoration and development. Moving forward to the comparative analysis of water treatment and its economics, the study of water governance and planning mechanism is a part of a larger group of scholarly literature on sustainable governance of the nations worldwide. Policy and technology, when combined together, can further enhance and expand water security and supply by changing the demands and related efficiency of use. Here, we compare the models of Sweden and Norway. First, taking up the example of Sweden, in order to treat wastewater from urban and built-up regions around Sweden, wastewater treatment facilities with sewage networks and pumping stations have been developed. Earlier, the stormwater was not treated because people believed that it might cause flood, but now since they have realized that it is important to treat stormwater, especially from highways and congested areas, they have resumed working processes and treatments towards it. Next, we'd like just a second. Moving on to the example of Norway. Norway has a master plan of water resources. In order to achieve excellent water governance, integrated water resource management is essential. Norway has a long history of being cognizant of concerns connected to quantitative use of water courses dating back to the early days of hydropower production. The administration of water resources in Norway is separated into 3 levels: national, regional, and local. Norway has developed a robust public administration to tackle these problems. Municipalities create water resource plans for water supply and quality, land use, sewage, water pollution, and fisheries as a part of their regular planning work at the local levels. County planning is being utilized as a tool for river and lake management at regional levels. Moving on, I'd like to talk about the water economics and its management in India. With 1/6 of the world population and 1/25 of the world water resources, India witnesses nearly 80% of all diseases and 1/3 of deaths due to the consumption of polluted and contaminated water. This has necessitated the enactment of various water laws through national water policies of 1987 and 2002. In order to curb the abuse of power and authority to control water resources by various state governments, the Supreme Court of India in 1997 established the public trust doctrine in India by categorizing flowing water as public trust progressive reform. This was incomplete as the Supreme Court did not provide guidelines with regard to protection of public interest, and thus the state governments could continue to define public interest at their discretion will while planning water resource projects. Looking up at the MC Mehta versus Kamal Nath and others case 1997, the judgment adopted the public trust doctrine for the first time in the legal history of India and required the private motel owner to pay for the degradation caused by their motel development on the ecology of river Bias. The judgment cited the case of National Audubon Society versus Superior Court that propelled restoration of water flows to Mono Lake in California in 1993 to support the decision. Looking up at the Sustainable Development Goal 6 and its targets, the creation of SDG 6 to ensure access to sustainable management of water and sanitation for everyone indicates a growing focus on water and sanitation concerns on global political agenda. According to Agenda 2030, rising inequality, natural resource depletion, environmental degradation, and climate change are among the greatest concerns of our time. SDG 6 consists of 8 universally relevant and ambitious global objectives. However, based on national realities, capacities, degrees of development, and objectives, each government must determine how to incorporate them into national planning processes, programs, and strategies. Moving on to the policy formulation and implementation, it is critical to provide accurate information about the hazards connected with the notion and how they are being addressed. The necessity to reuse treated wastewater must also be conveyed to consumers in order to earn their trust. In most cases, psychological obstacles such as the health hazards associated with recycled water and ambiguity about the quality and usage of treated wastewater are caused by a lack of information on the part of consumers and a lack of faith in public institutions. To conclude, I'd like to say that in India, energy generation through water has been a traditional function of national and state level government agencies. There is a need to incorporate mechanisms where grievances can be voiced upon and contested upon unfair resource reallocation. The benefits arising out of overuse of water results in dilution of water laws and environmental regulations. The institutions need to balance economic benefits of water sustainability and development with the benefits associated with other existing commercial uses in order to minimize socio-economic environmental impacts. Laws and policies provide incentives towards water development and its sustainable use. Lastly, strict guidelines need to be enacted by the court in order to give clear directions to carry out their obligations. Thank you.
Thank you, Ms. Nandini. Thank you, Ms. Sania. And I'm thankful to you for sticking to the timeline. Next, we would once again
Hello.
like to call Mr. Naveen Sisla.
Hello, ma'am.
Yes,
Am I audible?
yes, Mr. Naveen, you're audible.
Thank you so much, ma'am. And I would like to apologize for the technical issue which has been caused from my side. So, as you guys know, the topic of my research paper is Right to Water to Right of Water, a walk towards personhood of water bodies. So, I would like to start by stating a fact that the other day I was watching a movie with the name Deepwater Horizon, and that's when I realized that, water is our life's matter and matrix. And it's one of the most important resources which we should protect and preserve. So before going or before diving into the topic, I would like to mention certain facts which would help you to understand the issue which we have with the water bodies right now. So we almost have 326 million cubic miles of global water bodies, out of which only 3%, or to be more precise, around 2.78% of drinking water which is available. And we have water, I mean, only, yeah, 2.78% of fresh water. And every time we, spend around 1.36 crore a day to convert salt water into fresh water or drinkable water. So by these facts, the position is really clear that water is limited and we are supposed to protect it. So I believe that reality isn't a linear pathway. Every decision which we take changes the course of reality. So with that possibility keeping in our mind, we tried to change the reality by protecting the nature, by working towards the goal of sustainable development. And today we are now at a stage that we are using more humane approach by hearing the voice of nature and by providing it the idea. Get into details like what exactly right to water means, and the judgments like Subhash Kumar versus State of Bihar, and how exactly we as individual try to make sure that water is protected in each and every aspect. As ma'am already summarize the whole idea, the whole concept of personhood of water bodies, I just want to mention few points. In the year 2017, as the New Zealand came up with a legislation to grant personhood to water bodies. Well, the idea is like really what do you call it? I mean, the idea is really fascinating to me because, in that particular legislation, they came up with certain rights which are to be assigned to water bodies by considering these water bodies as person. So these rights are, right not to be harmed, right not to be polluted, right to be nurtured, right to maintain the quality of this water. And what we did, we as India, there were two cases which were filed in court of law, that is Salim versus State of Uttarakhand and Lalit Miglani versus State of Uttarakhand. It so happened that we tried to pick up the same idea which was originated in New Zealand and tried to, what do you call it, try to implement the same in India. I feel the idea, the concept is really good, and I believe that now by by attaching a personhood to a water body, we are trying to protect it from outside dementors. But I don't think so that much of a thought is given, because a generalized statement, as ma'am has already mentioned, a generalized statement had been given that water would be having all the rights and duties of a person. But how exactly, what are those rights, and how exactly these rights are to be provided? Who are gonna take care of these rights, whether if they are violated, has not been mentioned. If we go back and see and check the New Zealand legislation, custodians, the idea of custodians were developed, and these custodians' duty is to take care of these water bodies, and if in case any violation occurs, they can go and approach the court of law and they can take appropriate actions. But the same concept had been not been given in the judgment, the Ganga judgment, the famous Ganga judgment. It was so stated that water boards, I mean, the initial reaction of the court was water boards aren't working properly, but the same water boards have been given the role of custodians in this because of this particular case, which I mean, which from my side is being a bit unreasonable. And what I feel is these water boards which are being established has to be restructured, and a more positive way of or positive approach should be taken to protect the water bodies which we have. So these are my thoughts about what exactly, like how exactly personhood should be attached to water bodies. I understand that uh, by attaching personhood or by bringing a legislation, that particular idea isn't enough. We as an individual should be more responsible to make sure that these laws are adhered to. So I would just want to conclude by saying we, the people of India, should and will solemnly resolve to constitute a much better and preserved from the scary dementors, that is greed and capitalism, and be more ecologically responsible. So on that note, I would like to conclude my paper.
Thank you, Mr. Naveen. Our next paper is by Mr. Satya Prakash and Ms. Lakshmi Anita.
Am I audible?
Yes, ma'am, you are audible.
Good afternoon to everyone. My name is Lakshmi Anita. Before going to start my paper presentation, I wish all the honorable teachers a very happy Teachers' Day. Now, going to the topic, water management and the law, the way forward. First of all, what is meant by water management? Water management is the control and the movement of water resources to minimize damage to life and property and to maximize efficient beneficial use. Good water management of dams and levees reduces the risk of harm due to flooding. The main purpose of the water law is it defines and identifies the legal rights and obligations tied to water use and provides the prescriptive parameters for resource development and management. When coming to the question why water management is important, it helps determine future irrigation expectations. Water management is the management of water resources under set policies and regulations. Water, once an abundant natural resource, is becoming a more valuable commodity due to droughts and overuse. When coming to the abstract, since water happens to be a scarce resource, its sharing as well as distribution requires a regulatory framework have been brought about through not only written laws but also traditionally and customary practices. In terms of statutory development, irrigation laws constitute historically the most developed part of water laws. Statutory water law also includes a number of pre and post independence enactments in various areas. These include law of embankments, drinking water supply, irrigation, floods, water conservation, river and water pollution, rehabilitation of abuse, and persons, fisheries. Article 21 of the Indian Constitution guarantees to all the persons of fundamental right to life, and Supreme Court observed that water is a gift of nature. Human hand cannot be pretended to convert this bounty into a curse or oppression. The primary use of which water is to be drinking, it would be making nature to force people who live on the bank of a river to remain thirsty. Water law in India states under the introduction about this topic, air and water are the precious gifts of nature, not only for the humans but also for the animals as well as plants world. All living creatures have the right to the environment which they need to share for survival. Water remains scarce national resource which demands on it increasing on account for the ever-growing population. Water laws under Section 17(1)(a) of the Water Act, the function of the state board shall be to plan comprehensive program for the prevention, control, and abandonment of the pollution of streams and wells of the state and secure execution thereof. Their provision indicate the anxiety of the legislature to maintain quality of water for which standards are required to be laid down. The Constitution and the statute provision clearly brings the to protect and water as part of the environment and to ensure supply of safe water for the public. This obligation of a positive nature requires to state, including the area development authorities and the local bodies, not only to shield the people's common heritage of lakes, ponds, reservoirs, and streams, but to prevent them from becoming extinct and to rejuvenate and preserve them quantitative harvesting rainwater and qualitative by prescribing and enforcing standards of the such water. Ample legislation on these is the power to prevent and prevent abuse exist. When coming to the municipality of principles and rules, universal depiction of municipality of principles and rules and instruments did not lead to a overall workable framework. So law making of utilization of water resources was being done from 1873. There does not have efficient competent statutory authority for formulating the water policy. More than 90% of the laws enacted for the utilization of water resources are found to be state level legislations. At the time of enactment of these laws, the environment factors happens to be not so seriously taken. Utilization of water was a priority area rather than conservation of water. Moreover, the sharing of river waters in India between the states that constitutes the republic since given rise to long legal battles. Among the early disputes regarding the sharing of the Narmada River waters was the one excited between four states of Gujarat, Madhya Pradesh, and Maharashtra, Rajasthan. Cooperative federalism. Generally, although definite trend towards cooperative federalism and integrated approach exists in view of large dimension of the problem, its network needs to be widened and its full
Apologies, ma'am.
potential
Can you
to be
please conclude your paper? Apologies, ma'am. Can you please conclude your paper?
I was logging in mobile. I can't show my paper.
Apologies, ma'am. Kindly conclude your
Need for avoiding.
presentation.
Could you please repeat it again?
Yes, ma'am. Due to paucity of time, can you please conclude your presentation soon?
Sure. In 2 minutes, I will conclude. Need for avoiding fighting and politicizing water issues. Lastly, it needs to be an agrees that there would be no meaning to the right to life without right to the water. As to the other related fundamental rights of health, shelter, environment, etc. Gandhian philosophy stressed nature has been provided everything for need, not for the greed. When going to conclude about this topic, as per the foregoing, it can be concluded that water, air, and land are essential elements of nature, which are not only requirements for proper living all the creatures, including humans, animals, and plants, but also it constitutes important ingredient for the life and hence is need to be shared depending upon actual requirements. There are numerous laws as per the judgments in the course of implying this sharing principle, but this water being including in the state subject list, fighting and politicizing of issues has been common. Instead, the states needs to adopt give and take policy so as to share as per requirements through negotiations as well as continued deliberations, which breaks the ice among its rivals. Thank you for giving this valuable opportunity to represent myself in a great platform. Thank you everyone.
Thank you, ma'am. Our next speaker is Mr. Shailesh Dhyani. Mr. Shailesh Dhyani, are you here? Mr. Shailesh?
Mr. Shailesh, can you unmute yourself? Mr. Shailesh?
We'll move to the next presentation. We'll take Mr. Shailesh's presentation later. Our next presentation is by Mr. Ashwin Joshi and Jissa Matthew. Are you here, sir?
Yes, ma'am. Am I audible, ma'am?
Yes,
Yes, sir, you're audible.
Good afternoon, everyone. Our paper is titled "The Commodification, Privatization, and Water Market." Water has been and will be one of the most important factors for all forms since the first life that appeared in the water on the earth and other species evolved from it. In some organisms, up to 90% of their body weight comes up from water. Up to 60% of the human adult body is water. An adult male needs 3 liters per day, while an adult female needs 2.2 liters per day to maintain our body functions. As we all knew, water is essential for our day-to-day life. It regulates the temperature of our body through sweating and respiration. It helps to digest food through saliva and to transport the metabolized food into the bloodstream. It helps to lubricate the joints. Water is also helps in waste management of the body by urination. Water covers 71% of the Earth's surface, out of which 97% of the Earth's water is salty water, which is present in ocean. 3% of the Earth water is fresh water, and it is used by all the life forms on the Earth. However, out of these 0.5% is fresh water, which is accessible. According to UN Water Development Report of 2021, 2 billion people currently do not have access to safe drinking water. Water is treated as the oil of the 21st century. Our present study focuses on the effect of commodification, privatization, and marketing of water. Access to safe drinking water and sanitation has been part of the human rights by United Nations Resolution 64/292 dated 28 July 2010. Article 1.1 states that the human right to water is indispensable for leading a life in human dignity. It is prerequisite for the realization of the other human rights. It is defined the right to water as the right to everyone to sufficient, safe, acceptable, physically accessible, and affordable water for personal and domestic uses. The resolution calls upon states and international organizations to provide financial resources, help in capacity building and technology transfer to help countries, in particular developing countries, to provide safe, clean, accessible, and affordable drinking water and sanitation to all. According to WHO, 50 to 100 liters of water needed per person per day to ensure that most basic need. This water should be safe, therefore free from microorganisms, chemical substances, and radiological hazard that constitute a threat to a person's health. According to WHO, the water source has to be within 1,000 meters of the home, and collection time should not exceed 30 minutes. Water and water facilities and services must be affordable for all. The UNDP suggests that water cost should not exceed 3% of the household income. What is commodification of water? Commodification of water means water being sold as a product or commodity. For time immemorial, water has been a public good. By commodification of water, it mainly metamorphoses fresh water from public good into a tradable commodity. With commodification of water, water is traded like gold and oil, like any other commodity. In commodification of water, an investment bank buys the water right of a region, which include all rivers and water resources in that region. Anything which is scarce has economic value. Water is also scarce and has an immense economic value. The fear of water scarcity and need to be effectively manage water resources by assigning economic value to water resources are the starting point of privatization. The privatization of water services refers to transfer of ownership or business of water services from government to private sector. This includes services such as operation and maintenance of water services, bill collection, metering, and revenue collection. Growing population increase the demand for quality water. Water infrastructure needs huge investment. Many underdeveloped and developing countries are unable to find resources for water infrastructure project. Most developed countries were capitalist countries and votaries of privatization of public good. This paved way for commodification of water. Commodification of water have both positive as well as negative impact. One of the positive aspect of commodification and privatization is the economic use of water. Psychologically, people tend to use economically whatever they pay for it and tend to waste if anything is available free. Commodification provides opportunity for private entrepreneurs to make investment in water projects and to make profit out of it. If private investment will help in making quality water available in the market, more and more private investment in water project will ensure competition in the market, which will help in rationalization of water rationalization of price of water. Commodification of water started with the privatization of water utilities in some part of the world with an ultimate goal to privatize the water itself. Commodification and privatization of water also has negative impact. It also poses threat to the availability of safe drinking water to majority of the population. Commodification and privatization of water will lead to water being sold as a product at market prices. Since water is scarce and demand exceeds supply, the price of water will be maximum if left to market pricing. As we all know, profit maximization is the primary objective of any private corporation. Commodification and privatization of water will benefit only big private corporation at the cost of general public, and this will adversely affect the right to water. Commodification and privatization of water may also lead to over exploitation of water like any other natural resource. There is also a threat of monopolization and cartelization of resources. 2000 years before Indus Valley civilization had flourished in the banks of the river Saraswati. The Saraswati river is not existing now as a river. Its traces are only available. The Saraswati river may have dried up due to the changes in the climate or change of course of the river. The extinction of river might have contributed to the decline and end of Indus Valley civilization. Water scarcity, if continued unchecked, might result in similar situation in future. India is facing water scarcity. India has 18% of the world's population, but only 4% of the global water resources. According to NITI Aayog report of 2018, 600 million people, that is almost half of the population of the country, faces acute water shortage. This is mainly due to
Apologies, Mr. Ashwin. Apologies,
Yes, ma'am.
Mr. Ashwin. Please conclude your
Oh,
presentation.
okay, ma'am. 1 minute. This is mainly due to shortage in rainfall in many parts of the country, and on account of climate change, lack of shortage facility and rainwater and over-exploitation of groundwater for agriculture. Privatization of water in India started in late 1990s with the technical assistance with the international finance institutions such as World Bank and Asian Development Bank. Now let me discuss about the impact of water privatization, commodification, privatization of water adversely impact the poor. Because of these, people around the world always resisted in privatization in water sector. Now let me conclude. Now let me conclude by saying that water is so important to all our lives, and we all expect to get access to the water whenever we turn on the tap or any other time we need it. Commodification of water puts value on the water resources. With commodification of water, it changes to a product from which being big companies try to maximize their profit. Water privatization in India started in 1990s. Indian constitution categorically recognized water as a positive human right, and judiciary has interpreted right to water as a fundamental right, a facet of right to life and dignity. Well protected under ambit of Article 21, increased interest in the water as a commodity shows its importance. Recent development had raised concerns that water will become a marketable commodity like gold and oil, but with proper regulation, communities can work together to develop a regulated water market with prioritized local users and benefit us all. While water market cannot address the underlying causes that create water security, they can aid the more effective allocation of resources and the monitoring of water market prices by investors. Thank you, ma'am.
Thank you, Mr. Ashwin. Our next presenter is Ms. Avantika Shukla. Are you here, Ms. Avantika?
Yes, Miss Chandana. Can you hear me?
Yes, we can hear you.
Yeah. I hope I'm both audible and visible. Okay, so may I go ahead?
Yes, ma'am. You're audible as well as visible. Please go ahead.
So, a very good afternoon to the esteemed dignitaries, my fellow presenters, and to everybody listening. Firstly, I'm very grateful for this opportunity. I'm Avantika Shukla from New Law College, Bharati Vidyapeeth, Pune, and I'll be presenting my views on the topic of trisection of climate change, water scarcity, conservation measures. So before I dwell onto this topic, there is a famous quote by Benjamin Franklin that goes on to say that when the well is dry, we know the worth of water. And these lines are true, and they set the tone for the entire discussion, because we know the times that we are living in, but we are reluctant to understand that water is a scarce resource and that it will run out. But we are not, in a position to make ourselves or educate ourselves about this thing. Again, I would like to reflect upon the lines of Robert Allen, author, wherein he goes on to say that water is one of the most basic of all needs. We cannot live for more than a few days without it. And yet, most people take water for granted. We waste water needlessly and don't realize that clean water is a very limited resource. More than 1 billion people around the world have no access to safe, clean drinking water. And over 2.5 billion do not have adequate sanitation service. And over 2 million people die each year because of unsafe water. And most of them are children. So we can only understand the gravity of the entire situation through these lines. And India is not standing at a different pedestal, because in India itself, 600 million people face acute water crisis. 7% of the total India's population has no access to water. And as per the recent UNICEF report, 74% of the natural disasters between 2001 and 2018 were water related. On top of it, there is a certain change that is happening, which is a climate change, and we are all in a state of denial about that issue as well. So through this paper, I would like to touch upon the various issues where India stands currently and how climate change is affecting all these things, and at last, what all we can do as a collective and also as an individual to save water as a resource. So starting with the first thing, that why Indian water crisis is very grave and in a deplorable state of affairs. Nearly 48.3% of the households, both in the rural and in the urban, do not have exclusive access to drinking water. 1/4 of the household access it through a public unrestricted source that accounts to 23.6% as per the data of the National Sample Survey 2018 report. And then, as per the recent report of Niti Aayog, more than 21% of the Indian cities are, forecasted that they will run out of water. Then India is rated at a high risk in the climate change vulnerability index, with major Indian cities are projected to experience high number of consecutive drought days with less rainfall in the near future. Then to add to everything, we have climate change. Now, one thing we must recognize about climate change is that it is not a national or a territorial issue. It is an international or a global phenomenon. So if the Californian fires are happening, or if the forest fires are happening in the Australia, it's not that they are not going to affect us. We are all connected in this earth. And that is something which, again, we are reluctant to understand. And there are so many players, the industrial players, the rapid urbanization, all these things are, acting as a catalyst to the climate change as a whole. But the biggest problem before us is that we are not ready to understand or educate ourselves of this problem of climate change, which in fact is acting as a major obstacle in dealing with the issue of climate change. And it can be proved to be lethal if we don't stop now, because there is a reason why there is a Himachal glacial melt. There is a reason why the rivers are drying up so fast. There is a reason that we are experiencing such extreme temperatures. And there is a reason why there is an early onset of monsoon. There are flash floods. And that reason is climate change. So even if we cannot change things at a global level, we can still make an effort to stop, or at least, curb climate change at a national level. But having said all those things, they are not in our hands. We can at least talk about the things that there are in our hand. And let me give you some of the measures. They are not very scientific measures. They are day-to-life measures which we can implement at an individual level also. So we have repeatedly heard about the judgments that have been laid down by the Supreme Court in Bandhua Mukti Morcha's case, wherein the Supreme Court has emphasized upon the points that right to water is a fundamental right. And everybody should have an access to equal, safe water. Again, in the later case of AP Pollution Board versus Professor M.V. Naidu, the Supreme Court reiterated the same point, saying that water is an essential commodity and that everybody should have clean access to water. But my question over here is, shouldn't there be a positive obligation upon the state as well to provide an access to the water and equal access to water? Because there has been a complete imbalance when we see in terms of access of water between the rural and the urban households, between the upper strata and the lower strata of the society. between the clean drinking water and the unhygienic conditions of water that are being provided to the economically downtrodden sections of the people. And it is because of this reason that there has been no stop at the unsustainable urbanization, the rapid urbanization that is happening, because all these industries are in fact contaminating the fresh water. And on top of it, they are not paying their taxes. They are contaminating the groundwater, they are contaminating the freshwater resources, and they are corrupting the individuals, and they are just getting off by doing everything. Then the second issue that we can really deal with is the rejuvenation of the groundwater. Now, we all are aware of the fact that India is an agro-based economy. That means majority of our farmers depend upon the kind of produce, and not only our farmers, but the country as whole depends upon the produce that we exported to the outer world. But if the groundwater is not there, then the farmers cannot produce all that they can with the crops. And if they cannot do that, the economy will definitely collapse. And it is because of this reason that 42% of the Indian masses have been drought prone, according to the report of the India Spend. So through measures like rainwater harvesting, and not only like rainwater harvesting should be as a measure, but it should be strictly implemented. It should be made an obligation of each and every individual that we cannot waste the rainwater that is a fresh water. And we can indeed help the economy rise. Then lastly is, it might seem as an abstract measure, but still I think that there should be penalties.
Apologies, Ms. Avantika. Kindly conclude your presentation.
Sure, Ms. Chandana. So I'll be concluding my presentation is that we need to, manage these distribution sources, and there is a common human folly. We do not respect the things that we are gifted with. And it's high time that we start doing it and not enter into this cyclic loop of misery, this apocalyptic situation where nobody has access to water. And in fact, we understand the worth of water before the wells dry up, according to the Benjamin Franklin quote. That's all from my side. Thank you very much.
Thank you, Ms. Avantika. Our next presenters are Ms. Swati Panda and Mr. Animesh Jha. Are you present?
Yes, ma'am.
Hello. Yes, ma'am.
Okay. Over to you, sir. Over to you,
Who's
ma'am.
going to present?
Thank you.
Who should be made the presenter?
It is me, sir, Swati Panda.
Go ahead, ma'am.
Thank you so much, sir. Kindly confirm if the PPT is visible.
Yes,
It
ma'am.
is
The
visible. Go
PPT
ahead.
is visible.
Thank you. Respected chair and moderators, dear panelists, I'm Swati Panda, and I, along with my co-author, Mr. Animesh Shah, will be today we'll be presenting our paper and a presentation on it on the topic of decentralizing water rules and regulations in India. So kindly allow me to provide you a brief overview of our work. So as has been time and again reiterated over the course of this webinar, that water is the key to human survival. And not just that, it is also human livelihoods are dependent on it. So over a period of time, it has become overused. And now water is a scarce and an unequally distributed resource. But its demand is something which is increasing at an incessant rate each and every day. So today, water has become a dear resource, which explains the why we are having so many disputes surrounding it. So secondly, water subject has been dealt in the Indian Constitution in the 7th schedule, where it is spread across 8 entries across the 3 lists. So the power to make laws on this subject has been divided between the union and the state, and resides mainly with the states, which is one of the many other reasons why there is an increase in disputes between these entities over the subject of water. Now, to resolve these disputes, the United Nations and several other international organizations made some treaties. Even India had its own laws and rules and regulations. But we know for a matter of fact that it has not proved 100% efficient. We are still facing some issues. So where and how is the existing legal framework lacking? Why has it become outdated? This is something we'll be discussing in our presentation today, and we'll also discuss in brief the hot debate we are having nowadays on the topic of right to water, and we'll primarily focus on the question of how decentralizing the water rules and adopting an economic outlook, an efficient cost recovery mechanism may work as an effective solution to our current issues. So, firstly, let us see the existing legal framework in India that exists when it comes to water laws. So, the current on your screen, you can see some of the acts and legislations which are presently in work in the subject of water laws, and the chronology of the same: the Northern India Canal and Drainage Act 1873, and one of the most important acts, that is Interstate Water Disputes Act 1956 and more. So firstly, Northern India Canal and Drainage Act of 1873. This is a British regime law, one of the oldest on water law, and its main objective was to assert the government's right to use water for the broader public purposes, to even impose charges on it. So in the case of Jwalaram versus State of Pepsu, the Supreme Court observed that the intention of this law is to clearly obtain payment for water used, and the fact that the rates prescribed may be high cannot alter this position. And in the second case, that is State of Punjab versus Modern Cultivators Ladwa, the Supreme Court observed that by making laws on this subject, the government is merely exercising its statutory authority under this act. So the next legislation we have is the Madhya Pradesh Irrigation Act of 1931. Now, this act provided for the establishment of irrigation panchayats. Now, I won't delve into the functioning of the irrigation, the functioning of the IPs in detail, because due to the paucity of time, but IPs were quite efficient back then, as they worked on the grassroots levels to resolve the problems and to actually help regulate and manage the water resources. But as you can see, this law was made back in 1931. That was like 9 decades ago. That was a time when India had a village culture. But today the circumstances are different. There are technology has become so advanced, the problems have become advanced, and we are living in modern times. So if in today's time, this act has become old and it is redundant, but if it is to be made efficient again, this concept of irrigation panchayat needs an organizational restructuring to meet the demands of the modern times. Moving on to the next act that we have, the Interstate Water Disputes Act of 1956. This is one of the most important acts when it comes to water disputes. So Article 262 of the Indian Constitution, it provides for the barring of the Supreme Court and other courts' jurisdiction over the river water disputes. And this act made provisions for the same. It made provisions for establishing tribunals for resolving such disputes. However, we have seen in multiple cases that the intervention of the Supreme Court is still present. Even in the case of State of Karnataka versus State of Tamil Nadu and others, the Supreme Court itself observed that the tribunals should exercise its powers and courts should not interfere with it, but it comes with an exception. Now, this, we have no clarity upon it. Even the Supreme Court is skeptical about it. So this is proving to be a bottleneck. It is actually causing a lack of clarity, is actually causing a delay in resolving of such disputes. This is a weakness in this act that the authors have observed. And next we have the River Boards Act of 1956. Now this act provided for the establishment of river boards on the request of the state governments, which would then advise the state governments over the variety of subjects on the matter of water. But the problem with this act is that no matter how good it was on paper, but it just remained in paper. It was never brought to use in practice, and boards were technically completely non-existent in the whole regulatory framework. Next we have is the Water Prevention and Control of Pollution Act of 1974. This act had provisions for making establishing standards and making regulations for pollution control of the water bodies, and it also made mandatory its permission for establishing industries if those industries were to release industrial effluents into the water. And Section 42 of this act provides for penalties and punishments in case these provisions are not followed. But what is to be noted here is that these punishments range from imprisonment up to 3 months to fine of rupees 10,000. Now, in the present scenario, where if we see today, even the smallest of industrial units have like crores of turnover per year. So having such a negligible or such small punishments for violation of these provisions, it don't provide enough of an incentives for these entities to follow or abide by these rules. Next, now that we have seen what are the faults in the existing legal system, let me address the debate, the hot debate we are having nowadays on the right to water versus the private ownership of the water bodies or the commodification of water. So Supreme Court has time and again, it has established in the case of Subhash Kumar versus State of Bihar, and also in the very important case of Narmada Bachao Andolan versus Union of India, that right to water is a part of right to life. And if Article 21, if right to life is to be served, then it can only be done by providing source of water where there is none. But in the existing legal framework, water is scarce. Even though if it's a human right or not, it is scarce. And if we don't regulate it properly, if we don't put proper mechanisms into place, we won't be able to give this human right to everybody. So for this, the authors are suggesting a few ideas of theirs. The first one being having an economic outlook towards the usage of water, and not having such an economic perspective towards the usage.
Apologies, Ms. Swati. Kindly conclude your presentation soon.
Yes, ma'am. May I have like 2 minutes more, and I will just conclude it, if that's all right?
Yes, ma'am. Yes,
Thank you so
please
much, ma'am.
conclude
Thank you.
soon.
Thank you so much, ma'am. Thank you. So here I would just briefly explain 2 to 3 ideas that we have. First, having non-conventional methods towards water bodies, that is having interbasin water transfers like we had in Cane Betwa River linking projects and all. Secondly, the transfer of rights from owners to users, which resulted in the setting up of water users associations, and which my co-author Animesh Shah will deal with shortly, and also in the introduction of trade in entitlements, obviously with proper rules and regulations in place. Also, the next very important idea here is having a cost recovery of water resources. So basically, you are to pay for what you use, be it you are a domestic user or you are an industrial user or an agricultural user. That would be the first step towards water conservation. So I would like to invite Mr. Animesh to kindly take over the later part of the presentation. He'll just take 2 minutes. Animesh, kindly take over, please.
Thank you, Swati. Good afternoon, panel. Swati, kindly switch on to the next slide.
Sure.
Yes, thank you. So the state legislation that exists in India. So the state legislation that exists in Indian context are very wide. So we are just sticking to the concept of WUA, which means Water Users Association. So firstly, the concept of WUA came in the Andhra Pradesh Farmers Management of Irrigation System Act in 1991 firstly, and then it continued on to the another state legislation. Firstly, coming to the Madhya Pradesh Sichai Prabandhan ke Krishikon ki Bhagidari Adhiniyam 1999, as the name itself suggests the participation of farmers in the irrigation system. Now coming to the Rajasthan Farmers Participation in Management of Irrigation Systems Act, then Odisha Pani Panchayat Act in 2002, and now coming to the evolved part of the WUA, which came in the Maharashtra Management of Irrigation Systems by Farmers Act 2005. The principle remained same in all the acts, but the changes that came in the Maharashtra Act was that while keeping the principle same, the change that came is the equal distribution of water and environment-friendly use of utilizing the water resources. That was the change that was brought in the Maharashtra Act. And now coming to the concept of WUA and the working under the supervision of Irrigation Department, the WUA president will carry out the whole working of WUA will be supervised by the president itself. And the act was framed for decentralizing the powers of regulation from state government to other water regulating authorities. And the framework was designated in a way that they will just regulate the whole regions which they are designated to rule over or to supervise over. Now coming to the recommendation or observation that the authors have. Swati, can you switch on to the next slide? Yeah, thank you. So firstly, the introduction of Swajal Dhara scheme in 2002 is the first proper management and planning of the water resources, that how the water should be looked upon, was brought in the 2002 year. And the principle that led in that year was that you will get only those services for which you are willing to pay. Here it means the water resources that are being given to the regulatory authorities will be paid upon, and the cost recovery of theirs will be the duty of the water regulatory authorities. Now coming to the second recommendation that the authors have is that legislative intervention in groundwater conservation. Groundwater conservation and cost recovery are the two methods which authors consider as the best way for water conservation. The act that came in 2002, which says that Kerala Government Water Control and Regulation Act, laid down some provisions for that, but it is not complete, and there are some limitations that exist in that statute. Now, the distribution of power between Panchayat and WUA is the another recommendation that author suggests to the regulatory authorities, that WUA is overburdened with the powers that they are given with. They will maintain the charges. They will also look into the institutional structure. They will look into the infrastructure structure that will overburden the WUA, and it can lead to the fall down of the whole association. Now coming to the international perspective of the water law management. For broader conception of water law, international convention and treaties play a major role. You can't look at the water and say that this is our national treasury. The water has to be looked into the legal perspective as well. And for that, we have to look through the global eye. Now, all these recommendations and suggestions, it would be an adequate starting point for achieving the right to water and the concept of public confidence in the entire country. Swati, can you switch on to the last slide? Now, coming to the concluding note of the research paper. Firstly, the existing laws were inappropriate to ensure access to water for all. The new laws came, but still it is insufficient. The reforms that came are very narrow, and we are still lagging behind the legislative reforms that are there in the status quo. Now, ongoing improvements to the water law can help to improve the management of water, but they are unable to address the human rights, social, environmental, and health issues of water on a conceptual level. So the commodification of the water resources can be dealt with in this perspective. Well, we will look into holistic view of the perspective that we have on the water law resources. Now, while concluding the whole research paper, the authors are saying that there is an urgent need for revamping and transforming public systems, which is the need of our. Here comes the end of the whole research paper. The presenters are open to questions. If you have any questions, feel free to ask.
Thank you, Mr. Animesh. We'll have question and answer session at the end
I have a question. So,
yes, sir.
So what is in which any state of India, any particular state have any laws which says that criminal provision for the violation of those who are making water pollution, especially not in terms of from the part of citizen, from the corporate or industry or factory. There any particular state have any particular act which explains the criminal provisions?
As my co-author explained, the Water Law Prevention and Pollution Act, it lays down the penalties for that. There is no state framework for that. There is a national framework. National government advises state government on those matters, and under that act, the state government regulates those rules. So there are provisions for which we can prohibit the corporates and other entities to not exploit the natural resources. So yes, it is present in the framework, but still it lags behind where it should be. There is existence of penalties, there is an existence of punishment under the whole legal framework in India. Any other questions?
Thank you, Mr. Shaji. Are there any other questions? This is a gentle reminder. All of you, please post your questions in the chat box. And you can also write as to whom you are directing the question to. Thank you, Mr. Animesh. Thank you, Ms. Swati. I would once again call Mr. Shailesh Dhyani. Mr. Shailesh Dhyani, are you here? Mr. Shailesh?
Ma'am, I can't find him in the list, but let's proceed to the next person, ma'am.
Yes, sir. I would now like to call Ms. Shubhakirti. Is she here? Shubhakirti? She's present in the list. However, I guess there is a technical problem. Ms. Shubhakirti?
Ma'am, proceed to the next one. I can find her, but she's not responding. I don't know what's maybe a technical error. I have made her a presenter also. So let's go to the next person.
Yes, sir. I would now like to call upon Kirti Kumar. Mr.
Yes,
Kirti
ma'am.
Kumar, we can hear you, sir. Do you have a PowerPoint presentation?
Yes, ma'am. I want to share my screen.
Yes, sir.
Kirti Kumar, I had made you a presenter.
Over to you, sir.
Ma'am, is my screen visible?
Yes, sir. Your screen is visible.
My PPT?
Yes, sir. Your PPT is visible.
Okay, thank you, ma'am. Good afternoon, everyone. My topic of presentation is water is a gift of Mother Nature, don't exploit it. In my presentation, I have discussed about the common yet the most problematic issue faced by the water bodies, which we know as water pollution. So looking at the water as a source of life, it can be termed as a fluid, which is very much vital for all the mortal forms of life. And without it, life is not possible on this planet. Hence being an indispensable part of life, water has numerous uses in current times. Those uses can be mainly categorized into two parts, direct purposes and indirect purposes. Direct purposes can be referred as a process of availing water by human beings directly for their body needs and personal hygiene, such as uh, drinking water. Drinking water is very much essential because it's help in regulating body temperature. It also helps in creating saliva inside the mouth, which further helps in breaking down the food particles and it assists in chewing process. Adequate amount of water is important for proper urination and proper excretion process. Water is also considered as the biggest aid in digestion. Water is very much responsible for improving the blood circulation as well as oxygen circulation. Other than these direct purposes, there are other direct purposes which are feeding livestock and watering plants, etc. So I'm moving to the indirect processes. Indirect processes are termed as the process of using water for the purpose of agriculture, industry production, and medical purpose. So here the question arises is what is agriculture water, industrial water, as well as medical water? Agriculture water is a type of water which is used for producing grains, fruits, vegetables, etc. And the industrial water are termed as the water which is used for manufacturing and producing the industrial products, as well as medical water is a water used in hospitals and healthcare facilities. Uh, Here are some statistics for agriculture, medical, and industrial production. which is done every year in our nation. According to our data, yielding of food grains was about 305.44 million tons, and country index of industrial production was about 126.6 in this year. So just by looking at the numbers, anyone can compare the amount of water required for producing such heavy amounts of agriculture and industrial products. As well as in Bureau of Indian Standards for Hospital, it was stated that hospital having more than 100 beds consume about 450 liters of water per day. So it can be observed that water usage is equally important for direct purposes and indirect purposes. So further, I'm moving to the topic of water sources. Water sources are the bodies where the water comes from. I'm going to talk about the natural water sources here. So the first natural water source is groundwater. Groundwater source is present below the surface of earth or soil, and it can be obtained from aquifers, tube wells, or wells. Second natural water source is surface water. The surface water source is found above the earth's surface, which includes the rivers, lakes, ponds, wetlands, etc. Other water source is rainwater. Rainwater source is the purest source of fresh water, and it comes from sky, as we all know. And the fourth water source is ocean water. Ocean water source can be also be termed as sea water, which is very salty in taste. And according to our data, 97% of all the water present on Earth is ocean water. It contains salt, minerals, and gases in dissolved form, so it is unfit for the human use. And the fifth water source is glaciers. It is a kind of fresh water source in a frozen form. It can be termed as a reservoir of water. So now moving to the topic of water pollution, uh, I'm going to talk about the major problem related to it. So, as we all know, it is a human behavior that when any resources is present in a sufficient amount, it is exploited by us, all human beings. So, it is same with the condition of water. And water pollution is a process of contamination of water bodies, and water can be polluted by two different major sources: point sources as well as non-point sources. Point sources are the sources which are directly from which the pollution is done directly from a single source, and which is identifiable in nature. Like suppose a single chemical factory, or a single industrial plant, or any single person throwing a plastic bottle in ocean, which is identified, can be termed as point sources. As well as the non-point sources can be elucidated as a scattered source of pollution. It includes the agriculture runoff and the urban runoff, like sewage water and water include with insecticide and pesticides. Now moving to the causes of water pollution, there are several causes and I have explained some of them. The first cause is sewage water. The water which are used by us are drained into the other water sources, or which contaminate the major water source. Second causes of water pollution is plastic waste. Plastic bottle, polythenes, and other plastic products which are non-biodegradable in nature are dumped in oceans as well as other surface water sources, which contaminate the water source. Other causes of water pollution is agriculture runoff. The pesticides and the insecticides and other chemical used for growing crops are drained into the water sources termed as agriculture runoff, which is very poisonous in nature, and it contaminates the water sources. Other causes of industry causes is industrial waste. Waste like industrial residue, chemical, lead, mercury, etc., which is poisonous in nature, and it can harm the aquatic animals as well as the water sources. The last causes which I have explained is oil spill. Oil which is transferred on a ship to one country to another can be spilled by any leakage or something, and it leads to the contamination and effect on marine lives. After the causes of water pollution, it causes several externalities along it. It comes with several externalities along with it. Externalities can be referred as negative costs. So here I have explained three externalities, which is environmental cost, economic cost, and social cost. Environmental cost can be described as as the cost incurred in protecting in protecting the marine life which is disturbed by the process of pollution. And economic cost are the cost includes the cost which affects the fishing activities, beach management of beaches, as well as other protection of water sources. And social cost is a major externalities, and the last one in which the in this cost the major concern is to protect public health. Hence, the diseased person in the society takes the medical facility as well as the hospital facility, which incurs some cost termed as a social cost. Now, moving to the remedies of pollution as well as wastage, here are some remedies which I have explained. The first remedies is wastewater treatment. The water which is already wasted can be treated in various ways and can be reused by us. And it will kind of curtail the problem of scarcity of water. Second remedies is prohibition on plastic products. So according to my idea, government should ban on should impose a proper ban on plastic products, and so because it's a non-biodegradable substance, and it is affecting the water sources, mainly the ocean water source, it in a very bad manner. The third remedies is denitrification. It is a process in which nitrates are turned into nitrogen gas, which prevent the nitrates from seeping into soil, and hence it does not mix with groundwater and prevent pollution. The fourth remedies is green agriculture. The agriculture which uses less pesticides or the natural or the natural fertilizers are termed as green agriculture. The fertilizers as well as the pesticides are less chemical, have less chemical contains, and hence it helps in removing pollution. The fifth remedies is modern irrigation techniques for curtailing the problem of water wastage. Like the irrigation technique used in current time waste so much water. So modern irrigation technique like a sprinkle system or drip irrigation system can help the conservation can help in conservation of water. And the last remedies is water conservation and sustainable use. Water can be what we should conserve water, and it can be conserved in many ways, like limited usage of water in our homes as well as rainwater harvesting, etc. And water should be conserved and used in a sustainable manner so that our upcoming generation should get the equal benefit of this source as we are getting. Uh, Now, moving towards the conclusion, in in this presentation, I've discussed about the major problem of water sources, and also try to explain about the water as a vital source of life for human, plants, as well as animals. So, as we all can see that without water, it is impossible for anyone to live, and hence the water should be conserved and protected from pollution and contamination. It is our prime duty of every individual to protect it. Otherwise, the future there will become a scarcity of water. The problem related to the water scarcity, such as drought or acid rain or climate change or change in the rainfall pattern or melting in glaciers are included in this in this problem. And as since water sources are depleting and it is getting polluted, hence alongside the method of conserving and protecting waters, the government, international bodies, and the citizens should focus on the idea of sustainable development. This idea will lead the society to use these resources in a proper and adequate manner with the goal of conserving it for their upcoming children and grandchildren. It is everyone's responsibility to protect our mother nature and Mother Earth and make a better future for our upcoming generation. Thank you for your patient hearing.
Thank you, Mr. Kirti Kumar. I would now like to call upon Mr. Shailesh Dhyani. Mr. Shailesh Dhyani, are you here? Mr. Shailesh Dhyani? I would now call upon Ms. Subha Kirti. Ms. Subha Kirti, are you here, Ms. Subha Kirti?
Yes, I'm here.
Okay. Ma'am, over to you. Do you have a PPT to share?
Yeah, I do have a PPT to share. The problem here is that we don't have electricity, so it's working on my phone data. I don't think
Okay,
yeah,
okay.
there will be a turbulence. I can share the email the PPT to you, and I can look up and explain it right now. Give my presentation
Yes,
right now.
ma'am. That would be okay. Can you please send your PPT across to us?
Yes, I'm sending.
Ma'am, you got the presenter access. You can present.
Okay, I'll just present it and send it to you later. My paper is mostly talking about human rights, water as human rights. So basically, when we're talking about water, primarily, it's not a difficult thing for anybody to understand and appreciate the utility of water. How in various presenters itself have talked about how the element of earth is present in water, how we are dependent on the needs are to be dependent on water, how human beings have in present scenario used water everywhere. If we see the evolution of Homo sapiens, we see that mostly the civilizations have grown around where water bodies have been there. And over a period, over 2 billion people of our planet have faced water scarcity at different places due to different natural and man-made causes. When we say there are natural causes and man-made causes, we'll see that all these natural causes are somewhere or the other influenced by the man-made issues itself. Humans have time and again withdrawn water and utilized it from the ground source, from the open sources, and have not really taken care of how it will be beneficial for the future generation, how it is to be preserved, how it is to be managed. How if we see how China as in Asia has grown, we'll see that wetlands were utilized for farming, and these wetlands after utilization have never been given a place where they can replenish the groundwater. So over a period the irrigation facilities have grown. Water per se for mankind is a finite resource on a global scale. This is something we all have to acknowledge in our daily day-to-day basis. We all know about the facts, what is the limit of water that we have. We understand the utility of it. But since we do not in our day-to-day activities consciously see the importance of water as a resource and limit as to utility of utilization of water, there have been instances because of this that the commercialization of water has started, where this resource which is uh, available in abundance is now being commercialized, it is being sold to people, it is being utilized, where this was something that was to be inherited by us as humans as our human rights. When we're talking about human rights, we need to understand what is human right. Human right is something that no state was supposed to give it to us. We were born with these inherent rights, but ultimately because of the growth of civilization, how human beings formed, various cultures evolved, we because of political inflictions and financial footholds of various bodies, have come down to drafting various laws. Now when we're talking about drafting various laws, the basic law that we will talk about is the General Command 15, where we are talking about right to water, that comes under the United Nations Committee on Economic, Social and Cultural Rights, that was drafted in 2002, where the watershed movement talked about the rights of water movement, and right to water was basically discussed here. It talked about that every individual was entitled for sufficient, safe, acceptable, physically accessible, and affordable water for personal and domestic use. Now, when we are dividing this entire statement, if we read word to word, we'll understand what is the meaning of sufficient use, safe use, acceptable use, physically accessible use, what is affordable for people. We have to understand all these parameters individually and utilize water. Following these guidelines, United Nations Development Program UNDP also talked about human rights in 2006, where human development report was made. uh, I'll send the PPT over where the reference has been taken about the United Nations Development Program, where we talked about beyond scarcity, how power is to be utilized, how global water crisis is to be met, how what are the duties of individuals in our day-to-day use. Now, when we talk about water as a right, human beings' right, we all know about the Hoffeldian table talking about the correlation of a right and duty. So when we talk about right to water, which is largely in India also understood, taken under constitution under right to life. Even UDHR in particularly Article 3 talks about right to life and covers right to water under it. And when you're talking about right to life, right to water, which is to be safeguarded by various institutions, we'll talk about how what kind of disasters will occur if we do not have a counter part where we're just talking about rights of taking water. But what are the liabilities? What are the obligations that we as individuals have to follow, where our actions are positive and justifiable? Where we are having a claim that we should have water, access to water, we also have a duty, daily duty, as to how we have to understand the whole process of precipitation, how location of water is important, how storage of water is important, how if we do not take care of these resources in the right way, the political and economic exploitment of us is going to happen. It is we by and large that are going to be affected. So as a community, as individuals, we have to understand the requirement of water laws, what is to be managed, how things are to be managed, so that we can enjoy it as a right. And how, what are the obligations if there we are taking it as a right, what is our duty, how we have to manage these resources, how water laws and regulations are to be discussed on a global perspective, on the national perspective, how when we are talking earlier, various speakers have spoken about water as a property where ownership rights have come. So when we're talking about all public water sources that are present, when we're talking about surface water, we're talking about groundwater, how these are to be withdrawn, how these are to be utilized, what boards, what commissions, what countries, various countries, how they are forming institutions to manage these water resources. That is very important. In the rural and urban communities, we have seen that over a period there have been conflicts because of water. There have been conflicts in China, inland disputes in 1999, between Ethiopia and Kenya around 2006. Even in India, when we're talking about Kashmir issue, around 2002, there have been villages which have burnt each other's property down, fighting over water rights to cultivate. Because basically, all these things, water is a major resource for agriculture. When we are per se talking about agricultural rights, there also the right to water is a very, very important part. Then we come down to how courts and various institutions have played roles, like the state owned enterprises, which we mention as SOEs, or private public partnerships that have come up, which manage the water resources from rivers and ponds, how water is to be extracted to bring out various commercial products. It's not just when we are talking about privatization or commercialization of water, we are not just talking about bottling of water and utilizing it. There are various products from soft drinks to edible things, where whatever is to be, from tanneries, every industry is utilizing water in one form or the another. So when we are talking about these utilization of water, we have to see how state owned enterprises and public private partnerships and private institutions are managing and regulating the use, where they can be protecting the environment per se, avoiding pollution and preventing pollution per se. Exploitation of water is not just water pollution or water prevention of water pollution. We also have to see the magnanimity at which the water is to be utilized. While utilizing water in one part where water is available in abundance, we also have to keep in mind that there is a huge part of the civilization which is in a place where the water is scarce. How will they, as we're talking about water as human rights, the basic human right to life requires water for sustenance. So when we are talking about our rights, we have to keep in mind those people also who will require the residual water. We cannot be selfish in our attitude. There have been various disciplines, history, engineering disciplines, which has dominated in the field of water management till now. Laws per se, though we have been drafting there have been various Brahmaputra dispute, various disputes that.
Apologies, ma'am. Ms. Shubha, can you please
Yeah.
conclude your presentation?
Yeah, sure, please. While we're talking about all these water economics and water study, how price elasticity has also affected domestic water, we'll also understand how and when we'll follow the stages where how community rights, individual rights are to be met, focus over the political implication of water management, and behavioral models should be coming up. As a conclusion, I would like to say that we have to understand the acute water deficiencies that are there present encountered by the poor, and the consequential corruption and violence that follows, and how it is to be made susceptible in a way where people can utilize it not just as a commodity but as a right and as a resource. That's it. Thank you so much. Hello.
Thank you, Ms. Shubha. I would now like to call upon Mr. Shailesh. Mr. Shailesh Dhyani, are you present? Mr. Shailesh Dhyani?
Ma'am,
Mr. Shailesh Dhyani
kindly
is.
proceed. Mr. Shailesh is not available here.
Yes, sir. Yes, sir. I would like to thank all the presenters on behalf of DSNLU, and I would also like to thank Sudha ma'am and Biola sir for giving me this opportunity. Uh, there have been a wide array of presentations today in this particular session, and understandably, the debate of privatizing water is not just about privatizing and non-privatizing water, but it is also about recognizing community rights with respect to water. And all the presentations have been very thought-provoking. Thank you very much once again for giving me this opportunity. Thank you, Subha ma'am. Thank you, Baila sir. And I would like to wish everyone a very happy Teachers' Day once again.
Yeah.
Yes, ma'am.
Dr. Stelina might want to
Yes, ma'am. Yes, ma'am.
sum up things or say a few things about the presentation.
No, thank you, Sudha. I wish, I can actually spend a little time because it's 2:30, as everyone said, I was actually observing the presentations, the topics, they ranged from the issue of privatization to legal personality of the rivers, and they have highlighted the other issues connected with the pollutions and many. So in nutshell, I can say that I think all the presentations, focused on various aspects of the water rights, which has highlighted also many issues and needs to be addressed. So with regard to this entire topic of the sessions, see, I don't think that it is easy to conclude in support of a privatization or a commodifications. And we can't perhaps take an absolutely opposition positions with regard to commodification. As I think somebody pointed out that already existing, whether it is in terms of groundwater law, whether it is the industrial uses, if I take the WTO, the entire mineral water bottle. So the water as an item has become tradable, and yes, there is an economical value attached to it. But if it is the commodification is an imperative result, as a legal community, I think we need to look into what could be the measures in terms of protecting the human rights, the community rights, and also considering the social fault lines on which the society operates. And water is, I think, one area where the social fault lines are very, very clearly visible, whether it is in terms of race, gender, caste. So there has to be an effort on the part of the civil society, the public, and the legal community to look into this aspect, along with a very, very deep respect for ecology and nature. So this is how I mean, I can sum up. Thank you. Thank you so much for the wonderful seminar which you organized in the last 2 days.
Yes, Chandana and Shravani, I think you can conclude, both of you. Wrap it up.
Yes, ma'am. Thank you everyone for this wonderful opportunity. And the presentations were very varied, and we have had different perspectives with respect to commercialization and also recognizing community rights. And we've also discussed several areas of how water is being misused and how effective management can be a very useful tool for all of us. Thank you. Thank you. I thank all the presenters once again on behalf of DSNLU. And I also thank Sudha ma'am and Viola sir for this wonderful opportunity. Thank you, Stelina ma'am. It was an honor listening to your lecture today. Thank you very much. Now over to Shravani.
Thank you, ma'am. Thank you, Dr. Stelina Jolly, ma'am, Delhi Chandana, ma'am, Riya Hundal, and all the presenters and participants of this session. Now we'll go on with technical session 6. Once again, thank you everyone for participating in this session. Thank you.
Thank you so much, and thank you so much.
I will take over.
Yeah. No, I think Shreya, you should take over. Shreya?
Am I audible, ma'am?
Yes.
A very good afternoon to one and all. I hope we're all ready for the last and final session of this national webinar on water management laws, life, livelihood, and environment. I, Shreya Nair, your session manager, will welcome you to the technical session 6. And the pertinent issue or the theme of this session is water pollution externalities, legal instruments, and remedies, featuring a keynote address by our guest of honor, Neeri Jambal ma'am. I'll just take a minute to discuss a brief note on the theme before we commence the session. British poet W.H. Auden once noted that thousands have lived without love, not one without water. Yet while we all know water is crucial for life, we trash it anyway. Some 80% of the world's wastewater is dumped largely untreated back into the environment, polluting rivers, lakes, and oceans. Everyone knows what water pollution is. As a citizen of a developing country in the clutches of an ever-growing population, the problem in itself is way too familiar. Water pollution levels in developing countries remain significantly higher than in the developed world. While such pollution is often a byproduct of economic activity, it also imparts a health burden on the population. We understand that insufficient collection and evaluation of data continue to make it difficult to grasp the intensity and the scope of deteriorating water quality. It is also hopeful that organizations like UN Water and others are trying to help bridge the gap between water quality, the inclusive green economy, and wider development issues. I certainly hope that combining such a global issue with local understanding will provide public and private sector decision makers with a practical tool to deliver on all water related commitments for the 2030 agenda. With this understanding and an inclination to learn, I hope Nidhi ma'am has joined.
I think Nidhi got disconnected and she's restarting her laptop. So she'll log in just 5 minutes, she said. Couple of.
Sushmita వచ్చేసిందా? Mute చేసుకోండి.
Hello, Zen. Hello, Sushmita.
Hello, ma'am. Ma'am, I'll just join in 1 minute.
Yeah. We'll have parallel sessions. So we'll give you the details and send the link in a while. I think Nidhi is joining anytime. She'll be here.
Yes, ma'am.
Hi, good afternoon. Can you hear me?
Hi, good afternoon, Sudha ma'am and Payala sir. Can you hear me?
Sushmita, we are waiting for Nidhi, but just
No, it's a very small
One,
application, ma'am.
she has some technical issues.
All right.
Okay,
Yes.
it
I was
is
just checking. Yeah. Okay. Thank you, ma'am.
Okay, ma'am.
I think we should continue with our session. Nidhi will join. We can take the paper presentations perhaps. Start with the paper presentation, Sushmita.
And James, sir.
And Zain.
Yes, ma'am.
So,
List,
first ఎవరు ఉన్నారు? నాకు list లేదు.
Shreya దగ్గర ఉంది.
Shreya, you have the list, na? Just read out the.
Yes, ma'am.
Open the list.
So I think we can start now. With the paper presentations, is Mr. Dr. Vedpal ready?
Dr. Vedpal Singh Deswal.
I think you can take over, Shreya, Sushmita.
You'll have one. Yeah, please accept.
I hope Sushmita ma'am also has the list.
Okay.
Yes, I do have the list of a parallel session.
Shreya, can you introduce Zain and Sushmita once?
Yes, ma'am. So our moderator for the technical session 6 on water pollution, externalities, legal instruments, and remedies is Mr. Zain Saleh. And I also will invite Sushmita Patel, ma'am, to take over the conducting of the session.
I think Nidhi has joined. Right. We can start with her presentation.
Nidhi ma'am మాట్లాడమను ఒకసారి. Unmute చేసుకోవాలి. Unmute.
Nidhi?
Yes,
I think you can start.
నేను తినేసి వస్తాను లోపల.
It is an honor for me to introduce our guest of honor for the keynote address of technical session 6, Ms. Nidhi Jamwal, ma'am. Just to introduce her, with over 20 years of experience in environment and development journalism, Nidhi Jamwal, ma'am, has worked for 12 years with Down to Earth, India's only science and environment fortnight. Thereafter, she freelanced with several publications that include The Wire, Scroll.in, DNA, Indian Climate Dialogue, Bullet Square. At present, she is the Deputy Managing Editor with Gaon Connection, India's biggest rural communication and insights platform. She won the IHCAP CMS Environment Journalist Award 2019 under special category for reporting on climate change in the Indian Himalayan region. She was also selected as the Media Fellow for Wash Matters 2019 Media Fellowship by WaterAid India, and also for the Earth Journalism Network Bay of Bengal Stories Grant 2019. She completed DST SDC Media Fellowship 2018 for reporting on climate change impacts and adaptation in the Indian Himalayan region. She has also completed IWMI Media Fellowship on informing change in the Indus Basin in 2018. She won the first prize internet category in All India Environmental Journalism Competition 2015. Ma'am, I cordially invite you to deliver the keynote address.
Thank you so much. Thank you. And I'm sorry for the delay that has happened. Actually, I'm using some other laptop and there's some problem, and predictably there's some problem with the camera also. So please just put up with the thing. I had actually shared my presentation. Can you put it up? So I think we can immediately go on to the presentation. So I was actually, first of all, thanks for inviting me to speak with you all. And I think I'm the odd person out because possibly I'm the only journalist. who's speaking in this 2 days webinar. So I think my experiences will come from from the field as an environment journalist who's been looking at water issue. I think a lot of discussion, I was looking at the schedule also, is around water as a right, or the conflicts, or water pollution, water management. But what I will like to do is that I would like all of us to zoom out a bit from the issues that we have been looking at on this while, and look at the larger picture of water in the country, the water cycle, and what's happening to our water resources. Because eventually, whether we are looking at water as a right, whether we are looking at growing conflicts around water, we're looking at increasing droughts or floods, water management, legal framework for water in the country, everything depends on how much water is available to us and how much water will remain available to us in the coming decades. So if we can just put up the presentation.
ఒకసారి నిధి గారి ప్రెజెంటేషన్ పెడతారా PPT. I think Nidhi, you just continue. I'll ask IT department Mahesh to.
Oh, okay. Okay, fine. You know why I thought I will, because why I wanted to look at the larger picture of what's happening to our water cycle, what's happening to water availability in the country, is because eventually, if you want to look at water pollution, if you're looking at want to look at groundwater levels going down, if you want to look at agriculture, and if you want to look at legal issues, insurance, urban floods, and what's happening to compensation, everything depends on when we are receiving this water and how we are receiving this water. And I think this is a perfect time also to talk about it, because we have the southwest monsoon season right now going on. As you all know, we have 4 months of monsoon season in the country, from June to September. This is the month of September. It is last month of monsoon, and majority of our rainfall happens during the monsoon season, and this is where our water comes from. Sudha, I would really want the presentation to be up, because I think that's the better way of.
Ma'am, before we start, I had a small question that
Yes,
I've been
please.
wanting to ask. Since you were talking about a bigger picture, I recently read that India, despite its size, has the highest water consumption in the world. So, are you of the opinion that, even though water pollution is a global problem, India would be the worst hit of the fallback that we have, or of the outcome?
Absolutely. I think the reason also we have very high water consumption is also because of the population density. And we are, an agrarian country, and we also export a lot of food produce, stuff like sugar. We export it in huge quantities. So what happens is, as we all understand, consumes a lot of sugarcane, consumes a lot of water, and a lot of our sugarcane crop is actually grown in drought-prone areas like Marathwada, where you already have dipping water levels till about 1,000-1,200 feet. There is no groundwater, and these are also arid regions. So the rainfall is also scanty. So absolutely, I think we can already feel the water stress is already available, is already there in the country. Right now, if you see a part of our country, okay, great, the presentation is there. So a part of our country is facing floods. A part of our country is facing droughts. Can we just go like one more slide up? And I'll Vita, address your question, because that's exactly what I want to really talk about also in my presentation. And the reason I want this up is because I feel people will be more focused when they look at some numbers, they look at some pictures, they look at some maps and graphs to make sense of what I'm trying to say.
Yes, ma'am. Please carry on. Thank you so much.
Yeah, thanks, Shreya. Can we go to the first slide, please? And just like make it, let's go to the one slide up. Can we please? Yeah. So okay. So can you make it full screen? I don't think this is full screen. Yeah, thank you. So, like I said, that I want to tell you the story of Indian monsoon. And why I want to talk about the story of Indian monsoon is because anything we talk about water management, legal issues around water is connected to our Indian monsoon, because that's the main source of our water. All the precipitation that happens during the monsoon period is which gives us water throughout the year. And right now, as I said, we are in the month of September. This is the last month of southwest monsoon, and we have a part of our country which is actually facing floods. If you look at Uttar Pradesh, if you look at Bihar, Assam, and some more northeastern states, they're actually facing a massive floods right now. Whereas on the other hand, if we see states like Rajasthan, Gujarat, Odisha has actually already declared a drought. So that's where the picture comes in, that Indian monsoon is basically, we have two sides of the same coin, and we always have this variability in the rainfall that we get in the country. Can we go to the next? So this is just basically telling us, now we look at that, we see that Odisha already has declared drought, whereas we have Bihar, which since the month of June is actually facing floods. So for the last 3 months, Bihar is facing floods. Of the 38 districts in Bihar, almost 16 or 17 districts are affected by floods. Millions of people are displaced there. While just like in Odisha, you have a major drought, all the districts in Odisha this year have received less than normal rainfall. Can you go to the next one? Yeah, similar scenario. We have Rajasthan again staring at a drought, Barmer and Jaisalmer, terrible condition, crop loss, fodder crisis, cattle crisis. At the same time, if we come to Uttar Pradesh, we have rivers like the Ghagra, which is also known as Sarus, actually just eroding villages, eroding lands at a large scale. Next, please. Okay, so when we talk of water, we look at water as for the whole country. But when we want to look at Indian monsoon, why I want to show this map to you is this basically tells us the rainfall that we've received in this southwest monsoon from 1st of June till yesterday, till 4th of September. Now, this is the district map of India, and as you can clearly see, the entire country, the variability of rainfall. Red and yellow dots are the areas, the districts which have received scanty rainfall, deficient rainfall, or large deficient rainfall. Green is where we've had normal rainfall, and the blue and the deep blue is where we've had excess and large excess rainfall. So as you can see, our country, there's so much of, the zones are so different. So even within the same state, you will have areas which have drought and areas which have floods. Can you go to the next one? Now, same thing, if you look at on the left-hand side, if you will see the slide, that's basically India has 36 meteorological subdivisions as per the IMD. Now, you will see some meteorological subdivisions in the country are actually headed for a drought. Like I said, Gujarat, Odisha, you can say even J&K and Punjab and Himachal. Whereas there are some if you see the peninsular India, you will see it has received excess rainfall. Same on the right is the state-wise rainfall we have received from 1st of June till yesterday, 4th of September. And as you can see, half the country has drought, half of it has floods, and half of it has about normal rainfall. Now, this again tells us the rainfall, how it has happened this year. And we already, we started, if you see the beginning of the graph, we received very heavy rainfall in the beginning, June. And then it kept going down, then it went again normal, and now we are almost a -9% deficient rainfall, which is on the borderline of a deficient rainfall, below normal rainfall in the country. Can we go forward? Next one, please. Yeah, again, what I've tried to do is let's look at region-wise. India is divided into 4 broad regions. Let's see what monsoon has done this year. East and Northeast region, you can see on the left-hand side, deficient rainfall. Northwest region, which is the Punjab and even Jammu Kashmir and Rajasthan, that's all Northwest region. Again, we've had deficient rainfall. Can we go to the next one? South Peninsular region. Again, that's the only region in the country this year which has actually received above normal rainfall, as you can see on the left side of the graph. And again, on the right side, central region, again, deficient rainfall. Can we go to the next one? So basically, this just shows the variability of monsoon rainfall that is there in our country. We must keep that in mind whenever we are looking at our water systems, whenever we're looking at management of water resources. Can we go to the next one? Great. So now what is this? This is basically the Indian Institute of Tropical Meteorology, which comes under IMD. They've actually looked at the monsoon rainfall from 1871 to 2017. And if you can see, naturally, our monsoon is highly variable. You would have years when we've had droughts. If you see the red lines falling down, those are all our drought years. If you see the blue lines going up, the axis, that is basically the flood years that we've had. So this is the kind of variability Indian monsoon already has between floods and drought. Now, what has happened is recently, last month, on 9th of August, the IPCC, the Intergovernmental Panel of Climate Change, has come out with a report. Can we go to the next one? Now, so this report is extremely important for us to understand, to keep in mind when you're talking of water management, water laws, regulatory framework, and everything, because this actually tells us what is the water scenario of the country in the coming decades, rather this century. So what this IPCC report, which is basically the 6th assessment report on climate change 2021, the physical science basis, this report is available on IPCC website. If anybody wants to download and read it, you can read it. It has details about how the climate change is going to impact India. So this report clearly tells us, and this report is prepared by the best scientists on climate in the world. So this report clearly tells us that the planet is going to warm by 1.5 degrees Celsius in all scenarios. So the planet, by the end of the century, it is going to warm up. Can we please go back? Yeah. So, and again, it tells us that even in the most ambitious emissions, which means that even if all the countries take all the precautions that they have been talking about in their, in their goals, we will still reach 1.5 degrees Celsius by 2030s. And this is going to again overshoot to 1.6 degrees Celsius, and possibly by the end of the year it will decline to 1.4 degrees Celsius. But this is if all the countries do what they need to do to control the carbon emissions. Now, what is the report? The IPCC report also tells us that India is going to see an increase in both the frequency and the severity of hot extremes. India is, the IPCC report has projected an increase in annual mean precipitation, which means that the annual precipitation, whether it is in the form of snow or rainfall, is going to increase in the coming decades. It's also projected that the monsoon rainfall in the country is going to increase. Can we go to the next one? Okay, now further, what IPCC report tells us about India is that the increase in rainfall will be more severe over southern parts of India. And if you remember just a couple of slides back, I had shown you those graphs of region wise, and we saw that all the 3 other regions in India have had below normal rainfall this year. However, Southern Peninsula is the only one which has had above normal rainfall. So IPCC report has also been telling us that the southern parts of the country is going to receive increased rainfall, severe increased rainfall. Similarly, the IPCC report also tells us that the southwest coast of the country is basically going to, the rainfall is going to increase by around 20%. And if the planet warms by 4 degrees Celsius, which is going to be really, really terrible, that India is going to see a 40% increase in precipitation annually. And also this was for India. Now, even for South Asia, the IPCC report tells us that the monsoon precipitation is going to increase across South Asia in mid and long term. It is also telling us that globally also severe heavy precipitation events, which now occur on an average 1 every 10 years, is going to double in the frequency because of climate change, because of global warming. And if we have 4 degrees Celsius temperature rise, then the jump of such extreme events, heavy precipitation, is going to be 2.7 times in 10-year period. So clearly, IPCC report is telling us that our entire water cycle is disrupted, and it is going to get worse in the coming decades, because we are going to receive extremely heavy precipitation over short periods of time. So what is going to happen, as we all see, is that there are days of almost 15 days when there is absolutely no rainfall even during the monsoon period, and suddenly for 2 or 3 days there is very, very heavy precipitation leading to floods. Like we've just seen earlier this week what happened in Delhi, those 2 days of extremely heavy rainfall in Delhi, and the Delhi was completely inundated. It was completely underwater. Can we go to the next one? Now, what are the concerns? You know, when we're looking at a changing climate and increased severe extreme weather events, the challenge for India is also that we have a very, very long coastline, as you know, from Gujarat going on till, you know, West Bengal. And so where then you see that this coastline means the researchers have been pointing out that across 6 Indian ports, which is the Chennai, Kochi, Kolkata, Mumbai, Surat, and Visakhapatnam, we have 28.6 million people. We have billions of people living along our coastline, which are going to get affected once you have global warming, which is already happening, which is leading to sea level rise, because oceans actually trap majority of the heat, which leads to thermal expansion, and which is leading to the sea level rise. And the IPCC report, which has just come out last month, is actually telling us, which is extremely worrying, is that Indian Ocean is warming at a higher rate than all the other global oceans. And our monsoon currents come from the Indian Oceans, and the Indian Ocean is warming much faster than the other oceans. And this is actually, the climate scientists are telling us, this is affecting our monsoon currents, because monsoon current depends on the difference in temperature between land and ocean. If the ocean becomes warmer, then the difference of temperature between the ocean and the land is not very high, which means the monsoon current will not be good, will reduce possibly rainfall during certain periods. So that's what, and the report also tells us that if we have a 1.5 degrees Celsius rise in the temperature, that means the sea temperature is also going to increase by 1 degree, which means thermal expansion, rising of sea levels. We are already seeing, like I live in Mumbai, and I'm already seeing areas which never used to get inundated along the coast are actually now going underwater. You have Marine Drive, the waves are actually getting too much inland. So that's becoming a major issue. Also, the report tells us that, you know, heat waves and humid stress is going to increase in the coming decades. Glacier runoff is initially going to increase because you have global warming. Our glaciers, Hindu Kush Himalayas has a lot of glaciers. It's known as the third pole because of the amount of water that is trapped here in forms of glaciers. The glaciers are melting. Initially, we will have a good flow of water from the glaciers, but after a few decades, this water from the glaciers is going to recede, which is going to affect our rivers also, and overall water security of the Indian subcontinent. Can we go to the next one?
Next slide, ma'am.
Yeah, next slide, please. Yeah, so I mean, I've been talking of all these things, and you all must be wondering why I'm talking of so much data and graphs and reports and so much of science behind it. The reason is for us to worry is because 60% of agriculture in India is rain-fed. There are some different figures. Somebody says 52%. So between 50 to 60% of our farming is still dependent on rainfall because we do not have surface water irrigation facilities. Also, our groundwater levels are dipping, which means a large number of our farmers who are small and marginal farmers do not have the resources to, pull out groundwater and irrigate their crops. So this is a huge worry for us if our monsoon rainfall patterns are changing and are going to change further, because as we all understand, crops need timely rainfall. In Odisha this year, a large number of paddy farmers have completely lost their crop because they could not transplant paddy because there was no rainfall. So these are all the challenges. Then how do you compensate them? Insurance, other legal issues come in. That's the reason, I mean, because you are all from the law background, I wanted to put out all these issues in front of you. Similarly, if we look at Bihar, like I said, Bihar is facing floods for the last 3 months. What does that mean for a state to deal with floods for 3 months where millions are displaced? How do you relocate them? How do you rehabilitate them? What happens to their livelihood? What happens to their farmlands, which are underwater for almost 3 months? I don't know how many more months they will take to go back to cropping on that land. Similarly, like most of us live in urban areas, urban floods have become such a big issue. Like I was talking of Delhi, Mumbai, you look at Hyderabad, you look at Bangalore. I mean, you rains for a couple of hours and our cities are completely inundated because our cities are not planned to handle the kind of rainfall that is happening now, which actually the scientists have been warning us for the last at least 3 decades. So again, if the cars in Mumbai are going to go underwater because of heavy rainfall, what happens to the legal instruments of maybe insurance of my cars or insurance of the property and everything? Similarly, if you go to the Himalayan region, because of the heavy rainfall this year, we have seen how the entire hills have actually collapsed in Uttarakhand and Himachal. So I think these are, and in such a scenario where our monsoon rainfall, which is naturally variable, is getting more, the variability is increasing manifold because of climate reasons. The water conflicts in the country are going to increase in a big way. So do we really have the regulatory mechanism? Do we have a legal mechanism to handle these water conflicts, which are going to really increase in the coming years? So I think at that, I would just like to end my presentation. Thank you.
Thank you so much, ma'am, for such an informative and thought-provoking note. The floor is open for any questions for ma'am. Okay, so with that, we can go forward with our
IPCC have to say about the Deccan Plateau region? Any specific reference to it?
Yes, that's what it said, that the southern peninsula, they have clearly said the rainfall is going to increase. That's one specific region they have pointed out will have increased rainfall of about 20% is what they have said. So that's the only region there. And my sense is that's because we have the Bay of Bengal on one side, we have the Arabian Sea on the other side, and we see the intensity of cyclones are also increasing, which again the IPCC report has pointed out. So all that actually leads to the increased rainfall in the southern peninsula of the country.
I'm talking about the central part, Rayalaseema and Vidarbha, those drought-prone regions.
So those
improve there. Then in that case.
No. So the IPCC has not specifically looked at this bit of central India where you are looking at Rayalaseema and Vidarbha, but there's another IITM report done by Dr. Roxy and all, which actually 2017 they had released this amazing study which pointed out, Sudha, that in this region rainfall is going to reduce, and it's already reducing. If you see this year's rainfall also, it is deficient. I think last year also it was deficient. So central India is where they have pointed out, the 2017 study of IITM has pointed out that the rainfall, monsoon rainfall is actually already declining.
Thank you.
Yeah, thanks.
Thank you, ma'am. Any other questions?
Ma'am, Ma'am, this is Zain, assistant
Yes.
professor in KIT School of Law.
Thank
Uh, Ma'am, I just wanted to know if, because when we talk about the two sides of the same coin and talking about monsoon flooding in one region and uh, droughts being there in the other regions, uh, ma'am, our government is taking a very different view of this and going in for river linking. Uh, how
Mhm.
can how can that be? Because it is going to have some drastic consequences. So how can we as lawyers uh, uh, work it out in courts and try and stop, because it's a policy decision.
Absolutely. Absolutely. So, I mean, how as lawyers you can find is something maybe Zen I cannot tell you. But yeah, what I can say is that a lot of these projects are coming up, which are big ticket project, and we think that creating these large infrastructure projects, we are going to solve our problems of whether it is of water and all. You know, you're talking of interlinking of rivers, and there is a major concern regarding the Gangetic dolphins. There are so many studies done by marine biologists who tell us that if we have this water corridor starting, then the Gangetic dolphins will possibly just disappear because they are blind and they use this, sonatic sound waves to communicate and to travel here and there. And if you have large ships and other movement in through the Ganges where they breed and they live, it's going to drastically affect their population and their growth. Unfortunately, the sad part is that the scientists have been giving us these signals for a very, very long time. But I have no qualm in saying that I think our governments have completely turned a blind eye towards whatever has been pointed out, and only the big projects, are seen as something which will absolve us of a problem, whereas we have a lot of smaller decentralized examples to tell us that this is what actually works. You can't be transferring water from one basin to the other because you're actually going to increase water conflicts. And it has happened. I've traveled to a lot of areas in Maharashtra where people build these bunds also for water harvesting. So there are villages downstream who've actually gone upstream and broken these bunds which upstream villagers had constructed to stop rainwater, to recharge their groundwater, because they felt that all the water is being stopped upstream and we are not getting anything downstream. So, there are huge challenges around these kind of big infrastructure projects. But unfortunately, I don't know, I mean, our authorities are just completely blind towards it.
Thank you, ma'am.
Thank you, sir. Thank you, ma'am. Now we shall proceed to the paper presentation. There will be a parallel session conducted, and the link for which will be shared in your group and in the chat. And for the main session, our moderator is Mr. Zain Saleh, sir, Assistant Professor, KIIT School of Law, Bhubaneswar. And I request all those in the main session to stay back and the others to go to the parallel session. And thank you, ma'am, once again for such an insightful.
Yeah. Thank you. Thank you so much. Yeah, thanks.
Then I think you can start.
I can start.
Yes.
Ma'am, just a second, ma'am.
Good
Just a second.
afternoon.
I'll share the link, ma'am. Just give me 1 minute.
Okay.
Ma'am, sorry for the delay. We just shared a link for the parallel session in the chat box. I had shared the list of participants who are supposed to present in the parallel session. So I request them to use this link, and it will be moderated by Sushmita Patel. Ma'am, kindly use the link to join that meeting, ma'am. I'll admit you there. And Jain sir, you can take over. Shreya, Sudha ma'am.
Yes, sir.
Yeah.
Then, sir, I request you to conduct the presentation session.
Good evening, everybody. Good evening, Sudha ma'am, Viola sir. Wish you all a very, very happy Teachers' Day. A fantastic topic regarding. I'm really sorry. 1 second, please. I'm sorry. A fantastic topic regarding the externalities and legal instruments, basically, and the remedies also. We heard from Nidhi ma'am how while there are a lot of problems, when the government finally acknowledges these problems, the solution is more dangerous than the problem itself in a lot of situations. So, talking about this, we have our first speaker, and I would like to request Dr. Vedpal Singh. Please start with the session. The first speaker.
Respected organizers.
Vedpal sir, your PPT is ready, sir.
Respected chairperson of the technical session, organizers, and dear speakers from various universities. Good evening, I am Dr. Vedpal Singh from Faculty of Law, Maharshi Danan University, Rohtak, Haryana. It's my fortune that today I am sitting before you virtually to speak on the topic and assessment of legislations in protection of wholesomeness of drinking water. There is a judgment in a very important case, that is S. Sachinananda Pandey versus State of West Bengal. As a teacher of law, it's my duty to begin with the sayings of law. What it said, you teach your children that the ground beneath their feet is the ashes of our grandfathers, so that they will respect the land. Tell your children that the earth is rich with the lives of our kin. Teach your children what we have taught our children, that the earth does not belong to man, man belongs to earth. This we know, all things are connected like the blood which unites one family. So in this case, the Justice Chinnappa Reddy wanted to convey a message that we must respect to natural resources, whether it is water, air, flora, and fauna. We must respect our Mother Earth, because whatever we are doing, learning, teaching, eating, we are everything, it is related to our Mother Earth. Objective of my paper is to understand what is health. Number two, what are the factors deteriorating the health of the citizens? Number three, what is the role of the government, NGOs, and educational institutions? Number four, what role Indian judiciary is playing to achieve health of the citizens? Right to water is not expressly granted either through the constitution or any other legislation. It is indeed an implied right asserted through a set of laws which confer a duty upon the state through its various agencies to prevent and control water pollution. Next slide, please. Kindly change the slide, please. So hence the right to clean water is guaranteed under Article 21 of the Constitution of India, and no one can be deprived of it. The same has been upheld by the courts in the country who have widened the scope of Article 21 by including right in it. There are various agencies whose duty is to conserve water, environment, and air. That is government on one side and community on the other side. On the part of the government, we have Parliament of India, Indian judiciary, and executive. On the part of the community, we have got education system, our non-governmental organizations, which carry out awareness programs, and as an individual, what we can contribute to protect the quality of our water. There are various principles in this regard. Number one is PPP, polluter pays principle. It means the person, the agency, the company, whoever is destroying the quality of our water, it is to be taken on task, because water is just sacred in nature, which is the lifeline of every people. All living creatures, they depend upon the water, so it is to be preserved at all level. Number two, principle of no fault liability. Number three, PP, precautionary principle. Always it is said that precaution is better than cure. So for that purpose, we must make the system in such a way that peoples, they can have a deterrent punishment in case they do so. So for that purpose, we must carry out various awareness programs that what you need to do, what you are not supposed to do. PPP, public-private partnership. Government can't do anything. It is the duty of each and everyone living on this earth to contribute for the betterment, for the improvement. Number four is public interest litigation. Public interest litigation or social action litigation, it's a tool in the hands of right thinking people such as advocates. They can go to the court, that is High Court and Supreme Court directly, for protecting the rights of the citizens, ecology, and our environment, and sustainable development. As has been said by Mahatma Gandhi and so many right thinking persons, that today we must make use of the resources in such a way that we can fulfill the needs of the day by keeping in view needs of the future generations. So that will be better to make use of the resources in a better way, in an effective way. What is the role of judiciary? Indian judiciary has been playing very significant role in protection of quality of water. In some of the cases decided by Honorable Supreme Court of India held that right to life means an environment having clean and neat water for survival of human beings. Water is the most important element of our life. In the case of Himachal Pradesh versus Umaid Ram Saria, the Supreme Court held that everyone of the Constitution of India states that no person shall be deprived of life or personal liberty except according to the procedure established by law. It means it is the duty of the citizens as a fundamental duty to protect natural resources, because if we will put our attention towards those resources as a matter of sustainable development, we will be able to live a healthy life. This was interpreted by the court in Randhawa, Bandhwa Mukti Morcha versus Union of India in 1997, that where the petitioner was an organization dedicated to the cause of the release of bonded laborers. By various surveys, it was found that several workmen in these mines, they were migrant workers from other states in the country who were bonded laborers. They were not getting pure drinking water also. So clean drinking water and medical facilities are to be provided. The Supreme Court stated that there is no doubt that pure drinking water is absolutely essential to the health of the welfare of the citizens, and the government is responsible for providing it. Contributions of various jurists. In this regard, we cannot forget the contribution of Justice P.N. Bhagwati, who has allowed to use public interest litigation as a tool to go for the noble cause of the society. Our advocates, such as MC Mehta, they have done every every pillar to post for the betterment of ecology, for the betterment of our resources. how can the community can conserve these
Sir,
resources?
sir,
Just a minute. The government can formulate laws and policies, and it is our duty to support them. Otherwise, it will be a futile exercise. As a member of community, it is our duty to conserve and protect the natural resources and vegetation and water, not for our present, but for the future generations also. In the conclusion, I would like to say that on 18th December 2020, come to conclusion, please. Last slide. Last slide. Next, please. Next. 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 In the conclusion, on 18th December 2020, the Honorable Supreme Court held that affordable health care is a fundamental right of the nationals. Affordable health care means to carry out the treatment and to make the system in such a way health can be improved. If we don't have proper drinking water, it is just a kind of document only. Otherwise, first we need pure and neat and purity of water. In this case, the apex court of the country held that right to health is a integral part of right to life, and government has a constitutional obligation. Teacher of law, I can say that our parliament has enacted more than 100 acts to preserve and protect natural resources, that is water and environmental, which are directly or indirectly affecting the health of the citizens. We have to contribute a lot toward the government for making its policy of the country. It is our duty to help the government in enforcing these policies for the protection of our health. We must remember that health is wealth, and a healthy mind which is the energy of life. With this thing, thank you. And one more slogan: before asking what the nation has given to you, ask what you have contributed in the development of our nation. So it's our duty, individual duty, to protect flora, fauna, water, and air, and our ecology. Thank you, Jay.
thank you so much, sir.
Thank you, sir.
Thank you very much. Our next speaker is Dr. Jyoti Dharm. Her topic is Role of Pollution Control Board in India to Curb the Water Pollution, a study.
I'm audible, sir. Can you hear me?
Hello? Ma'am?
Can you hear me, sir?
Yes, ma'am.
Okay. Can I start with my presentation?
Yes, ma'am.
Okay. So good afternoon, everyone. The topic of my presentation, as sir has told, Role of Pollution Control Board in India to Curb the Water Pollution, a study. As we know that water is an important factor in the life of living being. It covers about 1/3 of the Earth's surface, but it is useful only when it is unpolluted. So we know that all over the world, there is a problem of fresh water. Justice Karju, in case of State of Odisha versus Government of India, opined that right to get clean water is a fundamental right under Article 21 of the Constitution. It is a gift of nature, and human hand cannot be permitted to convert this bounty into curse. Right to life guaranteed in any civilized society include right to clean water and decent environment. These are the basic human rights known to any civilized society. So in pursuance of this, to protect the water or to provide the clean water, the water legislation, that is Water Prevention and Control of Pollution Act 1974, is enacted by the Parliament for the purpose of prevention and control of water pollution and maintaining or restoring the wholesomeness of water, and also establishing the Center and State Pollution Control Board and Joint Pollution Control Board to protect or to prevent the water pollution within the territory of our India. So I'm not here to discuss in detail about the function, the power which is given to the Pollution Control Board to curb the water pollution. but there are specific powers which I want to address in this presentation, specifically Section 21 of the statute. It's empowered the State Pollution Control Board to collect the sample related with the polluting industry who is polluting the water, and that sample which is collected by the Pollution Control Board, it will be produced as evidence in the court of law whether they are polluting the water or not. Apart from Section 21, Section 25 is very, very important, which says that if any person is required to establish any industry, factory, operation or process any treatment or disposable of system or discharge of sewage or a trade effluent, it is necessary that they have to take the consent from the Pollution Control Board. But there is one provision in the same act which says that if an application for the consent is deemed to have been granted unconditionally if nothing is heard from the board within a period of 4 months. So within a period of 4 months, if it is not decided by the Pollution Control Board whether they have rejected or whether they have allowed, according to the provision, it is consent is given by the board and unconditionally, and they can start with their process. Apart from Section 25, one more interesting provision which is inserted in the year 1988 by amending the Water Pollution Act, that is Section 33A, which gave more power to the Pollution Control Board. Here, the board can give the direction to close any industry, operation or process, or the board can stop the supply of electricity, water or any other services if they found that a particular industry or a company is polluting the water. And whatever the direction which is given by the board, if they fail to comply, then this is an offense punishable under Section 41 Clause 2 of the Water Act. In a particular case, Ambuja Petrochemical Limited versus AP Pollution Control Board, the effluent treatment plant of the industry was not in an operation, and a partially treated effluent was being discharged, causing water pollution in the tank, which is resulting into the danger to public life. The state board directed the industry to be closed, and it was held that the order was neither shockingly disproportionate nor excessively severe. So, and recently in 2015, in One Shakti Public Trust versus Maharashtra Pollution Control Board, the NGT ordered the Central Pollution Control Board to make sure that the Maharashtra Pollution Control Board should take a strict action against all polluting industries which were discharging untreated effluent sewage in river Ullas in Mumbai metropolitan state. It further directed that for restitution and restoration of the environment, the CETP of Dombivli and Amarnath and the municipal corporation to deposit 70 crores with Konkan district commissioner. So here the polluter pay principle is applied, wherein 70 crore has to be deposited by the polluting industry for the restoration and restitution of the environment. As we know that for a small scale industry, it is difficult for them to establish a primary treatment plant and to remove the pollutant from trade effluent. The Ministry of Environment and Forest Government of India has instructed the State Pollution Board to examine the possibility of establishment of common effluent treatment plant in various industrial estate. Now, recently in 2015, the Central Pollution Control Board submitted a report wherein they say that 61,948 million liters of urban sewage is generated every day in India. And the sewage treatment plant which is installed in the city is not sufficient to clean the sewage. And the untreated sewage is discharged into rivers or other water bodies and even percolated into ground. So the Central Pollution Control Board issue a direction to all the State Pollution Control Board and 69 municipal authorities of metropolitan town and cities for setting up of the sewage treatment plant in their respective states. So here, the Pollution Control Board, whether it is a Central Pollution Control Board or a State Pollution Control Board, they play a very important role to remove the water pollution from the water. Now, recently, the NGT in Lieutenant Governor Sarvendram Singh Oberoi versus Union of India and others in the year 2020 opined that, or the tribunal observed that, under the public trust doctrine, the state has to maintain and restore the water bodies. Inter alia, helps availability of water, protection of aquatic life, maintaining microclimate, recharge the groundwater and flow of the rivers. The tribunal here directed all the states and the union territories to take remedial measure for restoration of the water bodies in their respective jurisdiction. Here, in various cases, wherein the Supreme Court or the High Court, and along with the NGT, they directed the Pollution Control Board, they gave the various guidelines to the Pollution Control Board, whether it is a State Pollution Control Board or a Central Pollution Control Board, to apply the polluter pay principle or a precautionary principle. And recently they say that the state, they have to be by applying the public trust doctrine, which is evolved by the Supreme Court in MC Mehta versus Kamal Nath, that it is the responsibility of the state to protect the water and to provide the clean water facility to the public at large. So as the Pollution Control Board is the agency and the instrumentality of the state, so it is their responsibility to provide us a clean water and wholesomeness. They have to preserve and control the water pollution from the water. So at the end, I want to conclude that our Pollution Control Board, with the help of the Supreme Court and the High Court and the NGT, they play a very important role by applying the precautionary principle, polluter pay principle, and a public trust doctrine. At the end, I would like to conclude my presentation with one quote by Lucy Larcon, which goes as, "A drop of a water, if it could write out its own history, would explain the universe to us." Thank you very much for giving me an opportunity.
Thank you so much. Thank you so much, Dr. Jyoti Dhan.
Yes, thank you, sir.
Our next speaker, Dr. Manjeet Singh. Their topic is Role of National Green Tribunal for Water Protection in India. Dr. Manjeet Singh.
Sir, I'm so sorry to interrupt.
Ashriya.
I request the lady to join the parallel session. If she's here, to please join the parallel session. Thank you. Sorry, sir, please continue.
Thank you so much. Dr. Manjeet Singh.
Good afternoon, respected members. And I am Dr. Manjeet from Guru Nanak Dev University, Regional Campus. And my topic is role of National Green Tribunal for the water protection in India. As we analyze the definition of environment is just not pretty trees and tigers, threatened plants and ecosystem. It is literally the entity on which we all subsist and on which the entire agriculture and industrial development depends. It includes air, land, water, human beings, other living creature, plant, microorganism, and property. According to the one of the indigenous theory established in Upanishad, the universe consists of 5 basic elements, which are also known as Panch Tattva. These elements are the land, water, light, air, and ether. The elements played a vital role for the survival of human being because every person needs a healthy environment which enables the people to enjoy an excellent life, which is the spirit of the right granted under Indian Constitution. For the healthy environment, everyone requires pollution-free air to breathe, uncontaminated water to drink, nutritious food to eat, hygienic conditions to live, and healthy environment to move. Water is the basic requirement for the survival of human being, and it is a part of right to life and human right as enshrined in Article 21 of the Constitution of India. In the absence of these above said elements, human beings cannot develop themselves in full extent. For the development of human being, the nature has maintained a status of balance between and among the these constituent or elements and living creature. But man is disturbing water bodies with river, wells, streams, seas. On land, the natural waste system is being polluted by the additions of industrial waste, urban waste, pesticides, and related pollutants. If we see the provisions under the Indian Constitution, then we can find that originally there was no any single provision for the protection of environment pollution under Indian Constitution. However, in the year of 1976, the Constitutional 42nd Amendment Act was passed, which expressly incorporated specific provisions for the environment protections and improvement in the form of directive principle of state policy under Article 48A and fundamental duties under Article 51AG. This amendment was adopted in the response of Stockholm Declaration, and it makes clear that individual has a primary right to equality, freedom, and ample conditions of life in quality environment and allows life of dignity and well-being. Constitution of India provides a Triveni Sangam, fundamental rights, fundamental duties, and fundamental principle of governance for the environment. All these principles shows that the Indian constitutional law is a fast expanding and is a subject to the changing dimensions. In the light of these statements, in the year of 2010, a National Green Tribunal Act was passed. And the next is Water Protection and the National Green Tribunal Act 2010. Access to regular courts for the environmental justice was very expensive, time-consuming, and inefficient in resolving the environmental disputes because of the growing complexity of environmental laws and science. To tackle with these techno-scientific issues in the environment litigation, the National Green Tribunal Act was passed. The Act has completely changed the outlook of environmental justice delivery mechanism under the major environmental laws enacted by the Parliament of India. The National Green Tribunal lessened the burdens of the court as it transferred the environmental litigations to NGT. The Act provides power to the Green Tribunal to hear preliminary grievance as well as appeals from the verdicts authorities under different environment laws. The tribunal consists of judicial members and experts from the scientific and technical discipline. National Green Tribunal, as established by the National Green Tribunal Act 2010, is the India's first environmental court with a wide jurisdictions to deal with the violation of environment laws and also provide for the compensation, relief, and restoration of ecology in accordance with the statutory principle stated under Article 20 of the National Green Tribunal Act. It is based on the principle of sustainable development, precautionary principles, and polluter pay principle. The enactment of the National Green Tribunal Act 2010 has ushered in the new horizons of green justice in India. It has been created with an aim to check the industrial pollutions and allow aggrieved persons to approach the tribunal to claim civil damages for non-implementation of environmental laws. The Act has completely changed the outlook of environmental justice delivery mechanism under the major environment laws enacted by the Parliament of India. The Act amend half dozens of the major environmental legislation and provide higher appellate machinery which was not available under the legislation amended by it. The tribunal is dedicated jurisdiction in the field of environment as provide expedient justice. It is specialized court to decide a case involving a matter on environment. It has disposed nearly 82% of instituted cases within a year of their institution. It played a significant role for imparting environmental justice in speedily and in less expensive manner. It has become one of the foremost environmental courts globally with wide and comprehensive jurisdiction. The cases of water pollution handled by the tribunals are 18% and industry pollution are 17%, which are high in all above categories. Both are related to each other because of the major reasons of water pollution in India is direct and untreated discharge of liquid and semi-solid waste of industry, especially chemical manufacturing units and delivery directly into the rivers of India. Such discharge is threat to the health of human inhabiting the regions surrounding the polluted water as well as the other life forms living in and around the polluted water. The major impact of pollution. Such pollution is also cast on the marine biodiversity of region leading to further problems like the issue of biomagnification visible in the higher levels of food chain. It has been the major issue in several Supreme Court judgments In the case of Narmada Bachao versus Union of India, the Apex Court observed that water is a fundamental need for endurance of persons, and it is a part of the right to life and as enshrined under Article 21 of the Indian Constitution. Even after the 2 decades of this judgment, right to clean water remains a distant dream for many. National Green Tribunal has made a considerable strides on the specific issues of pollution of rivers in India. Industries are the main reasons for the water pollution. 13% of the cases are related to the ecosystem and eco-restoration. It is the 3rd highest in the above categories after the water pollution and industrial pollution. The ecosystem is an assemblance of the animals and species of plants existing in common area and having effect on each other. It is also due to the progressive increase of industries and technology which affect environment and create a disturbance in the society. Thank you so much.
Thank you so much, sir. A very interesting topic indeed. Now I request Dr. C.H. Lakshmi ma'am. Ma'am's topic is effects of impurities in water on children's health. Dr. C.H. Lakshmi ma'am, the floor is yours.
Yes, I am here. Can you make me presenter, Jain sir?
Ma'am, your presentation, ma'am. One second, ma'am.
Presenter చేస్తున్నాను చెప్పు.
We are making you a presenter, ma'am. One second, ma'am.
Okay, ma'am. Okay, ma'am.
Now you can, I think, try.
Just a minute, ma'am. Yes, ma'am, sure. Ma'am, is it visible?
Yes, ma'am, it's visible.
Just a minute.
Yes, ma'am, visible.
Okay, ma'am. Okay. Is it okay?
Yes, ma'am.
Am I audible?
Yes, ma'am.
Very good afternoon to one and all. I think what's the time? 3:48. Very good afternoon to one and all. And first of all, happy Teachers' Day to all the teachers. Jain sir, after a long time, I think I didn't turn on my video. Am I visible, sir?
Ma'am, your presentation is visible.
I'm not visible.
No, ma'am.
Can you give few minutes? Few minutes? I think it is compulsory, no? One second.
Nice to see you, ma'am. Wish you a very happy Teachers' Day.
After a long time. A happy Teachers' Day to all teachers. And okay. Now it is visible, no? Very good evening to one and all. And as you all know, the famous saying, health is wealth, and which reveals good health is the real wealth of individual's life. But it's very strange to know that the water is one of the important elements to keep, maintain, and promote good health, especially individuals, we know that. But on the other hand, so with reference to that, here I wanted to present on effects of impurities in water on children's health and overview. And I don't want to take much time, especially I want to concentrate on 3 aspects. That is, the first one is relating to the global context of water accessibility. And then second point is relating to the effects of, that is, water pollutants on children's health, and what are the efforts of the international community as well as national level. But many of earlier speakers concentrated on that particular issue, that is national level. And so this is my topic, and these are all the three aspects I wanted to discuss on today. And as we all know, how the contaminated water and poor sanitation are linked to transmission of various diseases like diarrhea, typhoid, polio, and many diseases. And no one, in fact, can escape from these particular risks because of unsafe and unclean water, mainly because of the pollutants present in the water. And if you observe the statistical information, it's really strange to know that worldwide 2.2 billion people still lack access to safe drinking water, and more than half of the global population, in fact, does not have access to safe sanitation, and 3 billion people do not have access to hand washing facilities with soap, because nowadays it is very much required because of these COVID-19 situations. Many people are suffering because of lack of these water facilities. And in addition to that, the consequences of unsafe water, sanitation, and children hygiene this is very toxic, especially if you observe this data. Over 700 children, especially under the age of 5, die every day. And in addition to that, though we have a number of international instruments, especially in armed conflicts, in those situations, it is very strange to know that many people, that is especially children, they are nearly 20 times more likely to die from unsafe water than from the conflict itself. Uh, though international humanitarian law is clearly specifying, and the belligerent nations, they should follow the principle of distinction, but still these people are suffering because of the lack of supplying of proper water, that is a safe water and clean water, especially in those situations. And in addition to that, if you observe certain statistical information in India, and nearly there are 18% world population, but only 4% of average global runoff in Earth. And nearly 500 million people are affected by drought in India. And in addition to that, one out of 5 children, they are suffer severe diarrhea in India. And each year, nearly 3 lakhs children die due to severe diarrhea. And but when compared to past 2 decades, though there is a little bit of progress, especially in child mortality rate, but even on today, India, along with Pakistan, Nigeria, DRC, and Ethiopia, contributed to half of the under 5 deaths in the under the 5 deaths in the world. That is a very strange thing we have to notice, because these are all the result of the water pollutants, because the toxic pollutants present in the water, they are hazardous to children's health as compared to adults. Thereby, they are exposed to a greater risk of health problems. And children, they are also susceptible to certain diseases, that is gastrointestinal diseases, and that is stomach illnesses like nausea, diarrhea, and headaches because of taking this contaminated water. And the health effects of drinking contaminated water can range from sometimes no visible impact, but sometimes it is very dangerous, that is severe illness, includes death. As they are still growing, these contaminants in water causes more harm to their developing tissues and organs. Especially there are 3 contaminants, that is mainly lead, nitrate, and nitrate, and manganese. The lead is a toxic metal. It causes serious harm to human health, and up to 20% of the total lead exposure in children is attributed to a waterborne route, that is consuming contaminated water. And infants, fetuses, and young children, they are particularly vulnerable to lead poisoning. And high levels of lead contamination in children result in convulsions, major neurological damage, organ failure, and ultimately it leads to death. And the presence of nitrates in water causes the development of cancer, and the high level of manganese presence in water affects on the IQ levels and the verbal and behavioral performance in children. So, by keeping view of all these things, the international human rights instruments, this International Bill of Human Rights, does not specifically say anything about the importance of the right to water and as a means of right to health, but international human rights law that other instruments concerned about the children right to health, especially CRC, that is Convention on the Rights of the Child, 1989. Explicitly, this clearly mentioned water, environmental sanitation, and hygiene. Article 24, Class 2. Prior to that, CEDA also emphasized the need of that is right to water as means of right. And Article 24.2 of the CRC clearly states, states parties shall pursue full implementation of this right, and in particular shall take appropriate measures to combat disease and malnutrition, including within the framework of the primary health care through inter alia the application of that based upon the readily available technology, and through the provisions of certain adequate, nutritious food and clean drinking water, taking into consideration of the dangers and risks of environmental pollution. And other thing is another important instrument. You can observe the Protocol on Water and Health to the 1992 Convention on the protection and use of transboundary water courses on international lakes. This also places an obligation on the state parties to provide accessible and affordable water facilities to individuals, including children. And the 2002 General Commitment, but it number 15 integrates the Convention on the Economic, Social, and Cultural Rights, but it does not place any obligation. But here it's emphasized the need for the right to water. And another important convention is that is in the year 2010, United Nations General Assembly and Human Rights Council emphasize the need of water, how the water as an important fundamental human right. And another, the optional protocol of ICSR 2013. Yes?
Ma'am, if you could conclude.
Yes. And the optional protocol to ICSR, this is also emphasized, and recently there's a complaint mechanism created. Complaint mechanism is created. So with this, we can understand how the international, that is the role of international community in emphasizing the need of right to health, and as in right to health, with reference to the right to water. And in India also, under the head of the Article 21 of the Constitution of India, and we know how the judiciary plays a vital role, and it's a main architect in establishment of the right to water as a means of one of the fundamental human right. In many cases, from Vellore Citizens Welfare Forum versus Union of India, and Mansi Mehta versus Union of India, and another important cases, that is Sudhakar Kumar versus State of Bihar. So in all these cases, we can observe that how the apex court clearly emphasized that is right to life includes that is enjoyment of the pollution-free water. And in addition to that, so I'm concluding that this is though we have made substantial development towards the drinking water, but with reference to the that is sustainable development goals, and then in the year 2019, that is the Ministry of Drinking Water and Sanitation was restructured under a specific program that is Power of Water, that is Jal Shakti, and UNICEF is supporting this ministry program Jal Shakti in strengthening the Swajal and the National Rural Drinking Water Program. And we have to accept one thing, that is everyone should realize that clean and pure water is the only world's first and foremost medicine. And in this context, we have to understand the suffering of the children. And then though there are certain international and national efforts, but still children are suffering a lot. So in addition to the that is public government, in addition to the government, then the corporates and the NGOs and our individuals, they must take special care to protect the interest of the children in all aspects. Because though it is the little things that are important, like a little seed become a tree or flower, hence clean water awareness programs frequently organized to save the succeeding generations of the children from the scourge of water, because the fate of humanity is in their hands. Thank you. Thank you very much
Thank you so
for
much,
giving
ma'am.
an opportunity to present around today.
Thank you so much,
Thank you.
ma'am.
Thank you, ma'am. Thank you, sir.
Our next speaker is Mr. Shreyanshu Tripathi. Their topic is instruments to control water pollution. Shreyanshu Tripathi. Sir. Mr. Shreyanshu Tripathi. Shreya.
So Mr. Shriyanshu is not going to be
Not
presenting. We can move on.
Uh-huh. So then we'll wrap up this room of our session.
So there have been some shift made. I'll just confirm in a second.
हाँ जी. Anyone else would like to share their views with us?
This session can be concluded, no, Shreya? Then?
Ma'am?
I think
Yes,
it
ma'am.
was.
Ma'am, I request the answer to say a few concluding remarks for the session.
It's been hello everybody. It's been so long. After so long, I've come back to DSNLU. It's like coming back to DSNLU only, even though it's virtual. Uh, Fantastic line of discussions, especially when we talk about water. With so many things going on politically in the world, and with COVID and other things, we are missing out on this particular aspect as to how important water is and what we are going to face in the future, especially when it comes to clean drinking water, because that clean drinking water or generally usable water, uh, because that is going to be a game changer. It's Water is going to become a problem in the future, and uh, it's better if we start thinking about the solution. It's already way past emergency marks, but still it's very important for us to think about water. I thank Sudha ma'am, Bala sir, team DSNLU for giving me this opportunity. I also wish everybody a very happy Teachers' Day once again. Thank you so much.
Thank you so much, sir, and happy Teachers' Day to you also. Ma'am, please, Sudha ma'am, please, some remarks.
Nothing. I just said thanks to him. And thanks for your wishes also.
Thank you so much for having me here, ma'am.
I request if anybody else has any feedback, they can let us know. Please make sure that you fill out the feedback form for the end of this session as well, which will be shared with you on the WhatsApp group as well and in the chat box. And I also request all of you to, and I invite you to attend the valedictory session post the end of this session and the panel session. It was a pleasure managing this session and hearing all of you all speak and with such great presentations, and to understand that a single theme can, branch out into so many interesting topics and so many interesting point of view. So I thank everybody for their presentations and for their remarks on the topic. Thank you.
If anyone wants to express something during the valedictory, give their feedback, kindly volunteer, but just inform the organizers first so that we will make the necessary arrangements. Right? So I think we can break now and take a break and join at 5 o'clock. Right?
Yes, ma'am. Yes. Once again, I'll remind you that the valedictory is at 5, so please make sure to tune in for the valedictory session. We have a lot of other dignitaries coming up and giving their address. And thank you so much for joining the technical session. And we'll end the meeting.
Right. The link will remain.
Yes, ma'am. People can. Thank you so much.
Good evening, everyone. Charita,
Yes, sir.
you ready?
Yes, sir.
We'll start in a minute.
Yes, sir.
They have joined, Charita. Both the guests have joined.
Yes, ma'am. Ishwara Bhatt sir and CM sir both are there, and Vice Chancellor sir also just joined, ma'am. I think we can begin, ma'am.
Good evening, everyone. Firstly, I wish all the faculty present here a very happy Teachers' Day. I welcome you all for the last session of the 2 days national webinar, that is the valedictory session. It gives me immense pleasure and delight to welcome the guest of honor, Professor Dr. C.M. Rao sir, Principal Manikchand Pahade Law College, and Professor Ishwara Bhatt sir, Honorable Vice Chancellor, Karnataka State Law University, who would deliver the valedictory address today. I would also like to welcome Professor Dr. S. Suryaprakash sir, our Honorable Vice Chancellor sir, our all the faculty members and the students of Damodaram Sanjeevaya National Law University, the participants, the dignitaries, the speakers, and all the others present in the session today. I invite Professor Dr. S. Suryaprakash sir, our Honorable Vice Chancellor, to deliver the presidential address. Over to you, sir.
Thank you, Charita. So, my warm wishes for a happy Teachers' Day. Sir, Professor Ishwar Bhatt ji, namaskar.
नमस्कार नमस्कार
कैसे हैं sir आप?
फाइन फाइन वेरी गुड
Sir. And I welcome for this evening session, valedictory session,
Thank you.
Professor Ishwar Bhatt ji, and my friend Dr. C.M. Rao, Principal, and our former Registrar, SNLU. At present, he is Principal, MP Law College, Aurangabad, and other faculty members, and in particular, Dr. K. Sudha and Kiran, and here their young team who are instrumental in conducting this wonderful program. And this is the positive side of COVID-19. So there are so many disadvantages and we suffered with COVID, but technologically, before this COVID-19, we never heard of these webinars except for a few meetings whenever it was necessary, only online meetings. But technology, COVID pushed the technology, and today many programs, and this program particularly a very grand success because of more than 50 research papers what I learned, and on different topics relating to water conservation and management and pollution to all other things were deliberated and discussed for the last 2 days. As all good programs has to come to an end, and this program today, now we are having this valedictory session, and it's very nice and to see our senior Professor Ishwar Bhatt, a very, very good researcher and a great academician. And earlier he was the Vice Chancellor of NUJS Kolkata, and now presently working as Vice Chancellor. And sir, there's a lot to learn from you, particularly your research skills and your most celebrated book on social transformation, etc. And my dear students, we do participate, we present papers in seminars, and but what should be the takeaway? It is not only the knowledge. Definitely, by attending these kind of webinars, we acquire some information and we enhance our knowledge. But above all, because water is such an important matter, that is, without water there is no life. And as I said that it is on record, all water resources, they were safe till 1960s and 70s. And after 1970s, we consider that we have 5,000-year civilization. But I do not know where our civility has gone. And when we are polluting our water resources. So now this is the time, at least you can write a letter to the newspaper whenever you come across a pollution of a river or any kind of water resource. And in African countries, they have no water. But most of the countries, including South Africa, they are suffering due to lack of water. There was pressure. But in India, we are blessed with sufficient water resources. There is perennial rivers and tanks, and unfortunately, we are polluting them. That is, we are losing the fresh water. So with these few words, I wish all the youngsters not only to deliberate and discuss, but also somewhere, you have to reach over to action. So I'm not saying that you should go onto the roads and you should agitate or do hunger strikes, etc. At least a small protest. Write a letter to the newspaper. So this is the area where you have to. So the authorities may look into the matter if there is a more civilized way of making a protest. So, my friends, let's hope that we, the citizens of this country, will make it in a responsible way, protect our water resources. This is our duty. And if we miss our duty, we will be guilty before the coming generations. With these few words, I congratulate Dr. Sudha and her team and all the student friends who are working for the last 2 months or so to make this program a grand success. Thank you. Thank you, Beta.
Thank you so much, sir. Now I invite Bailakiran sir, co-convener of the webinar on water management laws, life, livelihood and environment, to deliver the report on the webinar. Over to you, sir.
Thanks, Chaitra. Good evening, everyone. It's an honor to present a report on a webinar which has been sponsored by ICSE, sir. So I start with a very sincere note of gratitude to the university and ICSE, sir, for all the support that we had got. So to start with, somebody else is speaking. Just give me a second. Yeah, I'm very sorry. So to start with, we started it as ma'am explained when things were normal. It was supposed to be a seminar. We went on to it and converted it into a webinar. So the journey was explained by ma'am, something that is visible and something that can be seen. Now something lies behind with all this. The strength that lies in the last page of the brochure. If you see, there's a dedicated team of 20 students. So I want to thank all of them before I present my report. So with that note, we had a wonderful inaugural session. Our Vice Chancellor had declared the webinar is open to put it in Sudha ma'am's voice. We have Rajendra Singh, who had roared like a lion yesterday. That's what ma'am said. So Rajendra Singh sir and Sharma sir had made a wonderful analysis of things. They come from different walks of life, and they serve as an inspiration to it. So I place on record their efforts in making the inaugural session successful. After which we had the first technical session titled Water Security Best Practices for Conservation of Water and Law, wherein a keynote address was delivered by Professor Collette, titled Conservation of Law, Regulation of Uses of Groundwater and Surface Water, and followed by the 4 paper presenters, and the session was chaired partly by Professor Collette, and he has to leave in a moment. So it was co-chaired by Dr. J. Umarao, Associate Professor of School of Law, Getam University, and Mr. Punyashlok Das, Assistant Professor, Birla Global Law School, had acted as the rapporteur. There were 4 papers that were presented. After which we had proceeded to the second session, wherein we had a keynote by supposedly it should start with the keynote, but there was a technical glitch. So we were fortunate. In fact, Dr. Sujit was telling as to why Rajlakshmi ma'am's plenary talk was way too good. So we went with that. So Rajlakshmi ma'am spoke elaborately on human right to water. She made a wonderful analysis of right to water and right to sanitation, the international instruments, followed by Dr. Sujit Skoonen's pinpoint keynote on human right to water in the Anthropocene, which generated a good amount of debate. And that session was further divided into two parallel sessions for paper presentations. So one was chaired by Dr. Lakshmi Priya Vinjamuri, Associate Professor of Uttaranchal University, and Ms. Ranjana Ramanathan, lecturer, Jindal Global Law School, was the rapporteur for it. There were four papers present in it. And the parallel session was chaired by Ms. Soma Bhattacharya, Assistant Professor, DSNLU, and Ms. Pratyusha Samavedam, Assistant Professor, Symbiosis Law School, Hyderabad. The rapporteur for the session was Divya, a second year student, and three papers were presented. Then after lunch, we had another wonderful session chaired by, with the keynote and chaired by Professor Tony Judge, and he spoke on India and international water sharing, and the analysis that he had given was way too wonderful. He spoke of all the neighbors that are there. He was talking about not just legal implications, the political and the international relations implications, and the strategic ramifications that are there for India. And post which he chaired the session, and Anjana Ramanathan of Jindal Global Law School had moderated it. The rapporteur for the session is Mr. Amandeep Singh, advocate with High Court of Uttar Pradesh. And we had a parallel session chaired by Aruna Kamila, of Associate Professor of Galgotias Universities, and ably supported by the co-chair and moderator of Maharashtra National Law University, Aurangabad's political science teacher, Mr. Vinay Kumar, who had added a lot of international relation ideas to the papers that were presented. Then we had ended the day one on a high note. We were expecting that everything would go well, and we would accommodate everyone. And to put things in perspective, we had a dedicated student team. Like I said, we had an LLM student by name Kirtana, who had acted as the day's reporter. She had submitted a report which will be made part of the record. And there is a dedicated set of students for each of the session. And today, the second session, we started with a keynote by Dr. Srinivas Chokakula. He had given the good, ugly, and the bad parts with the Interstate River Water Disputes Amendment Bill 2019, and wonderful analysis, which is followed by a technical session wherein 6 papers were presented. So Dr. Srinivas Chokakula had chaired the session. It was moderated by Dr. K. Pallavi of Andhra University, as Assistant Professor of Andhra University, Dr. B.R. Ambedkar College of Law, and it was heavily assisted by Mr. Ashish Kumar, Assistant Professor, Vigyan Institute of Law. Post which we had the technical session 5 titled Commodification, Privatization and Water Markets, which started with a keynote address by Dr. Stelina Jolly, who spoke on commodification of water with special reference to legal personality of rivers. Though it was a short presentation to see, there were only 4 slides, but it was so impactful that next presenters were quoting those 4 slides and the wonderful analysis that she had. So over here we had 2 parallel sessions. One was chaired by Dr. We couldn't have a parallel session because Stelina Jolly ma'am was like, we'll have it together. So we had scrapped lunch and we had a long session there. So Stelina Jolly ma'am chaired it. It was co-chaired and moderated by Ms. Delhi Chandana, Assistant Professor, Reva University, and Ria Hundal, Assistant Professor, Geetham School of Law, had been the rapporteur. And like I said, we had scrapped the lunch. We went ahead with the last technical session, which is water pollution, externalities, legal instruments and remedies, with the keynote address by Nidhi Jamwal ma'am. She spoke on the IPCC report 2021 on water with wonderful resources from the meteorological and the topographical data talking about rainfall and the implications that we have and what is the way ahead. So post which we had two parallel sessions. One was chaired by Mr. Jain Sala, Assistant Professor, KIT School of Law, and Chandana, the fourth year student of DSNLU, acted as the rapporteur, and the parallel session was chaired by Sushmita Patel, policy lead climate-related issues with Youth Ki Awaaz, and the rapporteur for the session is Divya. And for day two, the student rapporteur is Mr. Somesh Pandey, who had been through all of the sessions wherever it is possible, barring the parallel session. So that will be made part of the report. And there was a set of students who were continuously attending to all the technical details that are there, including sharing links, making people presenters. So I place on record all the efforts of the people, and if I had forgotten anyone, kindly understand that it is not intentional. Thank you so much. Over to you, Charita.
Thank you so much, sir. Now I take immense pleasure of introducing the guest of honor of the valedictory session, Professor Dr. C.M. Rao, Sir, Principal Manikchand Pahadi Law College. Sir is a PhD holder from Andhra University on the topic, a study of the doctrine of promissory estoppel and its application in the domain of public law of India. Sir has teaching experience of 33 years of UG and 15 years of post-graduation. Earlier, he was served as a registrar of Damodaram Sanjeevaya National Law University. He also served as a University Grants Commission Coordinator and Assistant Principal at Sir Kattamanchi Ramalinga Reddy Law College. Sir also acted as a National Assessment and Accreditation Council Coordinator at Sri Swami Vivekananda Shikshan Sanstha Law College and held many other administrative experiences. Sir has participated in 18 seminars or workshops on the presentation of papers. Sir has nearly 10 publications with ISBN or ISSN. He was also a founder of member of Academic Council of Maharashtra National Law University, Mumbai. Sir also has many other achievements and also held many other positions of responsibilities. It gives me immense pleasure and delight to request Professor Dr. C.M. Rao, sir, to deliver the address. Over to you, sir.
At the outset, let me thank Professor Surya Prakash ji for giving me an opportunity at the valedictory session of this two-day water loss webinar. And I thank the organizers for remembering me to say a few words about this water loss and management conservation. I get my refresh my memory what I did around 7 or 8 years back on the water crisis and conservation management in the British Scholars Association of Vizag, and also there is a seminar in Symbiosis, Hyderabad. As I observed, there are 16% population, world population is in India, and out of the world land, 1/3 of the land is covered by water. And at the same time, we are requiring 4% of water at present, 40 billion cubic meters at present, and it is going to be rising to 220 BCM by 2025. The greedy nature of the human being is going to make this particular thing worst in the coming days. If you look into the Godavari and Krishna rivers, there are 2,300 cubic meters every year going into the sea. And the way in which our governments are handling the things, and the people who are talking about linking of rivers, and the people who are fighting for the water rights, especially between Telangana and Andhra Pradesh, and Kerala and Tamil Nadu, and Maharashtra and Telangana. These are the places where water fights will come within future for the purpose of Riparian rights. The people who are downwards, they have to face a severe problem of water conservation and also management. And at the same time, if you look into this particular water area, We the people, I congratulate the foresight of the DSNLU, where they have made 150 liters of wastewater recycling. This is the need of the day. Okay, many of the institutions doesn't care of recycling of the water, and I congratulate the authorities of DSNLU for making the use of recycling of the water, wastewater, which can be used for the particular gardening and all those things. And at the same time, the particular participants who have presented their views and thoughts, which enlighten the young budding minds about their duties towards the society, towards the Mother Earth, what should be done by these people. I congratulate organizers for a wonderful academic feast that was arranged. It is not the quantity, it is the quality that is going to be seen in this particular seminar or webinar. So due to administrative work, I am able to hear some areas, but all the participants, while I am listening to them, excellent presentations, even the students are also taken pains to make it a grand success. And on behalf of myself, I congratulate Professor Sudha Madam and Baila Kiran and all the students who have taken pains for making this particular function a grand success. Thank you, one and all.
Thank you, sir. Now I would take immense pleasure to introduce Professor Ishwara Bhatt, sir, Honorable Vice Chancellor, Karnataka State Law University. He got PhD degree in law from the University of Mysore and LLD from the National Law School of India, University, Bangalore. He has 40 years of teaching experience, taught in many prominent institutions. He handled 5 research projects and guided 21 candidates for PhD successfully. He has specialization in constitutional law and has taught constitutional law, administrative law, law and social transformation, non-profit law, legal research methodology, intellectual property rights, and water law. He was an awardee of the Sastry Research Faculty in 1992. He participated and presented papers in more than 100 national and international seminars. He has also authored books that got published in Oxford University Press and many other publications, and also edited many books. Few books edited by Professor Ishwara Bhatt sir were International and Interstate Water Disputes and Law, Natural Resources Law. He has to his credit the publication of 130 research articles in reputed national and international journals and books. In view of his contribution to the system of legal knowledge by research, the Capital Foundation Society, New Delhi, has conferred Professor Upendra Bakshi National Award for Research in Law in 2020. On this note, I request Professor Ishwara Bhatt sir, Honorable Vice Chancellor, Karnataka State Law University, to deliver the valedictory address. Over to you, sir.
Okay. I hope I am audible and visible.
Yes, sir, you're audible and visible.
Yes. Professor Surya Prakash, Honorable Vice Chancellor of Damodaram Sanjeevaya National Law University, Visakhapatnam, Professor C.M. Rao, all the faculty members, delegates, and participants in this webinar on a very important subject, that is water management, then water law and conservation. First of all, let me extend to all of you a very happy Teachers' Day. At the outset, let me congratulate Professor Surya Prakash for organizing this important webinar in a very successful manner. Yesterday, I had an opportunity to listen to some of the presentations and some keynote speeches also. It has actually added to the existing knowledge system. There is no doubt about that. There were very eminent participants like Professor Tony George, then Kunan, Philip Kulle, and various other scholars. That itself speaks how the deliberations have opened up new thoughts, new ideas, and new analysis. The topic chosen is quite comprehensive. It is not just confined to, say, interstate water or groundwater, or relating to pollution, or relating to drinking water, etc. But it is a general topic, a comprehensive one. For selecting such a comprehensive topic, I congratulate the university for the reason that an integrated approach is to be adopted insofar as water management and water conservation is concerned. It is not possible to look only to the aspects of drinking water, or water for irrigation, or interstate water dispute, or tank water, or traditional water system, or groundwater, etc. It is essential to examine the water resources in a comprehensive manner. Further, problems relating to access to water, sharing of water, and management of water, conservation of water, avoidance of various types of pollutions or wastages, etc. And the possibility of, say, rainwater harvesting, the possibility of recycling, and most economical use of water. All things are to be examined in a comprehensive manner, because water problem is not something confined to any specific issue. Various things are interconnected. Water is one of the Panchabhutas, and it is essential for all living beings. For various activities, agriculture, or of course, for very survival, drinking water, drinking purpose, for health, for a commercial purpose, for industrial activities, water is needed. For cleaning or any other thing, water is the most essential component of economic activity in the country. Insofar as India is concerned, we have water resources from different sources. We have river water, then groundwater, tanks, and flowing surface water, and other such resources. See, insofar as its use and application is concerned, so many issues are come across. We find that there are human right dimensions. There was a elaborate discussion about the human right dimension of water. Right to water is regarded as one of the fundamental rights, right to drinking water especially. Even right to water for the purpose of irrigation, that is also considered as something related to means of livelihood. The seminar has dealt with all these issues. See, human rights issues are there, issues of federalism are there, issues of decentralization of power. There's a we have 5 layers of government. There's a central government, state government, then a panchayat raj, and a coordinated effort from the side of all the layers of government is required in order to ensure that in relation to water, the efforts are systematic, and they're promoting welfare, they're promoting equity in access to water, and they're ensuring efficacy in use. Then there is the dimension of democracy. See, not only federalism, democracy. Which level of government has the power? On that basis, the legislative power will be identified. But once that legislative power is there on the part of a state government, then how the state government enacts the laws to ensure that there will be distribution of water to various persons, to all citizens in an equitable manner, and relating to avoidance of pollution, or relating to conservation of water resources. What best efforts are to be put about this? It is the set of legislation that decides. Thus, the democratic participation from the side of people counts a lot. When a law is made, unless that law is accepted and internalized by the society and applied in day-to-day practice, its objectives will not be realized. Social transformation will not occur. There is a need that people should participate. So participatory approach relating to water becomes essential. And that was a part of our culture, whether it was the idea of Pani Panchayat, or the idea of say maintenance of tank systems, or various other methods of water distribution. There was a reliance on people's participation, and the people's participation is very much essential. Relating to rainwater conservation by water harvesting, or say avoidance of wastage, or recycling of water, and so many other things. It is only with the people's participation that water law becomes effective. We have seen from the experience of Israel and some other countries how through scientific method and through people's participation, optimum use of water could be made. And here we come across the use of science and technology. Thus, this is one sphere where number of factors interact, and overarching of various values can be found. And such overarching of values is something to be taken into consideration, because without an integrated approach, it is not possible to solve various problems relating to water management, conservation, then linking water with the livelihood and various other issues. Insofar as convergence of these values, we should consider that it is a part of the constitutional philosophy, or it is a part of the social system itself, because social, economic, political, and environmental factors count a lot in relation to water. Social issues are there. See, when the practice of untouchability comes in the way of access to water, then there is a social dimension of water. We have to take into consideration that factor. When access to water is something available only on the basis of economic power. Suppose a farmer, a small farmer, is not able to sink a bore well or an open well and extract water, but a neighboring big farmer is able to extract a whole of water from the groundwater resource, from the aquifers. He may put the small farmer into total impoverishment. Where is the equity? See, when Article 21 guarantees a right to life, and a right to life includes access to drinking water and access to livelihood, whether the small farmer should be deprived of such an opportunity just because of economic inability on his part? what should the state should do in such circumstance? All such issues are there, and hence an integrated understanding of a whole of the water problem is something required, and it is quite right that your university has taken a comprehensive subject and dealt with the various issues, both the international problems and the problems within the nation, interstate water dispute, and various issues. Of course, that is something that will really contribute to generation of new knowledge. In fact, seminars of these types, they evolve new ideas. That is the contribution. They spark the new thoughts. That's quite significant. The need for coordinated efforts can be identified in this way. First, various provisions in the Constitution relating to fundamental rights. There's Article 21 of the Constitution, or 14, 17, or even Article 32. Then Directive Principles of State Policy, especially the idea of economic justice, which is connected with the distribution of material resources of the community to subserve the common good. All these things are to be taken into consideration. See, development should be development with the justice. Without justice, that development becomes say, it's skewed, or it's a situation of imbalance, and that should be avoided. And in order to ensure that the factor of economic justice is infused to the whole process of say, water distribution, water availability, water access, and water use, we should consider that Article 39B and C of the Constitution provide a lot of guidance, a lot of input, and that should be considered as one of the important factors. It's true that Helsinki rules were taken into consideration in formulating the equitable apportionment principle, which is the central idea relating to distribution of water in various cases relating to riparian states. There's among riparian states, the distribution of water shall be on the basis of equitable apportionment. That idea takes into consideration the past use, then a territorial factor, then a catchment area, the extent of development, the future possibilities, and need of the people. All the factors should be taken into consideration. Once again, integrated approach. Integrated approach becomes one central theme in each and every aspect of water law that we cannot miss. Then about federalism. See, distribution of water power, there's a legislative power relating to water between a central and a state that we find under a 7th schedule. But in course of time, central government gathered power to enact a Water Act because of authorization from the side of the state governments. And a perfect coordination between a central government and the state government is something required and something contemplated. Of course, it is because of the participation of various federal units in the use of water and avoidance of pollution. There we come across again concerted application of power. And what happens if there is a lack of coordination between central government and state government, or between a central water pollution control board and a state water pollution control board? So state water pollution control board is not bothering about the central water pollution board's instructions, guidelines, and approaches, or it does not give effect to the central law to the extent needed, then we come across that discrepancy, because of which the extent of optimum use of water and avoidance of pollution, that is not properly addressed. Water pollution shall be totally eradicated. It shall be redressed properly. Of course, there shall be not only prevention, but also restoration of water and avoidance of such a pollution, and remedial action should also be there. All these things go together, once again emphasizing the integrated approach. Then about it is only relating to interstate water that the central government has the power, but relating to water other than interstate, it's the state government which has a power. That's relating to drinking water, or relating to groundwater, or relating to water that is to be managed by Panchayat Raj system or municipalities, etc. It is the state government which has to provide for the law. But here also some guidelines given by the central government. Model groundwater law bill, groundwater bill, that is framed by the central government, or various technological guidance that is given by the central government, that actually help in ensuring that there will be some viable policy on the part of the state government, and the state governments will be compelled to comply with some of the minimum requirements relating to protection of groundwater, etc. Relating to distribution of groundwater, drinking water, 24/7 system or various other systems. There also the state governments have major role to play. Since water is a local issue, states have such an important role, but under the environmental law as well as water law, since the central government has given certain legal norms which are binding upon the state governments have to follow those principles. Of course, regional variations may be there insofar as the groundwater law is concerned. There, yes, that is unavoidable. See, topographical variations, or the extent of rainwater that is available, or extent of rainfall as well as storage and various other factors. Those factors shall be taken into account when the riparian states near Ganges enjoy a very rich groundwater resource. Other states do not have so much of a groundwater resource. All those factors of variations may be there, but still, extraction of groundwater in an unreasonable manner, even in a Ganges belt, that gives rise to a lot of problems, and that ought to be avoided. And we come across so many laws from the side of those northern states as well. Then, in relation to pollution, see, pollution is one problem that puts water into a very critical situation, because it becomes unusable, or it may be giving rise to health issues, or so many other problems. See, pollution arises out of several reasons: urbanization, industrialization, then irrigation, then use of chemicals in agricultural activities. All these factors contribute to pollution. Of course, urbanization and industrialization, these are all local problems, but those local problems are to be effectively handled. But when those local problems give rise to some transboundary effect, suppose they have impact upon the neighboring states, then it is the task on the part of central government to ensure that water pollution is totally controlled or avoided and properly dealt with. We come across the famous Ganga purification project, which which cuts across a number of states. There are about 7 to 8 states which are participating in a Ganga purification. Of course, if cooperative federalism and the support from the side of state governments is effective in avoiding such a pollution and dealing with the various problems relating to pollution, then of course the effect of all such efforts will be quite good, and it will be promoting the overall fair consequence or comfortable consequence. Of course, insofar as these natural resources are concerned, or insofar as environmental law is concerned, consequentialist approach, because most appropriate approach in recent times in Europe, it's a consequentialist approach that is adopted. See, intergeneration equity or a public trust concept or a prevention principle or such are principles, they actually refer to this consequentialist approach, environment impact analysis, that is made for the purpose of ensuring that the consequence of the present project or a project that is going to be taken up is not unfair, or it is not environmentally hazardous, but it is in keeping with the the idea of a wholesome environment. See, consequentialism is a principle which has a larger implication. See, for thousands of years, we have developed our natural resources, and we have depended, people have depended upon these natural resources, and for subsequent generations in future, for several centuries hereafter also, this natural resources shall be available. So the consequence of some say project which is having a very limited perception, or which is not having a long-term vision, that will have some drastic impact. Professor Surya Prakash Rao was Professor Surya Prakash was referring to the change that occurred after 1960s or 70s. Up to 1970s, everything was okay with the waterfront, but afterwards, because of industrialization, because of climate change, because of so many factors, there is a deep inroad to this natural resource called water. See, climate change has become a reality. We find that in a coastal Karnataka or coastal Kerala or coastal Maharashtra, there is a torrential rainfall in few days during a monsoon, and thereafter there will not be rain at all. See, scanty water during other times, and flood in a few days. This is a product of climate change. So many such changes have taken place, and the problem relating to water is to be addressed as a part of the climate change problem itself. That is why so many of the states take into consideration the holistic policy of treating various components together. For example, Andhra Pradesh, your own state, has a very good legislation relating to groundwater. See, soil, land, and groundwater. or water as such. All these are to be treated together. See, by putting bunds or by various methods of water conservation, there shall be better harvesting of rainwater. There shall be afforestation, because of which better water resource can be ensured in the state. And about the use of water also, see, limitation on the quantity of extraction of groundwater, and a limitation on the purpose for which that is going to be used. There is a regulation of the purpose of water use, crop pattern, and such things. Concerning each and everything, suppose appropriate management is made, then it gives rise to a reasonable consequence or a desirable result. A desirable result. There's a desirable result which is contemplated in the Constitution, that lakes, rivers, and water bodies shall be protected, and they shall be used, made available to the people in a reasonable manner, and there shall be avoidance of pollution and so many other things. These are all contemplated in the Constitution, and these are contemplated in environmental law, and we have to take into consideration all these factors. Yes, about integrated use of water in various specific spheres, we can throw some light, or we can examine. For example, in relation to federalism, we find that the distribution of interstate river water according to the equitable apportionment principle has come to stay, and that has become the basic principle. Helsinki principles, then constitutional jurisprudence, all these factors are taken into account. Of course, development with the justice, which is a component of this equitable apportionment principle, should have been given a lot of focus. And for the first time in a 2018 Supreme Court judgment on Kaveri, Justice Deepak Mishra, Chief Justice Deepak Mishra, gives he refers to the constitutional philosophy which has to mold, or which has to support this equitable apportionment principle. See, there is a lot of wastage of money, time, energy, patience on the part of various riparian states in litigating in relation to their share of water. Suppose with a better understanding of the entitlement, there is the avoidance of litigation, or through say agreement, or through mutual negotiation, or through mediation and settlement, these disputes could be resolved. Then it goes a long way in promoting the integrated use of water. We come across a number of examples. For example, the books on interstate water dispute law, they provide a lot of information about the way in which these disputes are settled through negotiation, agreement, and mediation. That is also possible. We have to think on those terms, because integrated approach relating to water distribution or sharing of water and water management should take into consideration those factors. Then federalism has to support the cause of environmentalism. There is the idea of green federalism. Green federalism becomes very much relevant in the context of integrated management of water. See, there we find that the cooperative federalism, which persuades all the state governments and the federal government to adopt certain policies relating to conservation of water and interlinking of rivers and so many other programs. There much success could be there. Of course, the idea of interlinking of rivers was initiated in 21st century. There was much hope about this idea of interlinking of rivers. That is actually one prominent method of using the integrated system of water management in an effective manner. But it has its own shortcomings, because it cannot afford to have environmental hazards. Further, various other issues are there. But suppose flora and fauna or the existing water bodies can be supported through interlinking of various rivers, then it is possible to get the benefit of it. And we have to look into the experience of other countries also concerning joining of rivers. But at least joining of rivers to the extent permissible within the environmental conditions, or within the limitations of environmental protection, that ought to be taken into consideration. That's why when interbasin transfers are to be done, that ought to be done only without causing any kind of hazard to environment. No question of deforestation or submerging of water or such a thing. But suppose without that, it is possible to have such a interbasin transfer, then it may be permissible. There also, the idea of equitable apportionment and other principles will have to be taken into consideration. There's the idea of human rights that actually influence various spheres. See, relating to groundwater law, we come across the invocation of Article 21, right to life. Relating to say resolution of interstate water dispute, we come across a invoking of a right to life. And relating to say avoidance of water pollution, again Article 21 is invoked. Thus a human right becomes one of the central issue. And of course the integrated approach through the participation of various federating units and the central government is something that ought to support the cause of wholesome use of water. Then relating to water pollution, suppose there is a lack of coordination between a central government and state government, that gives rise to certain problems. We come across a number of cases on the point. Then about enforcement of international conventions through national law, we come across again some hint about the way in which integrated approach would be possible, because international law does not so much bother about internal division of powers within the domestic system. It only emphasizes about the basic principles that are to be followed by the municipal legal system. See, how exactly the power is divided between central government and state government, that is not the concern. When international legal principles, whether it's a convention relating to environment or conventions relating to human rights, are to be put into application. That's it is possible to invoke international law to go beyond the division of powers between central and state government and integrated management, integrated use of water that can be taken into consideration. Then another point that I intend to point out is that among different water resources, there is an interconnection. Now, suppose there is a water stored in a dam, and that could be used to feed so many of the tanks during the rainy season or during the period of flood. Then it can rejuvenate the tank system, and for a long time that provides a resource for groundwater also. Then groundwater resource can be augmented when there is a spread of water either in the dam or in other place of storage, so that the water, groundwater will become quite rich. Yes. Another factor is that between groundwater and surface water, there is a need to recognize that link, and the latest judgment of the Supreme Court in 2018 has recognized that the interstate river resource should be calculated by taking into consideration both the surface water and groundwater. That's a very important factor that shall be taken into consideration. Then pollution of groundwater because of pollution of surface water, or say other types of pollutions because of because of industrialization or chemicalization, etc. That should also be dealt in a comprehensive manner, and relating to each and every issue, we come across the need for dealing with those issues in an integrated manner or in a holistic manner, relating to local self-government and water. There, once again, we come across the need for a coordinated effort on the part of all the three layers of Panchayat Raj and also the state government. See, the division of powers between three layers of Panchayat Raj is not very rigid. There is a certain amount of flexibility, although there is some amount of power, but still it is not providing for a water treatment compartment. See, one thing is that watertight compartmentalization is not something recognized by water law, or the natural resource like water does not recognize such limits. See, it is said that interstate regarding interstate river, it is said that a basin as a whole should be taken into consideration, and natural resource like a river, interstate river, does not know the political boundaries. See, political boundaries are they are the creations of human beings, and a natural resource like a interstate, a river, does not know such boundaries. In such a situation, treating the whole basin as a whole becomes quite appropriate. So suppose a whole basin is treated as an integrated one, and so from Talkaveri to Kaveri Pattinam, whole river basin of Kaveri is now suppose it is developed in such a way that there is a very good vegetation or there is a very good development of greenery, and afforestation develops further receiving of water or conservation of water, and so there is a avoidance of pollution in various places where towns and cities are situated near the tributaries to Kaveri. Then it is possible to improve the river basin as a whole. Further, if there is a emotional and intimate relation among various people settled in various parts of the river basin, then they will better understand their problems, and litigations or all those bitter feelings arising out of litigations, etc., can be avoided, and human beings will be able to understand the problems of other section of the society. Thus, at the level of human beings or inhabitants of the basin as a whole, so there is a cooperation, there is a an approach of NGO, or there is an approach of water society. See, Kaveri Samaj or Kaveri society was constituted in order to have interaction of various people coming from different parts of that basin, so that there can be better interaction. See, number of activities are conducted by NGOs. See, it is through NGOs that we come across production of, a revival of the traditional method of water conservation in a coastal part of Karnataka. There is a katta as a method of say storage of water, or the revival of traditional tanks, kalyanis. See, these are all approaches which are evolved by the people. Thus, integration is not something only at the governmental level or the level of panchayat raj, etc. Integration should be there at the level of various sections of the society, NGOs, then the governmental bodies, and the people at large. Further, among different departments, suppose there is a lack of coordination. Once again, that will give rise to a lot of problems. For example, when there is a tank in an urban place polluted because of, say, diversion of pollutants, municipal pollutants to that place, then there may be jurisdictional war or a jurisdictional problem between various departments. Which department has to take into consideration? Is it the municipality, or is it the forest department, or is it the water department of minor irrigation and water, or is it an environmental department? So there are 4 or 5 competing departments, and because of a lack of coordination among these departments, so no specific department takes into consideration the problem of that pollution, and pollution still continues as a continuous problem. See, coordination is required, integrated approach is required even at that level, because water is something which does not know boundaries. Whether the boundary is something artificially evolved among different regulating agencies or such things, that is not a very important matter. But when there is a pollution, that pollution shall be avoided, and that shall be properly dealt. That is the important thing to be done. Another problem that is faced in this sphere is the role of these private actors. See, privatization of water. This has caused a serious problem, and this could not be dealt within the framework of an integrated approach. It is essential to extend the integrated approach, but that is a challenging task. Perhaps about that issue, about use of water by these private bodies, there were presentations of papers. Of course, the discussion that I have conducted here is pointing out one important approach, one important policy that should be evolved, that there shall be a comprehensive approach, because overarching of values requires that there shall be overarching of the methods of protection. And because of lack of coordination, the country should not suffer. Natural resources like water shall not suffer. This webinar has been successful in evolving new thoughts. It appears that various papers were well prepared papers on the basis of research, throwing a new light on the subject. And Professor C.M. Rao also told about the practical implementation of this water policy. See how through recycling it is possible to deal with certain problems. If Visakhapatnam campus of DSNLU is doing that, perhaps there's a commendable thing, and various other universities may also follow such an approach of say recycling, because relating to water, which is a very I mean a very limited resource, Why it is limited? About that there was much discussion. Yes, when it is a limited resource, we have to conserve it as if it is so precious, and with that it is possible to reach a consequence which is contemplated by our constitution makers, that there shall be wholesome environment, and water law shall promote that policy. With this, let me conclude. Let me thank Professor Surya Prakash for giving a very good opportunity of sharing my thoughts with this August gathering. Thank you very much. I know that DSNLU is coming out with a number of programs, various lectures, and various, it is busy with various academic activities, and there are young scholars there. I had also an opportunity of visiting the campus long back, and it's coming up as one of the very good national law university. I wish all the best. With this, let me conclude. Thank you very much.
Thank you so much, sir, for the
Yes, sir.
enlightening valedictory address.
Thank you.
We are pleased to listen to you, sir. Thank you so much.
I request everyone to turn on the camera for the group photo. Cheta, just give me a moment. You can pass it on to Sudha ma'am for that time. I request everyone to turn on your camera, please, just for the photo. Everyone, please. I request all the student team to turn on their cameras. Quick, we'll hand over the baton to Sudha ma'am again. Thank you so much. Back to you, Chelsa.
Thank you, sir. Now I request Dr. K. Sudha ma'am to invite the participants to share the feedback. Over to you, ma'am.
Participants to express their opinion, their feedback about today's session. I request Dr. Uma Rao to say a few things.
Good evening, ma'am. Good evening, sir. Ma'am, coming to my feedback about the two-day webinar, there is no facet that is not influenced by water, and every one of these facets was carefully covered in the 6 technical sessions that were there. The papers, when we were listening to the experts and the paper presenters, they were very thought-provoking. All the experts, when starting from Rajendra Prasad ji to Ishwar Bhatt sir, everybody, the paper presenters, we were given a reasonable amount of time to present our papers, and the question answers were very meticulously followed, so that we had to be well prepared. And then someone whose seminar, whose topic is on interlinking of rivers, it was like a refresher course. The way the topics were subdivided, it was really good. The student volunteers were really polite, very meticulous. I have worked with Dr. Sudha, and I have also worked with Baila Kiran, and I know the kind of thought that has gone into meticulously preparing everything. Thank you so much. I'm looking forward to the next seminar webinar that's being conducted by DSNLU. Thank you so much, ma'am.
Charita,
Yes, ma'am.
is there anyone else who would like to express their views? Any suggestions are most welcome. I know you already mentioned it in your feedback forms, but in case you would like to express something, please do. You're most welcome.
I would like to suggest the Honorable Vice Chancellor to get it published, the articles that are deliberated in this particular seminar. Please do the work for the benefit of property, IPR property of the DSNLU. That is only suggestion from my side.
Thank you, sir. Anyone else? I think
Yes,
we can
ma'am.
proceed.
Happy Teachers Day to you all, respected Bhatt sir. It is a quite enlightening session for us. Whatever paper I have given, I thought I have learned a lot from this session. Very insightful session. Thank you, ma'am. Take my regards. This is Dr. Sushmita Dhar from Sister Nivedita University, Calcutta.
Okay, then I think if no one is going to say anything, we can move on, Charita, to the next.
Yes, ma'am. I would like to invite Dr. K. Sudha ma'am, convener of the webinar on the water management laws, life, livelihood, and environment, to deliver the vote of thanks. Over to you, ma'am.
I could start with dignitaries and the guests. I thank all the dignitaries, starting with Dr. Rajendra Singh ji, E.S. Sarmagaru, Professor Philip Khaled, Professor Rajalakshmi, Dr. Sujit Punan, Professor Tony George, Dr. Srinivas Chokakula, Dr. Stalina Jolly, Nidhi Jamwal, Professor Ishwara Bhatt, and Professor C.M. Rao. Now, Professor C.M. Rao Garu, I'm not able to make out, and I only discussed about what all those who are outside DSNLU, am I addressing them and saying the dignitaries, but I'm not able to figure out whether I should include you within the DSNLU thing. It's very painful to say that you are outside the family. Then I again coming back to the other than the resource persons and the chief guests and guests of honor, there were many people who really rose to the occasion, and with very short notice they have actually helped us in organizing all the sessions. And for this I would like to thank Dr. J. Uma Rao, Unesh Daslok, Dr. Lakshmi Priya, Anjana Ramanathan, then Pratyusha, and our own faculty member Soma Bhattacharya, and Amandeep Singh, Dr. Pallavi, Mr. Ashish Kumar, Ms. Delhi Chandana, Ms. Ria Handal, Mr. Zain Saleh, Ms. Sushmita Patel, and for chairing and co-chairing the sessions and for being rapporteurs of various technical sessions. And I also thank our own LLM students, Kirtana and Somesh Pandey, for being the rapporteurs for the day 1 and day 2 sessions. Then I'd like to thank ICSSR and especially Dr. Jacob and Professor Usha Kiran for their support and for sponsoring this event. And coming to the paper presenters and participants, I've attended a couple of online sessions the post-COVID period. What I have noticed is that people, they do either they are not they are very silent and they don't participate, or it is very erratic and they are only looking forward for the feedback form. But somehow I find that the consistently all the participants have attended all the technical sessions. It was never less than 45, and it has been very consistent, and they are quite serious. Which I find that the people who have really attended, they are serious about this particular participating in this particular webinar. And with respect to Professor Ishwara Bhatt was saying that there is a lot of what we are speaking about integration. We have integrated many things into this webinar. One interesting thing I'd like to say is that when it comes to the resource persons, there is one interesting thing that struck to my mind. We found that there were senior teachers like Professor Ishwara Bhatt and Professor C.M. Rao and Rajendra Singh ji, E.S. Sarmagaru. Those seniors were there. Then they were middle-aged intellectuals who came and addressed the audience. And there were very young, talented resource persons also who addressed the gathering. So that kind of diversity is also there in terms of presentations. And I think it is very important to have people belonging to different generations to come together, sit and speak about certain things. Then there will be a kind of that kind of a thing. I think we had a rich experience that way also. Then I thank the press for covering for the coverage. We got a good coverage. Social media had covered it very well, and we also thank coming to our own DSNLU members. I'll start with our Honorable Vice Chancellor, Professor Surya Prakash, for his for his support and complete what he has never on one occasion unhesitatingly has done everything which was possible. I also thank Professor Madhusudan Rao, our registrar, and their office of Vice Chancellor, sir, and also office of Registrar, sir, for their support for this event. And I also thank the finance department for the kind of support they have given. And more than anyone else, it is IT desk, Mahesh, who has really been throughout these 2 days and also earlier. He's been very supportive in seeing that this event is smoothly conducted. Thank you, Mahesh. Then coming to the organizing team. Now, this is something which is very endearing in a way, and I have to share a few things. I know I'm taking a little bit of your time, but I have to thank Alia Akhtar, Shreya Nair, Priyanka Grandhi, Parki Rai, Shruti Kulkarni, Ek Priyanka, Sanjana Datme, Tanusha Kurapati, Krishna Vamsi, Bhavya Sri, Sravani Kurra, Sejal Lahoti, Chandana, Sachendra, Amruta, Charita, Srivalli Vaishnavi, Divya Sri, Kamanam. These, they have been, I would thank them in a few things about the way they came forward and organized this event. All the whole organizing team is living in different time zones. And one of the organizers in the organizing team, she's staying in US. So because of this difference in time zone, she was almost asleep. We had to wake her up, and she was working on the whole throughout the past fortnight. That is the way things have been going on. And I think I would say that all the whole organizing team, our student team, you are the precious sringas of this event. You have brought Pani, you have brought Giovanni, and I hope that in future you will bring even Kisani, what Rajendra Singh ji has rightly put. So you are the precious sringas of this event. You have brought water into this law, and you have brought Giovanni into this event. And I thank all of you. And it was a laborious process and a very good learning process for all of us. It's not only about the water law management thing, but even the way we organized it. There was a lot of editing and re-editing of each other's work that we did, and this might have been very painful because trying to correct your own creative work, and someone coming and saying, I think many of our teachers who have written something, we hate our editors. Most of us, because they try to show that we are not at a creative best. So this kind of editing and re-editing and the kind of work that we have done, ultimately we could come up with something. I don't say that it is a perfect event, but we strive for the perfection. And in this endeavor, whatever you have done, we thank you from the bottom of our heart. Then coming to I think this is I might have missed a few people, but and again I'll thank our own driver Ramakrishna for his support for the past 2 days. He's still waiting there to pick us up. And last but not the least, my own student and my own colleague who has been throughout this journey, Kiran. I thank you and it's not fair to thank you, but still it's my duty. I thank you a lot. With this few words, I'd say that this event is concluded. Thank you, one and all. I thank my own faculty for being so supportive, and I thank our academic director for coming forward and expressing his vote of thanks, and also being throughout for his cooperation for this event. Thank you, one and all, to all our teaching, non-teaching staff, everyone in DSNLU has done anything, or even if you haven't done anything, your presence itself means a lot to us. Thank you, one.
Thank you so much, ma'am. Happy Teachers' Day.
Thank you.
Thank you, ma'am. Bye.
Congratulations, ma'am. Congratulations.
Thank you.
Ma'am, we are ending this event. We are stopping the live stream.
3 cheers to DSNL. Hip hip.
Hooray.
Hooray. 3 times, Sudha ma'am.
3 times.
Yeah.
Hip hip.
Hooray.
Hooray. Hip hip.
Hooray.
Participants kindly do fill the feedback form that will be shared in the chat box.